manipulation of the USD ZAR appear to have been prosecuted and apparently went to jail, although I'm not certain that there's evidence of that on the
Well, at least he was prosecuted. We don't know if
Mr.
he's in
Cook
jail.
Mr. Cook wasn't prosecuted,
Yes.
but certain people were prosecuted. But to say it was just for the USD and not the ZAR, we submit is artificial. It was for, it would appear, it was for collusion in respect of the spread or for fixing the exchange rate. It wasn't just the USD, it was the USD ZAR exchange rate. So it's both. But the question is, what's the appropriate and convenient thing? The US people haven't gone against any South African traders for doing the same thing, the USD ZAR spread or the fix in relation to that. And it was interesting with the Commission, for example, one of the things that they were saying in their things was, well, we could then refer something to the US authorities because the South African authorities wouldn't have power over Mr. Cook or be able to get him here or to do anything in relation to that. So we submit that in terms of the appropriate convenience, if there is a SOC involving foreign and SA banks in relation to the RAND, that would give a jurisdiction. If it's just two foreigners in New York colluding over the USD ZAR spread or fix or other things, then we submit that the appropriate forum would in fact be the US one, and to characterize the prosecution in the way that my learned friend for the Commission did is not in the papers but not accurate.
Mm. Thank you. Yesterday, during argument, you mentioned the possibility of other currencies being implicated in the chat rooms. And maybe I didn't quite understand, but you thought that that in itself sort of weakens the ability of South African competition authorities to be able to go against the traders or the banks. I didn't understand. That's why I'm saying just explain what you actually meant to say that the presence of other,
yes. Other
currencies is implicated.
Thank you. What I was saying was their argument is because we were in the old GITS chat room, therefore we knew or could reasonably have been regarded as knowing that there was a worldwide SOC involving South African traders, many of whom were merely using the Reuters trading platform or involving with other banks. There was no connection with them. So what they had to say, we submitted, was that and remember their argument was simply being a member of the old GITS chat room is enough, as I mentioned to Justice Majid, is enough to get us into the SOC and to have our deemed knowledge. So then I submitted that, well, it's important in that regard, and this is what the tribunal said in CT1, was, is the old GITS chat room a malign chat room? Does it serve good purposes? Is it good or bad? Then so joining it, I could be joining for good purposes. But the other thing is, what does it relate to? And in the referral, in the initiation statements, they commented that there were various currency trading, various currency pairs that were involved, and there were four that they listed. So we submitted that if the old GITS chat room has good and bad, malign and benign purposes, and it's involved in they're trading in a number of different currencies, you can't necessarily then conclude that because you joined the old GITS chat room, you automatically had a malign intention and wanted to join a let known that you wanted to join a worldwide SOC. For example, it could be that Mr. Cook was actually trading other currencies and was filling in and trying to get a bit of help. But it's a question of what you can infer. And I'm just going to finish this thing. Is that the allegation is solely you knew about the SOC because you were in the old GITS chat room. That's the case against us. And we say, well, then you must look at the nature of the old GITS chat room.
I was wondering whether the details of that are not part of evidence. I'm worried about these technicalities being raised at this stage, because what the Commission has right now is allegations and just enough information. And they will probably, hopefully, at some stage after you've pleaded, have more information. That is what I'm thinking. And I'm asking whether at this stage of the proceedings, a decision should be made about their case at this stage.
No, indeed, Justice. But what we submit, though, is that paragraph, which is paragraph in 89 and 90. So they say they're drawing an inference, and then we would say, well, is it a plausible inference? Because this is the case that we draw. There's no point in going through a 5-week trial, and at the end of it, their argument is, well, you're a member of the Olgitz chat room, therefore you should be deemed to know about a worldwide conspiracy, if that's not, in fact, an inference that's going to be sustained. So we made that submission to the CAC, and the CAC accepted it. And then the question we would submit before this court is that particular factual finding as against the BAMLI or MOPFS, is that something that this court can, even if this court thinks, well, I mightn't have been so convinced by that, is that something that this court can overturn? But we acknowledge that the question has at this stage, they made about a plausible case. We say that's not a plausible inference to say, because he's in the Olgitz chat room, he knew about a trade in South Africa with banks.
Okay, thank you.
Mr. Farlam, on the general principle of personal jurisdiction, and this is assuming that the point is not rendered res judicata by the first appeal court decision. It's often said, and I think it's been repeated in submissions here, that the guiding principle is effectiveness. Now, insofar as effectiveness is concerned, I would like to know if there's any difference between a foreign peregrinus in respect of which adequate connecting factors exist and one where those factors don't exist. Let us take one of your clients. Assuming in the Olgitz chat room there had been South African banks and therefore adequate connecting factors, your client would still be a foreign bank with no presence in South Africa and with no turnover in South Africa and therefore no capacity to be subjected to a financial penalty. In what sense would the competition judgment in this country be more effective against a foreign peregrinus in respect of whom there are adequate connecting factors as against those where only Mr. Toby's Section 3.1 is present?
Yes. I think just right. This actually seems to me to feed in a little bit to the point Justice Collipin made yesterday about, well, effectiveness is really pointless and therefore, and should we develop a test with adequate connecting factors if effectiveness was pointless? The reason why I say that is I don't, with respect, personal jurisdiction effectiveness was an important base of personal jurisdiction, but I don't want to get into debate about personal jurisdiction and what the purpose of attachment or thing was, but we would submit that effectiveness is not the only requirement for personal jurisdiction. There are other factors such as comity, for example, fairness to the defendant, other judicial resources, etc. As far as we would submit, effectiveness is not the sole criteria for personal jurisdiction because, in fact, as we know, in some cases, it can't be effective. And I think in Strang, the court then said, well, it's up to the plaintiff to decide whether or not it's worthwhile proceeding with it. So given that effectiveness is not necessarily being a real consideration for a long time, that you can attach something of relatively trifling value, and yet there's still been the requirement of personal jurisdiction, we submit that the adequate connecting factors is the appropriate way and recognizes there are also some international dimensions in terms of which is the appropriate forum to do it and is it appropriate to bring this person here. And we don't submit that's out of kilter with some other jurisdictions worldwide.
Yes, I think we may need to recognize whether we do it in this case or not, I don't know, but we may need to recognize that effectiveness has largely dwindled into nothing when it comes to a legitimate basis for personal jurisdiction. Because apart from anything else, there are now procedures for recognizing judgments abroad and executing them abroad, potentially. I take your point about comity. Have you, or are you aware, has it ever been debated in the context of this case, are there any relevant principles under the rules of private international law, conflict of laws, concerning the recognition of for a competition judgment in one country to be recognized in another? Because as you know, generally in private international law, judgments in one country will be recognized in another if what they call an internationally recognized basis of jurisdiction exists. And I think that would effectively be a form of, it would be what we would call personal jurisdiction. And it seems to me that the adequate connecting factors test, having regard to the EU and American authorities to which the Competition Appeal Court had regard, was effectively having regard to the sorts of factors which internationally are regarded as acceptable for a competition authority in a country to exercise jurisdiction over a foreign actor. So, but on the question of recognition of foreign judgments in the field of competition law, is it something that you're aware has been investigated?
No, I'm not aware of that, and this has never been debated. I mean, the debate in this court has now taken a different and probably more sophisticated turn in respect of that, but no, it wasn't before. But in terms of, just coming back to the point about the adequate connecting factors, we submit that would be an important consideration as to whether or not this is an appropriate judgment which could be recognized overseas. But can I just go back to the premise on which this question is based? And, yes, we reiterate, we don't say that personal jurisdiction subject matter can be revisited in this case. I mean, just to clarify that. But if the court were to do that or express comments on it, we do submit that adequate connecting factors is the appropriate development of the personal jurisdiction, and it would be in line with international principles.
And insofar as adequate connecting factors is concerned, if the argument is, well, a conspiracy relating to the RAND is a sufficient adequate connecting factor, would that be caught up in the raised judicata point? Because it seems to me that if that was an adequate connecting factor, the pleaded case against the foreign banks was already sufficient for personal jurisdiction, because all of them were alleged to have conspired in respect of the RAND.
Yes.
So
I think
it seems to me that insofar as this case, I'm not saying any other case, but as between these parties who didn't appeal on either side in respect of the first appeal court judgment, we appear to have a finding that mere conspiracy in respect of the RAND by foreign actors is not enough.
Yes.
Am I right? Did the appeal court say what would be enough? Would be if it could be shown that in so conspiring, they were conspiring together in the same conspiracy with South African banks.
That's my recollection, yes. So we submitted, yes, it would be hit by it. 3.3.1, as you had to, in the case of all the named respondents, set out the facts which are sufficient to allege that there are adequate connecting factors between the parties and the jurisdiction sufficient to establish personal jurisdiction. They wouldn't be necessary if it was simply in respect of the subject matter. If it was simply in respect of the RAND, it wouldn't then be necessary to show that there was an adequate connecting factor with each of the named respondents in terms of 3.3.1. So our submission is that is hit by that point.
Then just one other question. I don't know whether this is in the record, so I don't want you to tell me if it requires on drawing on knowledge that isn't properly before us. But do we know whether all the details that are given of specific interactions in the old GITS chat room and the ZA chat room, do they represent the entirety of the interactions? In other words, do we know that the Commission had access to the entirety of the chats that took place over the full period, or is it plausible that perhaps they only had access to some through a leniency applicant? Or we don't know?
I don't know, and perhaps the other party, I know Standard Bank was trying to get the record, and perhaps they might be able to speak to it, but I don't know. But what I do, for Shepherd, we asked them for information, and they just shut us down. So we don't know what they had. We know they had access to the leniency applicants, but they also had some access before because they pleaded it. I don't want to, like the Commission, trying to give evidence that's not here, so I can't say.
Because I must say, I would be personally staggered if parties in the old GITS chat room who saw some advantages to themselves in manipulating the US dollar and the RAND didn't also see the advantages of manipulating the US dollars with a host of other currencies.
Oh, yes. Yeah.
So on the face of it, it strikes me implausible that the old GITS chat room was confined to discussions about manipulating the dollar with the RAND.
Indeed. And in fact,
it would have been fairly small beer, I should have thought.
Yes, yeah. And in fact, that's why the initiation, it struck me when reading the initiation, which is attached to the referral, that there are these four currencies and the RAND just happens to be one. And yes, so Mr. Cook is interested in the RAND. Yes, I suspect was very small.
You say the initiation statement says that old gets...
No, it doesn't say old gets, but it says, it refers to the, I'm just trying to find it while on my feet here. But it refers to 4 different currency pairs in respect of which the parties were alleged to have colluded. It says, the above-mentioned conduct includes, but not limited to, the following currency pairs: USD Rand, Euro Rand, Turkish Lira Rand, Mexican Peso Rand.
But that's all with the Rand on the other side.
Yes.
I'm thinking of the dollar.
The dollar in the southeast. Yeah, no, indeed, yes. No, I think it's almost certain.
We don't know.
We don't know, but it's almost certainly the case.
Thank you.
I just wanted to, my learned friend for the Commission mentioned the Mozilla case, and it relies on the res judicata. Would you give me 1 minute just to address that case, or are you happy that that's not a relevant issue?
1 minute.
Yes. We don't see the relevance. It was raised in the context of res judicata in overturning orders not before the
Yes.
court. We read the judgment. It's an application against a...
I'll give you 2 minutes.
Okay, it's an application against a pension funds adjudicate awards in 30p of the Act. That went to the High Court, to the full bench, to the SCA, and then to this court. This court overturned a decision of the SCA, which in turn overturned the full bench and the single judge of the High Court. But this court disagreed with each of those judgments. So it overturned the SCA order, which necessarily would have meant that the full bench and High Court judgments are revived, full bench having dismissed the High Court one. And because it disagreed with those, it had to overturn those as well. But we submit that's the normal course. That is nothing like the present case and nothing like the res judicata problems that raised in this case. It's completely not on point with respect. Thank you. I think that might have been a minute.
You want to do? Not on this one.
Mr. Follum, I think Mutsila, the point that the applicants were making, there was a judgment, Guarneri,
Oh, yes.
SCA judgment,
Yes.
and that question was not squarely before this court. And this court in Mutsila said that that judgment was wrong. A part of the judgment had been wrongly decided by the SCA. And I think the point that the applicant is making is that where there's a point of law that appears to have been incorrectly decided, it is open for this court to deal with it.
Yes, no, thank you, Justice Schwan, but I acknowledge that. I'm sorry, but that doesn't mean that the parties in that Guarneri case were now allowed to get the benefit of this court finding it was wrong. Of course, this court can say another judgment is wrong, but it doesn't mean that they've opened the fight between Guarneri, in that Guarneri case. And that's the difference here. They want to overturn it and open the fight between us.
So if I understand your submission, you're saying that this court could, if it was of the opinion that point was wrongly decided, but it might not benefit
Indeed.
the applicants.
Indeed.
Because of the question of res judicata.
Issue stop. Indeed. Thank you, Justice.
And if I may, yes, thank you, Deputy Chief Justice. Is it the submission on behalf of the respondents that you represent that and this is linked somewhat to Justice Rogers' question as well, that the Competition Act has no extraterritorial reach at all when it comes to personal jurisdiction?
No. And in fact, as I think the Commission pointed out, because in light of Section 3.1, we couldn't argue that, because that says it affects conduct within or having an effect within South Africa. So if you're a foreigner and you're acting overseas, but your effect has its direct and substantial foreseeable effect in South Africa, you could be caught, but then there's the personal jurisdiction hurdle as well. So it's certainly not confined just to within the country.
But if that's a proper interpretation of the Act, can that be so, given that the purpose of the Act is, and I quote, to restrain particular trade practices which undermine a competitive economy?
Yes. Well, so, going back to the debate, so it applies extraterritorially, but then one's got to read it against the overlay of the common law, and unless the common law is now regarded as impliedly repealed, which for reasons we submitted, it wouldn't be consistent with the Act to read it, then you've got that further one. We submitted wouldn't fundamentally undermine the purpose of the Act to do that. And in fact, the Act itself contemplates, as I will debate with Justice Majid, that you can't get a penalty against them, you can't subpoena them. So in effect, there's always going to be, there is a limitation in any event. So, the irony of this case, the end of it, they couldn't impose a penalty against my client. And so there are the indications in the Act that in fact it's while it's extraterritorial, it's not completely wide against the foreign.
Yes. Thank you. Thank you, Mr. Farlow. Thank you, Deputy Chief Justice.
Thank you. Sorry, Mr. Fallon. I'm just trying to get my head around the correct approach to exceptions and, in a sense, what emerges from this case. As I understand it, Rule 15.2 of the Tribunal's rules set a standard for pleading, if I could call it that. It would have to be material facts or points of law relevant to the complaint. In the tribunal judgment in dealing with exceptions, the tribunal sets out its approach to dealing with exceptions. And its approach is recognizing that it's a body that's sui generis, that it has got inquisitorial powers, but that ultimately the overriding consideration must be fairness. It also repeats the tried principles in our law that the exceptions must be decided on a interpretation of every reasonable possibility, and that the allegations must be taken as correct. So it doesn't contemplate that the tribunal, considering the exception, would, as it were, test the veracity of the allegations, but would accept the correctness of those allegations. And that being said, when I look at the CAC judgment, the connecting factors test, and that's set out in paragraph 85, I think, of that judgment, says on the one hand that there has to be a sufficient connection between, it should be sufficiently connected to South Africa. But then in the last paragraph of that, the last sentence of that paragraph, it says, it follows that to sustain an argument that there was sufficient connecting factors, the need is to provide clear evidence of linkages. So the CAC speaks of clear evidence, and then in the following page at paragraph 88, it then, in dealing with the position of Cook, as regard to the exception affidavit filed by your client, in, as it were, controverting the allegation made with regard to Cook. So what CAC is doing is it's subjecting, as it were, an allegation of a material fact that our law says you must take as correct. It's testing that, and it's then proceeding to dismiss the exception on the basis that it doesn't meet the test. And I suppose that the same would apply to inferential reasoning. One could apply the Blom test ultimately to whether you accept that reasoning. But is it so that at exception stage it's permissible? Because the danger here, Mr. Farlam, is that one, in doing so, you lose sight of the sui generis nature of the tribunal. And secondly, you actually sort of skirting into the merits of the case in determining an exception. And so I have some sort of conceptual difficulty with that approach and its consistency, as it were, with generally the law on exceptions, but in particular with regard to how the tribunal is meant to function. So, yeah.
Yes. Thank you, Justice Collipin. Yes, we noted the comment in its paragraph 88 about the exception affidavit. And before I get there, though, as I've said, the parties for pure excipients might have a different view, but our position is, well, we've got an exception against one, and then we've got a joinder against the other two. And so the test is different in respect of the joinder. You can then, we'd say you must at least make out a prima facie case on the joinder, and then for looking at that, you look at the facts that are made, that are pointed out. So, for example, the general test of prima facie is if the respondent raises a thing that you can't answer, well, then you must accept that to be right. And so we say that applies in that context. So we're in a slightly different position to the pure excipient. And that then leads on to the observation that the court made about the CAC referring to our exception affidavit. As in this court, what I argued in the CAC 2, was reference to the joinder affidavits. So I made the same argument, and I don't know if it was an error in there or whether they looked at the one, but I made the same argument with reference to the joinder affidavit, and I said it's common cause effectively in the joinder that a MLPFS is the party. So then the argument is the one that I had with Justice Majid. Well, in those circumstances, is it sensible in the interest of justice or appropriate to then close your eyes in the exception, or can that then also influence, and usually perhaps in this context. So it's not a pure, I wouldn't, from my side, and it may be that others were different from you, I don't have to defend an argument that on exception you can take into account facts given by the party in respondent. The fact that the tribunal allowed an exception affidavit in itself might have been a call that they shouldn't have made, but they did do it, and perhaps they did it with reference to the other provisions, because invariably then facts come in. But from our side, we don't have to defend that, and I didn't try before the CAC, and I'm not now before this court.
Okay, I just raise it because I'm just concerned whether that's reflective of an attitude on the part of the tribunal, of the CAC, as to its approach to how it sort of links its conception of the connecting facts test to the standard of pleading, and to how it will deal with exceptions. And other parties may deal with it, but that's a concern I have.
I fully appreciate that concern, Justice Polypin, but as I say, we don't have to get there. And in terms of an inference, we would simply say the question is, well, yes, you take the facts as correct, you say I was a member of the Olgits chat room, and then is it a plausible inference that we then knew about the SOC worldwide? And that's our response. Please.
Sorry, Mr. Farnham, I didn't read my notes properly. There's one more. Now, this concerns a bank's participation in the overall conspiracy. If my note is correct, yesterday you submitted that a bank's involvement in an SOC can only be measured through a trader or traders' activity or participation in the chat room. And a lot of the submissions this morning concerned that aspect with regard to jurisdiction. Did I make that note correctly? You say it's only through that the participation can be gauged.
Yes, so we said that you've got to look at the trader and see what the trader did, because that's obviously the link. And so if the trader's not part of the, well, say in the first instance, the trader's not connected to the company, then you're out. But if the trader is connected to the company, you look and you say, well, what did the trader do? In this case, it's that their pleaded case is because you were in the chat room, therefore you knew about it. And in our case, therefore, it's because you were in the Olgits chat room, you knew about it. So that's the link.
You would have heard yesterday the submission by Mr. Nkatobi that that's the first part. But there's a second part, that if the allegations are that the trading pattern matches the overall strategy and discussions in the chat room, that would implicate a trader as well, even if you don't satisfy the first part. In other words, let's say Mr. Cook is alleged to have discussed with other traders that he will pull or hold his trade for a certain time, so as it was put, to reserve liquidity for each other, which is a serious allegation, if proved at trial, but something along those lines. And it turns out, ex post facto, that's in fact what happened, that liquidity was reserved, or in another instance they agree on the pips for that period, and it turns out that actually that is what happened. Is that just sheer coincidence? Is that something that that can be summarily dismissed? Because here we're just dealing with allegations at exception stage.
No, I would agree with respect that if you're looking to say, well, was there an SOC? And this is fact one of the factors that they allege for saying why they think there's an SOC. You look at the trading patterns. So that's correct. But then the next question is, were you part of the SOC? And we know that and the Commission acknowledges the test is you must know or reasonably know about the other party's conduct and what they're doing. So we must reasonably know that in South Africa on a Reuters trading platform something's happening, or Investec is talking to someone allegedly, or Macquarie is talking to someone. And so that's why we say that's another thing. So it's not, is it enough that you can infer there's an SOC? Yes. But is it enough to show that we are part of the SOC? No, and it could be, as I say, that we were just party to a bilateral exchange or something else. And that's why that I did emphasize that third requirement for the SOC is the key one for guiding us. And they have to show that. And it can't show there was an SOC, because, yes, there is an SOC maybe, but they've got to show we were part of the SOC. And we can be, because it's guilt by association. Well, effectively, you don't want to make it just guilt by association. It's sort of, you're going to be responsible for the conduct of others, so you must at least know about that. And that's why that's a key factor, which is different to the point that your court made.
You can do a common purpose in criminal law, but in your submissions, you kept mentioning yesterday and again this morning that the old GITS chat room may have been set up for benign purposes. A, what was benign in the chat room? What was discussed that was benign in the chat room? And B, what does it matter? As long as it's turned bad, or there's mixed the good with the bad, surely if there's enough allegations regarding the bad at exception stage, that should be adequate. But what was benign in the chat room? Could you maybe point me to something?
No, well, we don't. I mean, the pleaded evidence, what they've just taken out are some instances of bad things. So the chat room lasted for 6 years or more, and they've taken out certain examples. But what we've said with reference to, for example, foreign cases, that some information exchange is necessarily needed. And if I want to trade with you, I need some information. I need to be able to talk to you, and I need to get some information about certain things. So the fact that there's a forum in which people can communicate and exchange information is not in and of itself a bad idea.
Of course, it must be so. I mean, nobody can argue against it. But once you exchange commercially sensitive information, this is what my client is going to do, and this is what he's not going to do, and so on. Surely then it's no longer benign, and then the whole chat room gets abused, and this is where the allegations are now.
Yes, well, what we don't know, I mean, we've got various instances which, say, well, this happened. Of course, it's over a period of 6 years that Mr. Cook was 40 instances. We don't know if there were, they don't say that it was, and this is the point that the tribunal made the first time around. They don't say it was originally fine, but has now become an overwhelmingly bad, malign place where people collude, and therefore simply by joining it is bad. They don't say anything about that. They just give examples of bad instances, and then that's why we then say, well, in those instances, going back to what the tribunal said initially in CT1, well, you can't say necessarily just joining it. And that's the point, for example, they say Shepard just joined the chat room. Now you can join a chat room in 2007. I think it was that he joined it. Well, was it a bad, did it serve good purposes? Could you have joined it because that's the way you trade? But they don't say it's an overwhelmingly bad chat room. They don't say it was only bad. And as I say,
Looking at all these instances and what Katz and others were up to me it looks bad enough. But let's leave it there. Thank you, DCJ.
Thank you, Mr. Fallon. Oh, looks like another question for you. Thank you.
Mr. Fallon, I've heard you on joinder and exceptions and so on, but are you not setting the evidentiary bar too high in this matter? You've got evidence pleaded of an SOC, you've got evidence pleaded of traders, of particular conduct, of chat rooms, of the consequences of the trade. Is that not enough to reach the threshold required by the Commission?
just going back then, I mean, our point is yes, that there's evidence of collusion, of trading, and there may be evidence that there's even evidence of an SOC. But is there an evidence of an SOC involving us? And that goes back to the question of what are the requirements for an SOC. So we would respectfully submit that it's not enough that certain actions of Mr. Cook might be regarded as collusive. you've got to show that he was part of the overall plan and that he knew of the overall plan, and therefore it's not enough to say, well, perhaps you could find him guilty on certain things. You've got to show that he was part of the SOC, and that goes to the requirement of the SOC that I've dealt with, and that's ultimately turns on the question, can you infer from his membership of the Olgids chat room that he was part of an SOC with SA Banks?
What is pleaded not sufficient? Because, of course, at a later stage there'll be more detailed evidence. But really what you're saying at this stage is that there must be more detailed evidence pleaded in order to meet the threshold required. But is that not too high?
Well, what the CSC said in CSC 1 is that if you're relying on inferences, you must plead the material facts on which the inferences are based. And they tried to do that, but the material fact on which the inference is drawn that we are part of an SSC with South African banks is purely that we were part of a chat room. So that's the material fact, and they draw an inference, and we say that's not an implausible inference. And in terms of the test, we say it's not simply an exception, it's also the question. You had a chance to flesh it out in the joinder. When you were dealing with MLPFS and Banner, you could have given us a little bit more. In fact, in that context, we also said, well, tell us a bit more about Shepherd, please, so that we can respond, and they didn't do it. So then some of the authors, their own misfortune, we would submit.
Thanks, Mr. Fallon.
Thank you, Deputy Chief Justices.
Mr. Loxton, it's your turn. We will allow you your 30-minute uninterrupted time, meaning we won't adjourn at 11:15. We'll adjourn when 30 minutes is up.
He says it's 15. Let's just check.
Sorry, Mr. Fallon, I'm just doing this. You have 30 minutes uninterrupted time. Is that correct?
30, yes.
Yes.
So I'm going to take 15 before tea and 15 after tea.
No.
Oh.
We want you to argue the whole time.
The whole thing. So
Yeah. Then we'll take our adjournment when we finish.
that
Yes.
is perfect.
Oh, my colleagues doesn't wanted to know you're for which party. You for the,
ANZ,
yeah, you for the ANZ group, isn't it?
first responder,
Yeah.
the merest of minnows, the
Yeah.
smallest respondent that's there.
Thanks.
Deputy Chief Justice, what I intend to do is to first make a few observations about res judicata, and then its consequence for what may be advanced as errors of law, and then to examine what may not be advanced before this court, namely errors of fact, and then to establish whether there are any errors of law which affect the decision of the CAC in its second decision in relation to ANZ. So I see that that there are two other respondents that have already had something to say about res judicata, and I might say right at the beginning that I fully take what Justice Rogers said about preemptions, and with respect, I think that he is correct and that this is a question of res judicata and not preemption. So the starting point then would be, well, what have we got here? And there is a case not yet, as I understand, cited by the parties in relation to res judicata, and it's TWK Agriculture Holdings versus Hoogveld Boerdery Beleggings, and it's 2023 5 SA 163 SCA. Now, that case dealt with the question of the circumstances under which a refusal of an exception would be final and definitive in effect, and then give rise to an appeal. So, of course, it's right that the granting of an exception would be final in effect and would give rise to an appeal, but the reverse is not necessarily correct. And the remarks of His Lordship Mr. Justice Unterhalter in that regard at paragraph 43 are insightful are helpful because of the guidance they give on why it is that when exceptions are brought in relation to jurisdiction, they are necessarily final in effect and necessarily give rise to a right of appeal. And His Lordship there said the following at 43, May's board does recognise a carve-out to the rule that the dismissal of an exception is not appealable. An order dismissing an exception will be appealable where the exception challenges the jurisdiction of the court. That is so for the reasons that were explained in Moch. Where the challenge concerns the jurisdiction of a court, and hence the competence of a court to hear the matter, the decision of the court is considered definitive and appealable. This is consistent with the principle enunciated in Zweni, because the decision as to jurisdiction is considered final. This position is entirely justified because an error as to jurisdiction, if not subject to appellate correction, would permit the court below to proceed with the matter when it had no competence to do so, rendering what it did a nullity. That is plainly an undesirable outcome. Furthermore, a challenge to jurisdiction is taken at the commencement of proceedings until this challenge is finally resolved by a court, should not exercise coercive powers that compel compliance. So in what followed in CAC 1, there was then a decision as to jurisdiction. And effectively what was said there is that Section 3.1 of the Act did not imply the repeal of the common law in relation to personal jurisdiction. And that is said at page 87 of the record in CAC 1. It's paragraph 22 of the judgment. And the court said, the tribunal also found that 3.1 of the Act could not be read to imply a repeal of the common law requirement for personal jurisdiction. I stop there to simply remark that the tribunal and the CAC were ad idem on that question. The question which was then where the CAC departed was what to do about that and how to deal with it. For this reason, it accepted the argument that a traditional declaratory order, one that has civil but penalty consequences, is not an order we can competently give without personal jurisdiction over the peregrinous respondent. Then at page 100 of the judgment of the papers, it's paragraph 51 of the judgment. The court then develops the common law in relation to personal jurisdiction at paragraph 51. And I note in the Commission's heads of argument that they said that that was the right thing to do, although they may disagree in other respects. And then, as we know, at page 116, the court ordered, consequent upon a finding that personal jurisdiction was required in the particular form which the court adopted, and that consequence was that the new referral affidavit must be in addition in the case of all the named respondents set out on the facts on which the Commission relies to allege that there are adequate connecting factors between the parties and the jurisdiction of the Competition Tribunal sufficient to establish personal jurisdiction against all the named respondents. So that much then is clear. That's the order. And we know that there was no appeal against that order. In fact, quite the reverse, because when one goes to the referral at page 374 of the papers, paragraph 9, the Commission says the following: in accordance with the order of the Competition Appeal Court on 28 February 2020, The referral affidavit replaces all previous referral affidavits filed by the Commission in relation to this matter. And in that referral affidavit, the Commission attempted, we would say unsuccessfully, to comply with the order and to establish personal jurisdiction. So it is clear that the Commission itself accepted that there had been a final and definitive finding by the CAC in its first decision to the effect that the 3.1 of the Act did not dispense with the common law requirements for personal jurisdiction, and that personal jurisdiction in a developed form had to be proved. It was really in this court for the very first time that circumscription of their right to raise 3.1 as a sole form of jurisdiction arose. Until then, they were happy and content to run the second hearing in front of the tribunal and the second hearing in front of the CAC on the basis that the CAC had definitively decided the question of jurisdiction. And you can also see that from the second CAC decision, which is at the particular paragraph is at 262, it's paragraph 83, and there the CAC says, so much for subject jurisdiction in respect of personal jurisdiction as it pertains to the Peregrini banks. The court in its 2020 decision said the following as it was applicable to Peregrini banks, given the very objective of the cartelists was to manipulate the USD ZAR exchange rate so that they could make higher profit. Common sense and logic tells us that it would be foreseeable that customers would suffer as a result, either directly as investors in a given transaction or in the price of goods and services for export or import. And then it says, ultimately the tribunal came to the conclusion that for the establishment of personal jurisdiction had been established, for at this stage the inquiry into jurisdiction requires the tribunal to decide whether its forum is appropriate and convenient to adjudicate on the alleged conduct of the foreign respondents. Now, what that then means is that everybody concerned, the respondents, the tribunal, the commission, the CAC in CAC 2, accepted that the question of personal jurisdiction as a requirement had been finally determined in CAC 1. Now, that would mean that it is no longer open to the Commission to advance an argument on the basis that 3.1 is the exclusive test for jurisdiction, and that as long as there are effects in South Africa, the tribunal has jurisdiction. But it then goes further, because when one's looking at what this court would be inclined to hear, we know that this court is disinclined to hear disputes relating to facts. That's not its function. And so the court is concerned with disputes relating to errors of law. Where there is an error of law which is identified, the next step would be to say, well, you erred, for example, taking the Commission's case, you erred in CAC in finding that there had to be a conspiracy between foreign banks and local banks. Then it would be possible to say, well, because in this particular case, that was the test you adopted, your finding that there was no jurisdiction established because there was no contact between foreign banks and local banks, that finding may be upset. But where there are findings which are unconnected to any error of law, those findings may not be upset in this court. And that is where I would then get to the case of ANZ. Because what I would wish to demonstrate to the court is that when the CAC deals with ANZ, it deals with it at a fundamental level of causation. It's not even dealing with it at the level of personal jurisdiction or subject jurisdiction. It's dealing with it at the level of, was there an infringement of Section 4? Is ANZ guilty of an infringement of Section 4 because one of its traders performed an act or was guilty of an omission which demonstrated collusion of the kind contemplated by Section 4? And so it's important then to see how this was dealt with by the CAC. And I'd ask you then to turn to C266, which is where the court deals with it. And in paragraph 95, the court says, there is no doubt that CATS is a central player in this case brought by the Commission. I'll stop there for a moment. What you'll see from both this judgment and from the reference is that CATS is said to be employed from 2013 onwards, TESL until 2012. Now, the problem that they have with CATS is that the last identified chat in which CATS is involved is October 2012, before he gets employed by ANZ. And in fact what happens is CATS goes off the air from being prolific to complete silence. Now one may speculate why that is so. It may be that the investigations have begun by the SEC, but the fact is that there is not one peep from him. And to go back then to the CAC's decision, he says, the difficulty, however, the CAC says, the difficulty, however, is that in every instance of participation in the impugn conduct alleged to have been carried out on by Mr. Katz predates 2013, the year in which he joined the fifth respondent from another bank. So I'll stop there for the moment, because what the Commission has attempted to do is to say, well, who knows but that CATS continued. But you can't base your case on ignorance. You can't say, I don't know this, therefore you must make an assumption that he continued, when everything you have demonstrates that he hasn't continued. So where the facts which you do have demonstrate an absence of continuation by CATS, the inference that is sought to be drawn that CATS continued is simply wrong. But there's a further difficulty with that, and it's a difficulty which permeates the submissions made by my learned friends in respect of CATS and TESL. And that relates to the nature of their involvement and the inferences they wish you to draw and the assumptions they wish you to make. Those are matters of pure fact. If the CAC got it wrong, if the CAC should have said, actually, you, CATS and TESL, are implicated in this overarching conspiracy, and should have said, I'm going to assume that CATS continued, and maybe something will turn up in the wash. That's not a legitimate complaint, because that's not a complaint which involves an error of law. It's pure It's a pure factual inquiry. Then he goes on to Tezel, and I'll demonstrate to you in a moment that what the Commission does is it misrepresents its own referral. At paragraph 96, the court says the only reference to Tezel in the referral affidavit is the following. On 18 October 2012, Katz, Ayer, Williams and Cummins were participants in an implicated chat room in which the following communication took place. Katz and Ayer matched each other's opposite fixed positions in order to offsell their respective exposures at the upcoming fix. Ayer copied and pasted a portion of the communication between Madras and Tezel from another chat room. And the court goes on to say, what precisely is meant by copied and pasted is not clear, not made clear, nor is there any suggestion that Mr. Tezel participated in a chat room or any similar discussion with other traders. But the Commission's case relating to Katz concerns the period 2 October 2007 to 18 October 2012. That is before he joined the fifth respondent, and no participation on the part of Tezel, whether active or passive, is shown in respect of any of the chat rooms. This justifies the conclusion that no case was made out sufficient to find the fifth respondent was a participant in the overall SOC as pleaded by the Commission. Now, none of that flows from an error of law. All of that is a question of factual conclusions which the CAC drew from the pleadings which the Commission had put up. Now, you will have heard from learned friends for the Commission, they'll say, well, these are exceptions and it's difficult to know exactly what happens. And maybe, in the fullness of time, something will come out of the wash. But that is a profoundly unfair approach to pleadings. It's fundamental to pleadings that you alert the other side to the case to which they have to meet. And that's why they were required to plead the material facts, not only because of CAC 1, but also because of the rules of the tribunal itself. So that they were obliged to say, the case against you is that Mr. X, employed by you at this time, performed that act in furtherance of this conspiracy in breach of Section 4. That they had to say. They can't say there was a conspiracy. You all participated in the conspiracy. The conspiracy was frequent. There were many chat rooms. Because it's unhelpful. How are we supposed to deal with that? So now we have a look at the case they made out, because we're only here to deal with the case that is made out. And as I said, in the case of ANZ, the interesting thing is that it can be decided at the most fundamental level. It can be decided without interrogating the subject matter test, without interrogating the personal jurisdiction test. It can be investigated at the level simply of, were you involved in the conspiracy or not? The CAC said, you haven't pleaded sufficient facts to show that you were. That's the end of the matter. There's no appeal against that kind of finding. So I just want to end off because there's a reference in the referral to Katz and Tezel, which has been misrepresented, we respectfully submit, by the Commission, and it's at paragraph, it's at 428, page 428, and it's paragraph 184. That's 184, and it's page 428. And at 184, the following is said. On 18 October 2012, Katz, Ayer, Williams and Cummins were participants in an implicated chat room in which the following communication took place. Now we know that at that stage CATS is not employed by ANZ, so this can't affect ANZ's position in relation to CATS. CATS and AIR matched each other's opposite fixed positions in order to offset their respective exposures at the upcoming fix. Now comes the crucial part for TESL. AIR copied and pasted a portion of a communication between Madras and TESL from another chat room, not an implicated chat room, just another chat room. Now, we do not know what that communication was. We do not know the purpose of the cutting and pasting. We do know that it was not TESL who copied and pasted it. It was AIR who copied and pasted it, who was non-employed by ANZ. And it's been suggested to you, for some reason which escapes us completely, that you must assume that AIR was actually in the same room, same chat room, as TESL. But where does that come from? That's not alleged. It's not on any interpretation of this allegation. You can't find an allegation that they were actually in the same chat room. And in fact, it's counterintuitive. Because why would you need to cut and paste and send to another chat room a message from Madras to TESL for your own purposes? So the degree to which this paragraph has been tortured into shape through inferences, assumptions, leniency in terms of pleadings is remarkable. The fact of the matter is it doesn't implicate TESL, it doesn't implicate CATS. This is the only allegation against TESL, and as far as CATS is concerned, it's too early. So at the most fundamental level, there is nothing at all against ANZ. And it's remarkable that we have been dragged through years and years of proceedings where the Commission has been given opportunity after opportunity to come up with something better. They've come up with nothing better. And it should now stop. They should let ANZ go. The purpose of CAC2 was in fact to refine the case for the Commission so that they would continue to be able to pursue the banks most centrally involved in the conspiracy, to make it into a manageable case, not to grab every conceivable bank to which there was a passing reference. And in ANZ's case, that passing reference is this one paragraph. You can leave out of contention the broad allegations that say, well, you, ANZ, participated in a conspiracy, because we can't answer that allegation unless you tell us who, when, and what. And that was never done. So our submissions are that the appeal in respect of, or rather the application for leave to appeal, at least in respect of ANZ, should be dismissed. There is no prospect of success. It raises no constitutional principle. It raises, at very best for the Commission, a question of fact. Thank you, Deputy Chief Justice, members. Those are our submissions.
Thank you very much, Mr. Loxton. You still have 3 minutes, but you forgot those. We're going to have to take a 30-minute adjournment, and then we'll come back. Thank you. this stage of or that stage of the proceedings being exception stage?
Yes. Deputy Chief Justice, there seems to have been things at play. The one was a confusion between joinder applications and exceptions, where there were affidavits filed, often in relation to very similar issues. And so evidence was then admitted in relation to those joinder applications. But if I have a look at the pure exceptions, leaving aside the joinder, then it would be unusual for a court to have regard to evidence beyond the pleadings, because the purpose of the exception is to test the pleadings, not to test the evidence. However, having said that, the CAC is a specialist tribunal. They devised what they believed to be a procedure which would enable them to winnow out things which should not be there and to concentrate the mind of the Commission on allegations that they should make. So, in answer to your question, it's certainly unusual. Is it impermissible for that particular court to go beyond the strict pleadings? I'm reluctant to say that that's not permissible in those circumstances where they want to try and concentrate everybody's minds.
Thank you, Mr. Loxton. Just one question from my side, and you may think that I asked the question because that's where I intend to go. But on your address, you might suggest that I need not go there. The question really is, you've addressed us on res judicata. And this court, in its jurisprudence in Malautsi and in other cases, has indicated its acceptance for the need for such a principle in our law, that it provides certainty, predictability, and finality. However, at the same time, it is said that the principle can't be applied with rigid formalism, and that there might be appropriate cases for a departure from the principle. And I think that is settled. My question to you is whether, given that res judicata may well be a mechanism just not for the use of the parties, but for the court itself to prevent the court from being abused and from the court having to determine issues that have been determined previously, whether a court may mero moto raise the question of a departure from res judicata and the circumstances that may warrant such a departure. I just ask that as a matter of general principle.
Yes, Justice Collipin, that raises a number of very important issues, because as you already indicated, the acceptance of res judicata as a doctrine to establish precedent, to prevent people from relitigating the same issues, is important. It comes to us from Roman times. And so it's important to preserve that document, that doctrine. However, as we've seen in relation to cases dealing with issue estoppel in particular, which is a form of res judicata, the courts have said there are occasions upon which that may work in injustice, and then there are two considerations. Is it an injustice in relation to one of the parties for issue estoppel? The court has got the right to interfere. Does the court have the ultimate power to say there was a final decision, it was not appealed, but we believe that there are sound reasons why we should interfere with that judgment? I would suggest that the power exists, but it should be very sparingly exercised, and with a view to not undermining the purpose of res judicata. So yes, recognition of the power. I can't spell out what those circumstances are, but I would imagine, to use the overall phrase if it's clearly in the interest of justice that there be a departure and that can be rationalized, then yes.
Thank you. If we should get there, would one of those factors be that this court is dealing with a significant issue, whatever the merits may be with regard to the complaint, that has an impact on the broader South African economy, but more importantly in the context of the legal issue, the proper interpretation of the Competition Act? Would that be a consideration? Not one that is dispositive, but a consideration?
It might, but I would like to draw a distinction between deciding that in this matter there should be a departure from res judicata and deciding that that is a matter which may come up again in the future where it's not res judicata and you don't run the same risks. One of the oddities of this case is that although a lot has been made of the distinction between a pure 3-1 basis for jurisdiction and an extended basis for jurisdiction which adopts a common law position, albeit with amendments, is that when you begin to tie that into the requirements for a Section 4 transgression, that there has to be participation. You have to know that there's a transgression. You have to know what the outcome is. You have to know about the overarching conspiracy. If you don't know about the overarching conspiracy, you can't participate in it. You'll probably find that a lot of that feeds back into the question of, well, should the court entertain or the tribunal entertain that complaint? So to go back to your question, the difficulty that we have in this case is that, firstly, all involved accepted that that dispute was over. So it would have to be resuscitated at this stage. It was not the subject of the CAC decision which is under appeal. So if you consider that question, you would be the first court to consider that question. There'd be no participation by the CAC in whether that was right or wrong, because that was the previous decision. So I'm hesitant to say it's the right thing to do. I would say the power is there, but probably not the opportunity.
Okay, thank you. Just finally, all the parties, though, have addressed that issue, not so? Whether it's properly before us or not, the parties have addressed that issue.
They have. To that extent, it's been addressed here. Okay. It hasn't been addressed in another court, but it's been addressed here.
Thank you.
Mr. Loxton, on this side. In the context of the plea of res judicata vis-a-vis the one of preemption, do I understand you on your feet now to be placing too much stock on the res judicata, but not on preemption?
Correct.
And if we look at the conduct of the parties in these proceedings, particularly CAC1 or the tribunal, insofar as it relates to the interpretation of Section 3.1, which is now the subject matter that the Commission seeks to advance as a basis for jurisdiction. If we take a step backwards and ask ourselves, if the Commission was not satisfied with the finding would it be your submission that what the Commission ought to have done at that time would have been to take the judgment on appeal and forget about what the Commission would have said, the Competition Appeal Court would have said about rearranging and redoing and reconfiguring your referral? Is that what they ought to have done?
Correct. That was the obvious step to take, because that decision would affect the entire proceedings in front of the tribunal. And so for a trial which, leaving aside the further objections that happened, but assuming that you had CAC 1 and there was compliance, the entire trial in front of the tribunal would have been run on the basis of a view of jurisdiction which had been adopted by the CAC. So at that stage, if the Commission really believed that it was correct in its view, it ought to have appealed and not to have allowed the matter to go on the basis of a jurisdictional view which it believed was incorrect.
Would you say the Commission misconstrued or misconceived its position when it looked at the entire order and concluded that the entire order, we were substantial insofar as the order is concerned? We could not launch an appeal on a particular point, which is the interpretation of Section 3.1.
Yes, I believe that they erred. I saw the response that said, well, we actually were the winners and therefore we couldn't appeal, but that's completely incorrect with our submission. There was a specific order. There was a right to appeal against that order, and that is what should have been done. The fact that later in CAC in CAC 2 there was an addition, it seems, that the Commission complained of, which was that the conspiracy had to be between a foreign bank and a local bank and a regularity. That didn't affect the position that there was a definitive decision that personal jurisdiction, whatever its form, had not been, by implication, eradicated by Section 3. So the crisp point was, and Mr. Kaitubi there was a debate about that, and I gathered a bit of hesitancy of him on his part to commit himself to say, are you saying that the common law doesn't apply? Or are you saying that Section 3.1 excludes by inference or by necessary inference the common law? And that really was their case, and it was that case which the CAC in CAC 1 said was incorrect. It doesn't exclude the common law. The common law, however you want to develop it, applies.
Well, that's the fact that the CAC 2, or perhaps let me say, the misconception, the alleged misconception, and which permeated to the CAC 2 insofar as the interpretation of this section is concerned, have any bearing at all with what we are about today?
Yes, it would if res judicata applies, as we believe it does.
Sorry, when would res judicata apply? Back then?
Yes.
And not at CAC 2?
So by the time CAC 2 happened, res judicata applied because it applied to CAC 1. Because it was CAC 1 which said the common law has not been excluded by Section 3, and therefore there's personal jurisdiction.
Sorry to interrupt you, but at CAC 2, correct me if I'm wrong, was it ever raised as not raised?
So it doesn't, there was no, yes, so with respect, Justice Matopa, you're correct, that The shoe only pinched here.
Okay.
It didn't pinch there. And now that it's pinching here, there's a struggle to escape the consequences of res judicata.
It worries me a bit because I'm looking at where the shoe pinched. It's here, and at the CAC2, there was nothing wrong with the shoe.
There was no debate about it. Yeah. It was accepted that CAC1 determined that personal jurisdiction on the modified common law rule applied. So it didn't, shoe didn't pinch then.
But then if, as the Commission says, at the CAC1 and CAC2, this was an error of law that has permeated itself through those fora, and it is now also an error of law. And if we look back, we say, well and good, in CAC1, this was the order. CAC2 parties conducted themselves differently, and it was not raised. And before us, it is raised as a point of law, or an error of law, or a point of law rather, that could be raised competently before us, and they are raising it, and they say, you can deal with it.
Now,
Looking at the interpretation, we are saying the interpretation that has been adopted by the CAC2, it's not in line with CAC1, or there's a disjuncture between the two interpretations. We are asking you as a court to give us a definitive and proper clarified interpretation to the Act. Would they be wrong?
they would be wrong.
In what?
So this is the debate, I think, that I had with Justice Collipan now. The principle behind res judicata is that the decision stands right or wrong. Whether it's wrong on a question of law or whether it's wrong on a question of fact doesn't matter. What res judicata then does is to preclude a party from raising an issue which it's prevented from doing by res judicata, whether or not that relates to law or fact. So this court has the right, or has the power, to entertain appeals about errors of law in the court below. But a party cannot bring that case if it's precluded from res judicata, because litigation must come to an end. And so the whole theory we find that behind the Roman Dutch principle accepted by this court is the fact that it's there to stop endless litigation. And it brings me back then to the debate that we've already had. A party is precluded by res judicata from raising that issue again. If a party is precluded from doing it, what then about this court's power to decide a matter where there's an alleged error of law? And the answer to that is that if there is a power to look past res judicata, so it's now not the party who's entitled to do it. This is the court exercising its own powers, because the party is precluded. And the party itself can't say this is a bad error of law. It's a really bad error of law, and therefore I want to bring it. Res judicata doesn't permit of bad errors and errors are not so bad. It's definitive and exclusive. So the question which arose in the debate was, but is there some residual power? And my very hesitant answer, because I'm not prepared for it, because we didn't need res judicata in the end, is that if there is such a power, it would have to be exercised on the rarest of cases and with due appreciation from damage which might be unintentionally done to a doctrine which has been accepted by this court in res judicata. So That's really the thing. It's not, the party can't get past it. Commission can't get past it. My learned friend has said, Mr. Kutubi said, well, you know what, this is an error of law and you should correct it. That's wrong. Res judicata precludes exactly that argument. But then there's the question, well, is there some residual power? And I was hesitant to say that your hands are completely bound. But I would imagine be very rarely used. And take, for example, where this court considers the decisions of other courts in matters which are not before it, it may well say that decision was wrong. And if this court says that decision was wrong, then it's wrong. And it's always been wrong. It's never been right. But that doesn't infringe the principle of res judicata, because as between the parties, it was the end of the road.
Obviously, obviously you are aware that it causes me some bit of discomfort. Hence, I did not want to interrupt you.
No, not at all.
Yeah. Perhaps let me share with you what my discomfort is, and then you can dispel it if it's unfounded. If the plea for res judicata is to be sustained, one, is it correct, let me put it this way, is it correct or permissible to look at how parties conducted themselves? I mean, referring to the subsequent CAC2, can one say at the CAC2, by conduct, I'm saying this, I'm not sure about the legal proposition, whether the parties conducted themselves in such a way that the CAC1 order was not binding on them. Would that be a proper legal proposition?
No, Justice Matopo. And the reason for it with respect is the following. The elements of res judicata would be a final judgment of a court with jurisdiction, not subject to appeal. Once those requirements are met, then res judicata applies, and it doesn't matter what the parties do. They may, for example, erroneously believe that it wasn't a final order, but it's still a final order, and it's still res judicata. So it operates.
So in other words, as it is in this case, all the parties may have erroneously not raised it as a special plea, but conducted themselves differently. Now it arises yesterday and today, and it can be raised as you are raising it now to say it is dispositive of the matter. It does not matter what happened previously. Correct. So in other words, if you are correct, and if we are inclined to accept your submissions, we would have to say that this issue was disposed of during the first CAC1, and whatever the parties did at the CAC2 did not take away the right of any other party to raise it as a plea, which is now been raised, and that point as it is has been finally determined, and that will be the end of that point which is raised by the.
Precisely, just
would that be the
my
position?
submissions, yes.
Okay.
Mr. Loxton, I apologize if I might cover some ground
Not
that
at all, Justice.
my brother, Justice Matopo, has already covered. In relation to preemption, is it the submission of the fifth respondent? Oh, let me rephrase. Is your submissions on preemption applicable, given that the applicant's compliance with the CAC1 order was limited to amending the referral affidavit and was related only to the issue of sufficiency of pleadings.
Justice Turan, as I've indicated, having listened to the points raised by Justice Rogers, I think we were incorrect in raising preemption as opposed to res judicata. And so I don't wish to pursue those submissions and that particular argument.
Thank you. I understood just the submissions that you made regarding Mr. Katz's involvement predating his employment
Yes.
with the fifth respondent as being a possible factual issue. I did not understand the Commission to be contending that that issue was a question of law. As I understood what the Commission was contending was that the Competition Appeal Court got the test wrong. The court held that the fifth respondent's participation in the conspiracy must be regular, as you answered in your discussion with Justice Matopo. And the conduct within the conspiracy must be directly linked to a South African bank. And the Commission contends that there lies the error of law. The Commission says that all it needed to prove in order to establish jurisdiction in respect of ANZ was that ANZ was a participant in the SOC. So that's how I understand the error of law to be.
Yes. Now, the difficulty with the Commission's submissions is this. The first is they don't actually establish the very minimum. That is a participation. And that's why I said we can deal with the question of ANZ without concerning ourselves with the test which the CAC adopted in relation to personal jurisdiction.
I'm sorry to interrupt you. I'm just mindful of time. Don't we establish the test first before we go to this
Exactly.
sufficiency of
But
evidence?
then what
But
you...
if the test is incorrect, or if the Commission is correct in its allegation that CAC got the test wrong,
But then you've got to demonstrate that the findings of fact were affected by the test. In other words, but for this test, you may have come to different factual conclusions. If you look at the factual conclusions as we do here, and you find that they are unaffected by any overarching test which might have been adopted. In other words, at a pure level of participation, mind connecting factors, they have failed to establish participation, which was our objection. They have failed to establish participation
yes,
in...
you may be right on the second leg. Does that mean then that this court does not consider the test if the test was wrongly applied or determined by the CAC?
You may, if this court were to look at it, it would, with respect, adopt a two-stage process. It would have said a three-stage process. The first is it open to us to reconsider the test adopted by the CAC in relation to a specific respondent? Because each respondent is a different respondent. Or is it excluded by res judicata? If it is not excluded by res judicata, then have we reason to interfere?
I'm really sorry to interrupt.
Not at all.
Yes, but in determining the test, we must be careful not to confine a particular test to a particular party. It's a legal test that would apply in certain scenarios. And if the legal test is incorrect, at that stage, surely this court must say, well, we must remedy that if it's wrong. And thereafter, if we get there in these proceedings, look at how that impacts a particular respondent.
Correct. I accept what your ladyship says.
Thank you, Mr. Loxton. Thank you, DCJ.
Mr. Loxton,
Justice Mtlanhla.
just to follow up on the question that was raised by Justice Matopo. The Commission says one of the reasons why they are raising this point is that the CAC2 introduced a new requirement, thus extending the requirement that was set out in CAC1. Would that argument also be met by the res judicata point?
Sorry,
They're
I
saying-
missed the...
They are saying why they are now raising the Section 3.1 issue before us is because what the CAC2 did was to actually extend the requirement that was set by CAC1.
Yes. So to the extent to which, and I take the 2 points they've made, the one is the requirement that the conspiracy be between a foreign peregrini and a local bank, and the other that there should be some regularity in it. So to the extent that that is a requirement imposed in CAC2 and not in CAC1, then that falls outside of res judicata because that decision is in fact appealed against. And so they would be entitled to say, we want you to have a look at those further elements. They're not affected by res judicata, and we want you to consider whether that affects any of the decisions made by the CAC. Does it filter through into anything which would give this court jurisdiction to consider?
So if we do that, then it would mean that would we be entitled to go back to CAC1?
No.
Or we just look at what the next judgment decided or determined in that respect?
Justice Mtlanhla, your option 2.
Okay. No, that's fine.
No, there lies my problem. There lies my problem. I don't understand on what conceivable basis, if I were to take into account the debate that I had with you about CAC1 being res judicata, and the point raised by my sister now that we should look at CAC2 and its implications. Can we do that?
Yes, so Justice Mtopo,
And if, I'm sorry, if we do that, are we going to be doing that in total isolation or total exclusion of what CAC1 did? And if we do that, on what legal basis are we going to be doing it? Because you contend that that issue was res judicata. If I understand you correctly, it ought not to have featured before the CAC2, but somewhere, somehow it did. Now it's before us. And if it's before us, and on the formulation that my sister has put to you, you contend that we must deal with it. And when we deal with it, can we deal with it vis-a-vis the res judicata point? Are they not mutually exclusive?
the res judicata, so it's the question of what is the ambit of res judicata? What is its operation here? And its operation relates only to the first judgment, because that was the judgment not appealed against. So the decision, and I'll see if I can confine it even further, the decision of the CAC...
Perhaps for my understanding, let's look at the two decisions.
Yes.
and say, here's decision 1 by the CAC 1, and which you contend is res judicata, and decision 2, and which improved on the test, or gave some, it talks about a qualified test. And then, is it possible for us to say, insofar as as decision 2 is concerned, if we agree with the Commission, we have jurisdiction, or we are precluded by decision 1 to ever entertain it? This is where my difficulty is.
I'm going to do my best.
Please do.
Decision 1 was effectively a decision which says that Section 3(1) of the Act does not exclude the common law. So that decision is res judicata. An argument by the Commission that Section 3(1) is the exclusive test for jurisdiction and excludes the common law is not permissible. But in CAC 2, there were 2 add-ons. They do not form part of res judicata. They are add-ons. As far as the add-ons go, if they make a difference, then this court would be entitled to examine the effect of those add-ons, whether they were correct or not correct, and then whatever conclusion it reaches, that's not affected by res judicata.
Sorry to interrupt.
I understand that it's messy because,
Yes, okay.
and it's messy because of the way in which CAC 2 added 2 considerations to CAC 1. But CAC 2, the court itself couldn't, by its conduct, undo the effects of res judicata unless the parties decided to abandon CAC 1. And you can see from CAC 2 and from the referral that's quite the opposite. They accepted fully that there was a requirement for personal jurisdiction, and they applied themselves to whether or not the requirements of CAC 1 had been met. So I understand, Justice Matopo, the difficulty which comes from the fact that these things were not clinically separated between CAC 1 and CAC 2, where CAC 2 didn't say, that's what I've decided. This is the law. This is what will apply. Decided it's going to add a little bit on. Creates a bit of noise, but it's noise. It doesn't undo res judicata or CAC 1. And it's the best I can do, just for TOEFL, for a difficult.
No, I'll think about it, and hopefully your colleagues, if they so wish, they can take the temptation. The Commission had an alternative argument on the CAC 2 extension or expansion of the test. And if I understood the argument correctly, the submission made was that even on that test, they still come home on jurisdiction. It was more like a fallback position. In the event that you are not with us on 3.1, as decided by the CAC 1, the alternative argument that was pursued, here was insofar as it relates to the CAC 2, the importation of the new test, the qualified test. would they come home on that as well, or
And
not?
they're in deep trouble. Because then they're saying the CAC2 was wrong on fact. It was wrong in its appreciation of the fact. It should have said this is enough to meet our test. So as soon as the Commission is not arguing about the appropriate test, which is a matter of law, but arguing about whether the pleaded facts meet the test, which is a matter of fact, then they're in trouble, because that's not an argument they should have here.
So on your submission, they fail on both ends. The first one is the res judicata. The second one is the one that you've just shared with me now. With us now.
Exactly.
Thanks.
Mr. Loxon, just to clear some issues for me. When CAC1 sent the Commission back to the tribunal, it was for what purpose?
Sorry, I didn't catch the last part of that.
It was for what purpose? Why was the Commission sent back to the tribunal?
Well, why did they send it back to the tribunal?
I'm sorry, Mr. Locke.
Yeah.
That was my phone. I'm sorry for interrupting.
Not at all.
Thank you.
Because I think the CAC2 judgment explains why it sent it back
Yeah.
in its introduction.
So can I attempt to explain a difference between what would have happened in a court of law and what happens in the CAC and the tribunal? Is that in a court of law, if there is an exception to jurisdiction, you haven't pleaded the appropriate facts, the exception would be upheld and you'd be given leave to amend. You wouldn't be told how to amend or what to plead. But in this case, what the CAC did was to say, let me educate you. This thing is a mess. It's a complete mess.
Okay, let me stop you there. It said go back and redo this.
Do it again. Right.
Did the Commission not raise the 3-1 argument for the tribunal?
It raised it in the first hearing and in the first SAC hearing, so it lost both of those arguments. It lost in front of the first tribunal.
Yes.
It lost in front of the CAC and didn't raise it again in CAC2 or the second tribunal.
But when it went back to CAC2, there were additional banks who were not there before.
Yes.
Was that the reason why CAC2 then decided to go back to personal jurisdiction in particular in CAC2? Paragraph 83 of CAC2, sorry.
I must say I haven't concentrated on the joinder issues, Deputy Chief Justice, but it's paragraph
83. I think it runs from 83 on to 85. Maybe let me ask you this question differently. Why was CAC2 minded to go back?
Oh, yes. I think it looks like to me they're simply saying, let's remind ourselves about what happened in CAC1. This is the position and this is the territory and this is the way forward. So that they were simply reminding everybody that CAC1 was a decision in which they had set the parameters for jurisdiction.
Yeah.
I don't think they went further than that, except maybe in respect of what the Commission complains about, the two extra factors.
But they did that when they were looking as to whether there was an SOC between
Yes.
the banks. Now, there must have been a reason why it did that.
Well,
It's,
by that stage, by CAC 2, they had the new pleadings.
yes,
They had the new referral. So now they were moving from, so they restated their position on jurisdiction, and then they were looking at whether there is an SOC as pleaded.
yes.
And they found you haven't shown it against A, B, C, you've shown it against these ones.
Right. But they're discussing that in the context of them discussing personal jurisdiction.
Yes, so they're looking at personal jurisdiction because those are the connecting factors. So they don't in 3.1 they don't go back to subject jurisdiction and say this is what you need. They're looking at personal jurisdiction, and it's to broaden the debate a bit. The attempt was to control jurisdiction by imposing sufficient connection between the jurisdiction of the tribunal and the parties and their conduct. So if you have pure Section 3 as the only basis for jurisdiction, as the Commission has argued here, you have a problem which has already been debated. You have a problem that it's effectively open-ended. You can get two people for their own purposes entering into a collusive agreement in relation to gold or silver, which actually happens to have an effect in South Africa. And then the question is, well, would you exercise there in Kazakhstan and Uzbekistan? Would you exercise jurisdiction? So to control, and bear in mind too that for the Commission, there's not only a power to investigate and to bring matters before the tribunal, there would be a duty to investigate and a duty to bring matters to the tribunal, so that you're looking for methods to control a completely open-ended form of jurisdiction which says, is there an effect in South Africa or not? Is there a breach of Section 4 or not? If there is, we've got jurisdiction. And this was the attempt of the court to control it, to bring it closer.
Thank you, Mr. Luxon.
Mr. Loxton, do I understand you to be saying that even if the CAC got it wrong on the facts, that there are not any errors of law which engage our general jurisdiction, and that there's no reason that would permit or warrant this court to consider any of the issues because of the issue of res judicata?
That is my submission.
And on the residual power issue, and if we were to say that we needed to revisit the point on res judicata, might it not be that sound reasons exist for us to consider the issue, given its systemic importance within the whole structure of the competition world, and also having regard to issues of justice between the parties, and thirdly, because of the role of CAC2 in extending the findings of CAC1?
The easiest part is the last part, because on the last part of the question, what is beyond the reach of res judicata is any additions made in CAC2 to the test. So there you'd have to say, was there an error of law? If so, did that error translate into outcomes? Because if there's no outcome affecting a particular respondent, then the error of law doesn't lead anywhere. on the more important question, which is the debate that I've had earlier with members of the court, there would have to be a compelling reason for this court to enter into a debate and make a decision in respect of a matter which is subject to res judicata, because the inadvertent damage to the doctrine which this court has itself accepted is high. And if one were to do that, it would have to be exceptional. So it wouldn't be sufficient to say it would be a good idea to do this, because this affects the economy. Bearing in mind that this case, this case is dead and buried. So the last conversation we had in this case was about, I think, 2018, and there was one. So it would have to be something which goes beyond the importance to the parties of the outcome of this case. It would have to be, there is something fundamental in respect of that interpretation which will affect future cases, which make it imperative that this court say something about that and correct, if you wish to correct, that particular test. I'm hesitant because this court's not really gone there before. There have been hints of it, here and there, but as far as I'm aware, this court has not sat down and said, right, this matter is subject to res judicata, but we've decided we're going to go here. There are other areas in which this court has exercised jurisdiction where there is no list left. So you'll find that a party has settled, I'm willing to pay, but the court wants to hear a particular issue. So that has happened before. But, and I repeat what I've said to other members of the court, I can't really take it further than that.
Mr. Loxton, mine is completely different focus. It's the SOC and the participation. Now, the Commission's case is that CATS was active as a participant in 2013, early 2013. Now, your argument is that he only joined ANZ in 2013. But of course, they plead that in the referral, they say that they are not sure when the conspiracy has ceased, if at all. Does that matter for your argument, as far as CATS is concerned?
No, Justice Majid, what has happened to CATS is that, as you say, we employed him from 2013. But when the Commission responded to the requirements of the CAC and set out the facts, material facts on which it based its SOC, it set all of them out. And October 2012 was the last you see of CATS. So they are trying to persuade this court by saying, we don't know whether CATS was involved after October 2012. And so we want you to assume, although we haven't pleaded it, that there may be further involvement after his employment. Now, the difficulty with that is at least twofold. That would be a denial of our right to know what the case is against us, first. Secondly, we can assume that the Commission, having been given time to marshal all of its evidence and all of its facts, has given you all of the facts. So when I look at the question of cats, did cats go beyond 2012? The answer is, well, there is no evidence and they haven't pleaded it. And it's at least equally likely that in 2012, that was Katz's last effort because something happened. You know, we know there were investigations, he just went off air. And so it's more probable that he actually stopped what he was doing than it is that he continued. And the Commission can't say our inability to tell you what happened should be your problem.
I understand. Can I just turn to TESL?
Yes.
Now, the Commission says that in terms of their definition of a participant in a chat room, there are only three things that must happen. That person must log on to the Bloomberg platform.
Yes.
Secondly, enter the chat room. And three, then remain in the chat room, either participate actively or passively, and then acquire knowledge and information. But here's the thing with TESL. They say, and I'm just going on what their written submissions say, they say that TESL, in fact, logged on, entered the chat room, and he participated. He must have participated because they say TESL remained present in the chat room as active participant as he posted messages in that chat room. Now, I understand your argument is to say this copying and pasting suggests that he was in another chat room, perhaps not even an implicated chat room. Otherwise, it wouldn't have been necessary to copy and paste. That's your argument. Right. So, as far as TESL is concerned then, and CATS, is your argument, given what we've just discussed, is your argument then that there's not even a question of minor participation here as far as ANZ is concerned? There are no allegations at all which bear scrutiny as far as these two are concerned.
That's exactly it.
I ask that because we know that in EG bonds, there are certain features that must be present for a SOC. There could be a core group with peripheral participants, as long as they have the same conduct, and other things. But there's also European authority, I think it's Alborg, which says it doesn't matter whether you're a peripheral or a minor participant, as long as you share the same conduct, even if you passively remain in the chat room and acquire knowledge, and then you become part of the group. You say there's not that doesn't apply at all to ANZ. Yeah. Sorry, are you saying that doesn't apply at all?
So those considerations wouldn't apply to us. We're not a minor participant. We're not a participant at all. And the EU bonds case, my learned friend said, well, in EU bonds, they said the knowledge of a previous employee can be transferred to a new employer if the previous employee communicates his knowledge to the new employer. But they don't allege that.
Thank you, DCJ.
Okay. Thank you very much, Mr. Loxton.
Thank you, Deputy Chief
That will
Justice.
be it. I think we're going to go on to the next thematic respondent, Mr. Gotts. I think you. It's your 30-minute uninterrupted time.
Good afternoon, Deputy Chief Justice and Justices of the Court. I am going to be dealing with two themes in my address. The first theme relates to what we internally call the Nedbank specific allegations. With respect, we consider it important to highlight to the Court the differences between the case that is sought to be made out by the Commission against Nedbank and perhaps some of the other respondents. The second theme is the issue of initiation and joinder, and I would like to perhaps try to divide my time equally between those two topics. If I can then commence with the case pleaded against Nedbank. While the Commission has pleaded a broad, ambitious, single overarching conspiracy, the specific allegations against Nedbank are extremely narrow. The Commission's case against Nedbank is based solely on the Commission's analysis, or what it refers to as an assessment of so-called trading data on the Reuters platform, which is not alleged to have constituted a platform that permitted messaging or communications between the banks. It is a public platform. To be clear, the data on the Reuters platform does not reflect trades, and I'm somewhat hesitant to fall into the trap of referring to this as trading data. It merely reflects, and this is common cause between the parties, indicative quotes posted by the banks. At a particular time on a particular day, a bank will post an indicative quote which contains two components: the price at which the bank is willing to buy foreign currency and the price at which it is willing to sell it. That is the quote. And that quote is posted on the Reuters platform for all to see. Now, the Commission's case against Nedbank is based on the Commission's purported assessment of this trading data over a period of 6 years. The fact that it is based on an assessment of this trading data was made clear by my learned friend, Mr. Ngwatobi. In the hearing before the CAC, we have attached as an annexure to the answering affidavit in the Commission's application for leave to appeal a portion of the transcript in which he makes it clear that this is based on an assessment of the trading data. The relevant extract is at volume 38 and it's page 3587. So, Deputy Chief Justice and Justices of the Court, this is not a case in which the Commission has evidence of Nedbank being a participant in any chat room. And in that respect, the case against Nedbank is significantly different from many of the other respondents and the appellants. The allegations against Nedbank are skeletal. There are 11 paragraphs in the reformulated founding affidavits which relate to Nedbank. Yesterday, my learned friend for the Commission said there are 7 instances over a period of 6 years. We actually count slightly more, but I think the difference comes from the fact that 2 of the allegations, the ones in paragraphs 234 and 235, I beg your pardon, 235 and 236, refer generally to the local banks. In other words, they don't refer specifically to Nedbank. So we count 9 instances if those 2 allegations, the last, are included. Many of the allegations relate to an assessment of trading data over a period of a mere few minutes. There are at least 3 of them, when the allegations are that over a period of 3 or 4 minutes, something happened. Let me give the court one clear example of that. It's the allegation in relation to the general banks, 236. It's at page 441, and I'll just read it very quickly. On the 7th of March 2012, we actually think this is meant 2013, but be that as it may, between the hours of 10:12 and 10:16 UTC, and on the Reuters trading platform, local banks withheld quotes and enabled RMB to dominate the market. The fundamental difficulty is over a period of literally 3.5 minutes, all of the rest of the banks are accused of having withheld quotes. But why is it to be expected that any of those banks, over a period of 3.5 minutes, would have been vigorously posting quotes? But on the basis of this apparent observation, RMB or FirstRand is implicated in alleged collusion, and it appears that Nedbank is implicated in alleged collusion. A similar difficulty infects the first allegation, which purports to bring Nedbank into the single overarching conspiracy in rather extraordinary circumstances on the 1st of January 2008. The relevant allegation is at page 429 of the record, and it's 186. On the 1st of January 2008, between the hours of 2014 and 0513 UTC, and on Reuters trading platform, ABSA and Standard Bank withheld quotes to enable Nedbank to fix the exchange rate at the indicated value. Now, with respect, Justices, I think it's been pointed out before that the 1st of January was a public holiday. The time period indicated, which is starting at 2014 UTC, you have to add 2 hours in order to get to South African time. So we're talking at 10:15 on a public holiday, after normal business hours, and more particularly on New Year's Day. ABSA and Standard Bank are accused of withholding quotes. Now, the Competition Appeal Court had a fundamental difficulty with this notion. And the proposition was put and not properly answered, we respectfully submit, well, why do you expect ABSA and Standard Bank to be sitting in their offices duly posting quotes at that point in time? It's a public holiday. They're no doubt sleeping off the festivities of the night before. Nedbank, it should be noted, is wholly passive in all of this. It's not accused of posting quotes. It's not accused, it's said to be withholding quotes. It is not alleged to be instrumental at all in the conduct of ABSA or Nedbank. And critically, the Commission does not allege that Nedbank had any knowledge that anything that it was doing or not doing on that public holiday constituted the fixing of the exchange rate. But it gets worse. The Commission does not say, and I must preface this by emphasizing that the allegation is that this is an international cartel. The Commission does not say what other banks are doing. It does not say that every other entity authorized to trade in the rand-dollar pair, or even every one of the other respondents, were engaged in posting quotes during that period. If they were posting quotes, it's entirely unclear how it is that Nedbank can be said to have fixed the rand-dollar exchange rate. On the other hand, if some or all of the respondents also did not post any quotes during the period, why does the Commission not accuse them of having withheld quotes as well? So, Justices, it is these types of allegations that Nedbank is expected to answer. I could take the next hour, which I do not have, taking the court through each one of the allegations that relate to Nedbank, to show the paucity and indeed the cryptic nature of the allegation. In many of the instances, Nedbank is accused of having done something nefarious by doing nothing else but posting a single quote. Now, why is that suspicious? Why is Nedbank posting of a single quote during this period in any way nefarious? It is in the business of posting quotes. In addition, the instances referred to are sporadic. The date between the first instance of alleged conduct is the 1st of January 2008. The second instance appears in paragraph 187. It's 6 months later. In paragraph 191, it's alleged that on the 11th of January 2009, between 23:20 and 007, a space of 45 minutes, Nedbank and Standard Securities, alternatively Standard Americas, putting up matching bids and matching bid and asked quotes in succession. That's on the 11th of January 2009. The next allegation that we can see is 196. On the 28th of May 2010. It's 14 months later. 14 months. What sort of cartel is Nedbank involved in? Cartel where once every 14 months or 6 months, it does something, as the justices will see, for a period of 3 minutes. 196. And then, with respect to my learned friends for the Commission, this is simply nonsensical. What they did on the 28th of May was that they affirmed a focal point of 7.57. It is incomprehensible with respect. The next allegation is 229, 16 August 2011. Again, more than a year later. The next allegation, 232, 28 September 2012. Again, more than a year later. Again, 232, a period of 7 minutes. There was a pattern of alleged successive consecutive quotes. So what we see is that the case against Nedbank is based on sporadic allegations of cryptic market conduct that the Commission has effectively thumbsucked from a set of trading data. And I say thumbsucked advisedly. What the Commission has is a record of these quotes. The record itself does not say that a particular bank is withholding quotes. What the Commission is assessing, observing, is that a particular bank did not post a quote. It's drawing an inference from the data that is available. And that is the case. That is the entirety of the case against Nedbank. What does the Commission not do? The Commission does not put Nedbank in any of the chat rooms. The Commission does not allege that there was any contact, communication, understanding, agreement, consultation, sharing of information between Nedbank and any of the other respondents. One would have expected an allegation. Let's take 186. One would have expected an allegation that said, perhaps, 3 employees of the various banks were sitting on Christmas Day on Camps Bay Beach, and they hatched a plan to implement a withholding pattern on New Year's Day the following week. But there is no such allegation. There is no allegation of any prior contact between Nedbank and any of these firms. And we respectfully submit that that is fatal to the Commission's case. The Commission must allege that there was a prior agreement. It does not. The Commission will say, no, but this is an inference that you must draw. An inference that there was some prior agreement or contact on Camps Bay Beach the week before. But it hasn't pleaded such an inference. There is no allegation in this founding affidavit which says we must infer from this conduct that there is a prior agreement between the parties. On the issue of the single overarching conspiracy, many of the parties have addressed the requirements that have been set out in teams relocations. The third requirement is knowledge. Knowledge of what the others are doing, knowledge that what you are doing is contributing to this overarching global conspiracy. Now, by contrast with the case that is articulated in relation to the other banks who have been a participant in chat rooms, where the Commission's case is quite clearly that the participation in the chat rooms gives rise to knowledge. There is no similar allegation in relation to Nedbank and this data. So may I refer the court to paragraph 86 of the founding affidavit, where the allegation is clearly made that if you are a participant in a chat room, you will, by virtue of that participation, have knowledge of the SOC. There is no such allegation against Nedbank. There is absolutely no basis in these pleadings on which to suggest that Nedbank had knowledge of the SOC. Now, my learned friend, Ms. Hobden, for the Commission, comes yesterday and says, no, but that's another inference that you must make. So this is now the third inference. The third inference is because this conduct has some vague similarity with something that we have identified in the chat rooms, you must infer that Nedbank had knowledge. With respect, that is fundamentally problematic. If I may refer your lordships, if I may refer the court to the Soliver case. The Soliver case made the point that, and I do not, in making this argument, concede that any of the prior requirements have been met, but in the Soliver case it was made clear that the only decisive criterion in order to establish the participation of an undertaking in an overall cartel is whether that undertaking, when it participated in a particular agreement or concerted practice, knew or should have known that in doing so it was joining in the cartel as a whole, thereby expressing its accession to that cartel. But the case also makes the point that the mere fact that a firm participated in one aspect of the conduct with which the SOC is concerned does not mean that a party was involved in the agreement as a whole. Something more is required. So the inference that the Commission asks you to draw is fundamentally wrong as a matter of principle. The fact that, and I'm not suggesting that Nedbank has, been engaged in collusive conduct. But the mere fact that it is engaged in conduct 7 times over a period of 6 years cannot lead to an inference on the Soliver test that it knew or should have known that what it was doing was joining the cartel as a whole, thereby expressing its accession to that cartel. The Soliver case and the relevant passage, which is paragraph 101 of Soliver, has been accepted into our law by the Competition Appeal Court in the NPC Simpor case at paragraph 80. So that principle that I've just read out is already part of our law. Now, may I turn very briefly to what we do, or what we say the court with respect should do, given the fact that the CAC judgment does not deal with Nedbank at all. We accept that there is no, well, let me qualify that. We accept that there is no heading that says Nedbank and an analysis of the Nedbank allegations and a finding that in relation to Nedbank specifically, that a case is not made out. But that does not mean that findings that the court made in relation to other banks aren't equally applicable to Nedbank. At the end of the day, the Competition Appeal Court set aside the Competition Tribunal's order dismissing the exception. It must have had a basis for doing so. And that basis we submit is the fact that precisely the same complaints were considered and analyzed in relation to other banks, and in particular FirstRand and Standard Bank. In relation to FirstRand, the relevant passages of the judgment, record volume 5, I think it's volume 5, 287, paragraphs 154 through to 161, where the court analyzes the allegations. It specifically mentions allegations such as Sunday, 11 January 2009. That is an allegation which implicates Nedbank as well. In 156, it mentions 28 May, 7 March, 20 September, 28 September. All of those allegations implicate Nedbank as well. And the court ultimately concludes in 161 on page 288 that there is no case which was made out in the referral affidavit which implicates FirstRand Bank. Accordingly, the appeal must succeed. We submit that by parity of reasoning, the same conclusion must be reached in relation to Nedbank. As a matter of logic, if the court had difficulties with the allegations made against Nedbank, it would almost certainly have said so. Similarly, in relation to Standard Bank, the allegations are dealt with in paragraphs 165 and 166, the New Year's Day allegation in 165, and then critically the concluding words of 166, where the court says this information gleaned from the Reuters platform is hardly indicative of participation in the SOC. We submit that that is a general factual finding. It's a factual finding, not a finding of law. And in relation to Nedbank, Nedbank can rely upon that factual finding. And so the application for leave to appeal must fail, both on its merits and because of the fact that there is effectively appeals against factual findings, and that aspect of the case must fail. May I deal briefly in the 4 minutes that I have available with the initiation point? I do not need to belabor the point, as given the discussion yesterday, the justices have the point that is made. One cannot rely upon Pickfords for the proposition that a firm that is not referred against can still be added, as it were, later in the proceedings. Under this notion that it was implicated in the original cartel, the tribunal found that that was not a proper reading of Pickford's. The Competition Appeal Court said that that was not a proper reading of Pickford's. And we submit that it was not a proper reading of Pickford's. Paragraph 21 of Pickford's makes the point, contrary to the submissions of the Commission, that it is important to identify parties or firms. You cannot draw this artificial separation between conduct and firms when evaluating whether or not there has been an initiation against a prohibited practice. And that must be so as a matter of text, context, and purpose. An initiation is against a prohibited practice. A prohibited practice is defined as conduct engaged in by identified firms. Excessive pricing is engaged by a dominant firm. Can't evaluate excessive pricing in the air, divorced from the culprit. And while we accept that in cartel cases, it is often not possible for the Commission to be able to identify each and every one of the alleged perpetrators of the cartel at the outset. And for that reason, the courts, including this court in Pickford's, have said there's no problem in adding respondents at a later stage by way of an amendment to the initiation. That is not a license to do what the Commission has done in this case. Having regard to the three stages, there was an initiation in 2015, a referral, an investigation, a referral in 2017. Nedbank was not one of the parties that was referred against. And then in 2020, 4 years later, Nedbank is, as it were, added to the mix. We say that the cutoff point was the referral. The investigation is complete. The Competition Commission has identified the firms against which it has evidence. The cutoff point is the referral. Cannot continue to investigate the same complaint after the referral of that complaint to the tribunal. And a moment's consideration would reflect that if that is the proposition of the Commission, it's an abhorrent notion. The notion that the Commission, having referred a matter against a variety of banks, can continue to investigate either those banks or other banks post the referral, using all of its investigative powers, such as search and seizure, interrogation, summonses of witnesses, in a stage where it has referred the matter and is effectively appearing as a litigant before the tribunal. But that is the natural consequence of the argument that the Commission wishes to make. And we submit that it should not be accepted. Pickford's finds no support in Pickford's. And so on the Commission's own version, it has not initiated against Nedbank, and for that reason cannot refer a matter against Nedbank, and as a consequence can also not join Nedbank to the proceedings. I had another topic, but I'm going to run out of time, so best I not start it.
Thank you, Mr. Goff. Thank you very much. We will take the lunch adjournment now for 30 minutes. And then we'll come back and we will put some questions to you. But let me just say this. There is a very strong possibility that we will sit beyond 4 o'clock today. I'm just warning you.
I hope that's not a warning to suggest that I will still be up at 4 p.m.
So, Court adjourns for 30 minutes.
hatched a plan or exchanged an email that planned this result. This seems to be a conclusory statement. It's essentially saying we've looked at all this data and this is a summary of what we say it shows. In other words, it's the type of paragraph that would appear at the end to say, having regard to all of the above, we conclude that this is what the parties did. To say that this is an allegation which, as it were, prefaces everything and is intended to capture, by way of this level of generality, an allegation that my client met with ABSA on a particular day, we say is deficient.
I appreciate it would be poor pleading, but nevertheless it does appear at the beginning and not at the end, and it is not stated to be an inference drawn from the information that follows. So the most natural reading, is it not, is that everything that follows from 186 is as a result of arrangements of the kind described generally in 185. Now, I would have expected them to say, well, ABSO at least was represented in that respect by Kunani and, what's it, House, whoever their other man was, who might or might not remember who the Nedbank person was, for example. But we've got to look at this in every way it can be read. And should we be concerned, why should we not be concerned that the information we read here is of a kind that ABSA has identified to the Commission and is based on the recollection of witnesses that at least these instances were instances flowing from pre-arrangements, even if they haven't been and perhaps couldn't be specifically identified with reference to dates.
Justice Roy, I do need to emphasize, to the extent that your question is, can we read this as something that the leniency applicant has provided? In relation to Nedbank and, in fact, FirstRand, the Commission has, in fact, made it clear that its case is based on the trading data and an assessment of the trading data. That is what it said to the tribunal, and that is what it said to the Competition Appeal Court. Now, there is this difficulty, of course. In exception proceedings, one needs to look at the four corners of the pleading. But the Commission has, in fact, clarified that its case is based not on information provided in relation to these paragraphs by the leniency applicant. It has said expressly that it is based on its assessment of the trading data and has made that point on a number of occasions in the prior fora.
Yes. Well, I think perhaps to some extent that is how the Commission's counsel even put it in this court.
Indeed.
But we shall hear. I certainly wouldn't want the Commission to have us decide this case on the basis that all of this is based on evidence that it has from specific people, that these were coordinated matters, if that isn't in fact the case. But I'm sure it will be clarified in reply whether this, as you say they've said to the tribunals below, is based simply on its analysis. On that basis, then, we'd have to read paragraph 185 as the inference, which is said to be supported by everything which follows. Thank you.
I've got a question. I've got a... I just have one question, Mr. Katz. Is it competent to pursue both a review and an appeal on the same facts in the tribunal?
Justice Torona, I was hoping that that wasn't going to be a question posed, given that it is a relatively complicated issue, to be honest. And there have been some recent decisions by the Competition Appeal Court which have dealt with this issue. So there was a review and an appeal brought in a matter that was decided by His Lordship Mr. Justice Valley in January. That is something that the Commission has identified. There have been two recent decisions by the Competition Appeal Court which find differently that, depending on the circumstances, a review is competent. One in a matter EST versus PPC, or rather PPC versus EST, and the other in the Lotto Land case, if I'm not mistaken. And in both of those cases, there's a more nuanced approach where the Competition Appeal Court essentially says, yes, there might be issues when there's an overlap, but depending upon the nature of the review, it may be preferable for us to decide the review. And so I, and decide the review and the appeal is also potentially competent. So with respect, Justice, I'm not sure that there is a simple answer. What is said, certainly in the EST PPC case, and I can get the reference for the court, is that it all depends on the facts. And so, yes, it all depends on the facts. What does seem to be relatively clear now, certainly not at the time that Nedbank launched its review and appeal, is that the court may frown on reviews and appeals which raise identical points and which are essentially a replica of the others, just framed in different ways. But Justice Saron, we thankfully don't need to resolve that question. Ultimately, what the Competition Appeal Court did was not decide the review. There's no decision on the review. And so an appeal to this court, an appeal always being with respect against an order, there is in effect nothing to appeal against. And so it's appealing against conduct of the parties. It's not appealing against anything that the Competition Appeal Court decided by way of an order. And so we would say, as regards that aspect of the Commission's appeal, A, it shouldn't be entertained, and B, to the extent that the court entertains it, it can't categorically say an appeal and review are not competent if brought simultaneously. It depends on the facts.
Mr. Goss, thank you.
Thank you, Mr. Lotz. I just have one question. Thank you.
Yes, Justice.
Mr. Lotz, in analyzing the number of incidents that Nedbank may have been, let's not say implicated, but named, you may have missed one at paragraph 192, and that was more than 7 seconds. That seemed to be 7 hours. That doesn't really matter. It's neither here nor there. But it's with regard to posting, ask and bid prices, etc. But I suppose your response would be, well, one more doesn't really make a difference. But the point I simply wish to raise is that what the approach of this court must be in looking at that information. And the judgment of the Competition Commission in Competition Commission versus, let me just get that, got it here 1 second, Interaction Market Services Holdings. It's quite instructive because it spoke of the need to recognize that one was dealing with some issues that were relatively unique in competition law. It involved the intersection of law and politics. It involved the court having to sort of draw conclusions from economic data, which is very different from, in a sense, the day-to-day stuff that facts, proven, etc. So that's one important issue. And then secondly, it also recognized that in looking at allegations of cartel conduct, invariably you may have to resort to inferential reasoning. And ultimately, whether an inference is proved or not is to be established at the end of the proceedings. So to that extent, you probably would agree that we have to be guided by those considerations as well. It doesn't detract from what you said, but I just want to make sure that we locate what you said in that understanding of our approach to both the pleadings and the allegations that seek to suggest collusive conduct on the part of Nedbank, as well as ultimately the establishment of inferences, and at which stage we satisfy ourselves that an inference has been properly established.
Indeed, Justice Colopin. Just on the first point, we did do a calculation of the total time which my client is alleged to have engaged in collusive conduct, and over a period of almost 7 years, the total time is 24 hours. And as I'd indicated, many of those instances are 3 or 4 minutes, and the question does need to be asked, well, what sort of cartel is this where a party aligns its prices for 3 or 4 minutes with another bank? What is the point of doing so? As regards the general question...
I'm not sure if that's a neutral fact. I mean, we don't have any evidence with regard to whether a cartel can bring down an economy in 6 minutes. It's possible. Or manipulate, so that factor is neither here nor there, not so. Just as midnight on New Year's Day is neither here nor there, if we take into account that the markets open throughout the world 24 hours a day.
Well, with respect, Justice Colopin, there is a section towards the end of the affidavit where the Commission explains in some detail how vibrant these markets are, and we're talking literally millions of trades a day across the world. And so the context in which the Commission itself recognizes that this conduct occurred certainly does indicate that it's unlikely that this is certainly as far as my client is concerned, I'm talking specifically about Nedbank, is something that its conduct, if it is collusive, had any impact at all. But we deny, of course, that it was collusive. As regards the general principle, Justice Colopin, that you asked, yes, of course, these are matters that at the end of the day might have to be decided with reference to economic evidence and the like. The problems that we have are matters of pleading. There are essential facts that are simply missing. The essential fact, for example, the essential fact that my client had knowledge of the broader cartel, it's simply absent. What is alleged in paragraph 86 is that the participants in the chat room had knowledge. That is never alleged in relation to Nedbank. Now, the Commission came and said, well, you must draw an inference that the conduct, because it is similar, results in knowledge. But you need, with respect, one needs to plead that. That allegation is never made. And so my client, on the face of it, does not have a case to answer in relation to the single overarching conspiracy, and what the Commission itself accepts is the necessary things that it must allege in order to bring all of the banks into the conspiracy. Simply missing material allegations. And that is our fundamental point. As regards inferences, of course, we submit that a court at this stage can, to the extent that the Commission is expressly relying upon inferences, can interrogate whether or not those inferences are justifiable or not on the ordinary test of inferences. And we submit that that is something that is competent. If the Commission is saying my pleaded case is one of inference, then we submit that the court can and should evaluate whether that inference is competent on the basis of the facts pleaded.
Even though that exercise may be best one reserved for the determination on the merits, but are you saying that once it's dispositive here, then surely the court can't go back to it for the purpose of an exception?
At the end of for the purpose of the exception, we submit that one ought to engage in that exercise. Of course, at the end, having regard to all of the evidence, different inferences may need to be drawn in relation to a particular bank that survives these proceedings and must go and answer the case. There may be direct evidence that comes out. Inferences may be unnecessary. So there is a different test at the end of the proceedings.
But if the test will remain the drawing of an inference, are they tested at different levels? Or are they the same test both at the stage of exception and at the stage of the merits,
Or Justice Colopin,
if there's no direct evidence?
I'm mindful of the question that you asked, but with respect, bear in mind that the test on exception is whether these facts are put up, and only these facts are put up at the end of the trial could relief be granted. So we submit
The correctness of those facts.
It's not a matter of saying, well, more evidence could be presented at the end of the day. Obviously, more evidence may be presented, but one cannot say we ignore the ordinary principles and the tests and say anything may happen and therefore the exception must fail.
Thank you. Thanks.
Thank you very much, Mr. Godds. I think that's all the questions we have for you.
Thank you, Deputy
Thank you very
Chief
much.
Justice.
Yeah. We now have the third and the fourth respondents. Counsel, that's you, Mr. van der Nest. My understanding is the third respondent's involvement in the joint submissions is to argue a matter that is said to have been dealt with in KEC 1 and should not be rehashed here.
Deputy Chief Justice, yes.
Okay.
The third respondent was unsuccessful in front of the CAC and consequently is not a respondent in the Commission's appeal.
Yes,
It is not an appellant in this court.
yes.
And so it wouldn't have participated, save that because of the argument that has been raised by the Commission in this court looking to revisit CAC 1,
Yes.
where the third respondent was a party, the third respondent has made written submissions.
Thank you. And you've been in court and you had the debate between the bench and counsel on those issues. So hopefully you'll do what Mr. Loxton did.
Yes, Chief Justice, Deputy Chief Justice, I have one or
Deputy
two
Chief
notes,
Justice.
which if I get permission after I've made my 15-minute submission, I may just address one or two things that have
Yes.
arisen in the course of the discussion.
Thank you very much. Please do that in your allocated 15 minutes. Thank you.
Thank you, Deputy Chief Justice. Members of the court, the fourth respondent has made written submissions, and it has also made written submissions with the third respondent, and so I'm not going to traverse those, but would ask that they be dealt with in the court's time. Before I deal with the facts relevant to the fourth respondent, I want to deal with 2 points of principle. The first point of principle, I think, has been uncontested so far, but it's important to mention it. And that is that the appeal in respect of each respondent must be dealt with independently. This is not a matter in which the court will grant leave on one issue and then look to revisit all issues. We respectfully submit that the correct way to deal with this is to look at the appeal in respect of each respondent, look at whether there is in fact a constitutional issue or an arguable point of law of public importance in respect of that respondent, and make the decision in respect of that respondent. And where there are respondents where the appeal is purely a factual one, then leave to appeal ought not to be granted in respect of those respondents. The second point of principle relates to pleading. And it's in the context of certain of the debates that have been raised yesterday and today. Mr. Justice Majid this morning said that the Commission's in the same position, or asked the question, isn't the Commission in the same position as a civil litigant, where they don't have all the facts when they're about to make their pleading? And there is a fundamental difference in this case. We've spoken of the 3 phases. The initiation is the point at which the Commission is in the position of a civil litigant. Once that initiation has been made, the Commission is no longer the civil litigant. It now has the full powers of the state. It now has the powers to subpoena parties, to do dawn raids, to call for documents, and consequently, by the time the referral is made, the Act and the rules say the Commission must be satisfied that it has sufficient facts to convict. It has, I use the word convict, it's my word, it's not the word of the legislation, but it must have sufficient facts to have a positive finding against the respondent. And so when we receive a referral, we are not receiving the plaintiff's particulars of claim against the hospital where they still have to get the hospital records. We are in a position where the Commission has now exhausted its investigative powers, the powers of the state, and has now decided it has the facts, all of the facts to secure a conviction. And with respect, that imposes a different duty on this Commission. They are obliged then to plead facts. And I heard the debate with Mr. Justice Rogers this morning. It wasn't paragraph 185 enough. With respect, there is a fundamental difference between a primary fact and a secondary fact. And in our heads, we've addressed that. The primary fact is the fact itself. The secondary fact is the conclusion that you draw from those primary facts. And what the Commission has pleaded are conclusions. And the reason there is an objection and why this case has been fought so hard is because the Commission has not pleaded primary facts. And so I would ask and submit that the correct approach to this matter is to look, when you read the pleading, and decide whether or not what you're reading is a primary fact or merely an allegation. Then, if I could turn to the case against the fourth respondent. The issue on the appeal in relation to the fourth respondent is a very narrow point. The essence of the case is recorded in paragraph 124 and 125 of CAC 2. In summary, what the CAC found was that the Commission did not plead facts to establish the cause of action arose out of the business carried on with the fourth respondent's branch, or that the collusive conduct was attributable to its appointments and authorized dealer in South Africa. I want to highlight this is a point taken only by the fourth respondent in these proceedings. It's a point particularly to the fourth respondent. And the facts are important to understand because the law is a very narrow point of law. And the point is this. The common law and the common law cases that we've cited have not been challenged by the Commission. So there's no dispute on what the law is. The law is that if you want to establish jurisdiction over a foreign party in a local court, and you want to do so by way of the branch office, that if you make the allegation, the reason I have jurisdiction over you is by virtue of your branch office, then in pleading the subject matter over which the jurisdiction is pleaded, you must plead the subject matter or the conduct into the branch. You must say that the conduct in which I am bringing you to court for is conduct at the branch. That's the law. That's the common law. It's been the common law for more than 100 years. And that is the point that was taken by the fourth respondent in these proceedings. It said, you have brought me here on the basis that I have a branch and I am an authorized dealer. And the relevance and prejudice I'll come to. But you say you have a branch in Johannesburg and you are an authorized dealer in terms of the exchange control regulations. That's why I am asking the court to exercise jurisdiction over you, or the tribunal to exercise jurisdiction over you. We say, if that's the reason you bring me to court, you must plead facts which show conduct in South Africa by my branch or as an authorized dealer. And we say no such facts are pleaded. The answer from the Competition Commission is that they don't make a positive case. They don't say we did plead facts. What they say is that the Competition Appeal Court erred because JP Morgan introduced new facts. They say you introduced new facts, and because you introduced a new fact, the Competition Appeal Court took account of that new fact, and that's the reason why the Competition Appeal Court was incorrect. And we submit, and I want to take you to the facts to show you that there was no new fact. So if I could ask that you go to volume 17, if that's available to the court, and to paragraph 13, where we plead that at no point does the Commission allege that either Mr. Iyer or Mr. Simister worked at the Fourth Respondent South African branch or exercised the powers of an authorized dealer within South Africa. As the Commission is well aware, neither Mr. Iyer nor Mr. Simister was employed in South Africa. That is the new fact to which the Commission objects. The Commission says that's a new fact, and the introduction of the new fact is the problem and the reason why the CAC should be, why the CAC order should be overturned. First of all, the allegation is the knowledge of the Commission. That's the first point. The second point is there's no onus on a respondent. The onus is on the Commission to plead the positive fact. And there's no dispute that they haven't pleaded the positive fact. But as to why we were entitled to plead that the Commission had that knowledge is because it appears from the Commission's own pleading. And if I can ask you to go to page 470 in the referral, I think that's volume 5. And this is a part of the referral that my learned friend referred to more than once, referring to the people who went to jail. Mr. Iyer, who is alleged to have been employed by J.P. Morgan, Mr. Iyer was found guilty in the New York Southern District Court. So where there was an allegation that there was a knowledge of the Commission as to where Mr. Iyer was employed, and we say the Commission had that knowledge is pleaded by the Commission. And so the introduction of a new fact is not a basis on which to resist the CAC order. The other important element, I said I'd come to the prejudice and why it's important, is because in the Competition Act and in those proceedings, there is a specific, there are country-specific elements to the factual investigation. The first one appears from the Commission's referral at page 464 in paragraph 274. At this paragraph, the Commission says that the conspiracy included at least 5 insular South African banks and 4 authorized dealers. This accounts for 9 out of the 25 authorized dealers in South Africa. The influence of the global conspiracy, therefore, also had the potential to affect competition within the local interbank market. And what this does is it puts beyond doubt that the Commission wants to make a case that there was a South African branch, that the authorized dealer was in South Africa and party to this alleged conduct. So where you make a general allegation like that, you have to plead facts to back it up. Primary facts, not conclusory allegations. The second point goes to remedy, because when a party is brought before the tribunal, they may be subjected to an administrative penalty. But that penalty in terms of Section 59 is only in respect of the turnover in South Africa. So if they bring the Peregrinus here by way of a branch in respect of their relevant income in South Africa, then that turnover is on the line. If they are bringing in a foreign Peregrinus in respect of something happens overseas, that turnover is not on the line. And so there is a fundamental reason why they pleaded in, and a fundamental reason why they should be held to their pleading. Because as this court said in Kaba, when you're assessing jurisdiction at pleading stage, you look at the pleadings, and you don't look to try and give them some, you don't try and create a different case. Sorry, I don't have the quote from Kaba in front of me right now. That is 2010, volume 1, 238 in this court at paragraph 75. So that is the basis on which the JP Morgan fourth respondent presented its case to the Competition Appeal Court, and the Competition Appeal Court agreed with it. Now, there is the relevant question here is whether there are facts. Whether there are facts which plead the case against this respondent into the branch in Johannesburg. And where there are no facts, and that is the basis on which the finding was made, then leave to appeal ought not to be granted. I see I have 1 minute and 54 seconds, Chief Justice. If I can deal with a couple of points. Just in relation to Mr. Loxton's address in relation to preemption, I acknowledge Mr. Loxton's point. I just want to make it clear why we understand preemption is not applicable. The reason preemption is not applicable is because it's a principle that applies to appeals. And my learned friend yesterday for the Commission said they are not appealing the CAC judgment. If they were appealing the CAC judgment, as in Van Arbo, the applicant came and said, I'm appealing CAC number 2 and I'm appealing number 1. And the question was, are you preempted under 1? So the question of preemption arises if that step is taken to apply for leave to appeal. What would be an extraordinary outcome is if they are in a better position by not appealing CAC 1 than they would be if they had. So just to put preemption in its context, it's not something we must ignore. It is a relevant factor because it's only not relevant because the Commission hasn't challenged that judgment. If they had, preemption would apply. And we say that they couldn't be in a better position. And then lastly, just dealing with a question to Mr. Gotz in relation to a benevolent reading of the pleadings. I think we've referred to I can't remember which minister it is, but the minister in Kadir, I think it's the Minister of Police in Kadir, where the exception test is set out. And what the appellate division said there was, you plead your facts. Your case can't get better at trial. That the facts on your pleadings must be sufficient to allow you to win a trial. You can't suggest that more facts will be introduced. And that's the law. We said there were trite principles of exception. That's one of the trite principles. Deputy Chief Justice, thank you for the indulgence.
Thank you very much. You granted yourself the indulgence.
Mr. van der Nest, can I just ask, in relation to the third respondent, who the Commission says isn't really before us at the moment, it's neither an appellant nor a respondent in an act of appeal, does that have a bearing on the res judicata point? And it might affect other parties who are not, Investec isn't here, for example, 2 Investec entities. As I understand it, although for various reasons they may not think it worth pursuing an exception type of objection, it will still be open to the third respondent and the Investec entities at trial to show that there were in fact not adequate connecting factors or qualified effects in accordance with the first Competition Appeal Court judgment. And for that reason, an absence of personal or subject matter jurisdiction. If they are not here, what is the position about us nevertheless reversing a point of law, which if we were persuaded that this was one of those cases in which we should depart from res judicata, would the result be binding only upon the active respondents in this court, leaving the third respondent and the Investec entities untouched? They can still hang on to CAC 1.
Yes.
Or should it rather inform our decision as to whether we actually allow a deviation at all?
Yes. Mr. Justice Rogers, it is a pertinent question, and it is a question of fairness, because it does strike at the fairness with which the parties who are not here will be treated. The consequence of this court declaring a different legal position will be that that is the legal position, and whoever decides a matter after this will be bound by this court's decision on the legal position. The unfairness arises in this case, where in this case, as between these parties, the parties who are not before this court wouldn't have had a chance to participate. Now, and that's the direct answer to your question. But if I can give you some context to that question, and it's something that my learned friend for the Commission seems to have brushed over. We are here on their pleadings. Whether there is a dispute about something must arise from the pleadings. There was a question this morning that says, well, now there's a plea of res judicata. There's no plea of res judicata on the pleadings. The reason there's no plea of res judicata is because it's not a dispute between the parties on the pleadings. And unfortunately, once one gets to this court with the greatest of respect, we start talking in concepts and theories and principles. But that's why a case like this should never come to this court. Because this is a case about pleadings. And the pleadings in this case, if I can take you to the referral, the pleadings in this case, and I just want to take one topic, it's not necessarily the only topic, there are pleadings on personal jurisdiction. Well, let me take you to the personal jurisdiction of foreign Peregrini. Page 391 of the referral, paragraph 50. It says, the tribunal has jurisdiction over the foreign Peregrini by virtue of the following connecting factors. It says the foreign Peregrini participated in a conspiracy involving the exchange rate of the South African rand. And number two, the foreign Peregrini participated in a conspiracy together with South African respondents. Now, my learned friend says the CAC introduced a new test. CAC wasn't introducing a new test, it was checking whether it said that the Commission hadn't proved what it pleaded. The Commission didn't plead a fact that there was participation in a conspiracy with a South African respondent. Now, the parties who were party to these pleadings, now remember, the consequence of dismissing the appeal is that we go back to the tribunal on these pleadings. Now, all of a sudden, we need to ignore some paragraphs. Because in the Constitutional Court, the Commission decided its pleadings didn't fit its case anymore. And we submit that that is a significant complication, and it's a complication that arises pertinently in respect of the third respondent, but it arises for everybody.
Thank you.
The second point I wanted to raise in the same context is at page 200.
Are you still answering my question?
I am answering your question. It's the same. It's just a second example in answering your questions, Justice Rogers, and it relates to the qualified effects test, which is another element that would fall away if this challenge, belated challenge, affected the third respondent. If you go to page 445, that is paragraph 259. At paragraph 259, the Commission says, the conspiracy had a direct or immediate and substantial effect in the Republic, and it was foreseeable that the impugned conduct would, or had the potential to, have such effect. It then goes over the next 10 pages and deals with allegations where it deals with directness, direct or immediate, substantial, and foreseeable. And it says, this is why it is. That's their pleading. They've pleaded themselves into a qualified effects test.
So you would say the potential prejudice to the third respondent is it's perhaps absent here because it's confident at trial that it's joining in a conspiracy with South African banks will not be proved, and that the qualified effects won't be proved. And that's the case it understands at the moment it has to go to trial on.
Precisely. Precisely. And that's what it argued before it said that the facts in these pleadings, that's what it argued before the CAC. So the facts in these pleadings don't achieve that. Now, on a pleading basis, there's a benevolent reading of a pleading, but it has the potential and the ability to go back and address that at trial.
Thank you.
Thank you, Chief Justice.
Thank you, Deputy Chief Justice. Mr. Turner, I'm sorry, I'm a bit delayed.
Sorry.
In the respondent's response to the Competition Commission's submissions regarding jurisdiction, it is submitted that the principle of territoriality, as was determined in the Lotus matter, is the guiding principle for jurisdiction. Now, that is somewhat different to the effects test as formulated by a number of jurisdictions, the United States, the European Union, Brazil, Nigeria, as those countries have all accepted that in the context of competition law, some degree of extraterritoriality is necessary to properly address and combat anti-competitive behavior in that industry. Now, is the submission that's being advanced on behalf of the respondents that you represent not an outdated approach to jurisdiction and potentially harmful for the South African market?
Thank you, Justice Turan. No, let me make it clear what we are saying. We do not dispute, and I think we said it right up front in our practice note, we do not dispute the Act has extraterritorial reach. That there's no dispute that Section 3 allows the competition authorities to investigate and for the Act to apply to conduct in foreign countries, which has an effect in South Africa, and that effect is, of course, is the qualified effects test, the direct, substantial, and foreseeable effect. So if there is a direct, foreseeable, substantial, and foreseeable effect in South Africa, the authorities in South Africa have the opportunity. So we are aligned with the foreign jurisprudence on that. The question that we were addressing here is that both in the Competition Act and in the Constitution, the parties are required to read statutes consistently with international law. So where you are dealing with the interpretation of a statute, and particularly a statute that purports to extend jurisdiction extraterritorially, you must consider international law. The Constitution enjoins us to do so. And what we are dealing with here is what is the international law. And so that is the international law. It's not a question of being outdated. It's a question of taking it into account and doing as little damage to it as possible. And what we say is in doing as little damage to it as possible, you will not abandon the requirement for personal jurisdiction.
I didn't quite understand the submissions that you made in respect of your response to the objection by the Commission that JP Morgan was adducing new evidence in the exception proceedings. Is the position of JP Morgan that they are not introducing new evidence?
Yes. If I can make two submissions on that. The first is the one I addressed, the one that is pertinent to the fourth respondent. We say that's not new evidence at all. And in any event, it's not the test. The test is, did they plead the fact? It was their pleading that would get them home. Second element was that there was a complaint that in the second half of the JP Morgan affidavit, there is a fairly extensive explanation of terms. There's an explanation of what is the fix, what is a spread, how do these things work. And with respect, we would submit that that is a better way to label and understand these terms than to do so from the bar. And so that's not new evidence, it's just explaining that when you talk about an exchange rate or a spread, what is that? And that is what is explained in that affidavit. But it has no bearing on the fourth respondent's appeal, the appeal against the fourth respondent.
Thank you, Mr. Turner. Thank you, Deputy Chief Justice.
There's been some confusion, but Mr. Turner, the Commission makes this point as far as the fourth respondent is concerned. The Commission says it's not clear how the CAC found jurisdiction over the third respondent, who is a foreign, a pure peregrinus, but then finds that in respect of the fourth respondent, who they say is a branch officer, it's not a pure peregrinus, they say the two doesn't rhyme. And then the second point in the same breath, it says, Commission says, in its argument, your client, the fourth respondent, is in the same position as BNP Paribas, and I think another, could be one of the HSBC Bank, which is a UK company. What do you say about that argument? So there's no clear, it's not clear on the reasoning, or the reasoning is absent to show why there's this distinction.
I think with respect to Justice Vijay, there's a simple answer to that, in that when you are deciding an exception, you are bound by the four corners of the exception that is taken. The fourth respondent took the exception in relation to the branch office and pleaded the absence of a legal basis. The other respondents didn't. And it's not a question of comparative reasoning. This is an exception against a pleading, and you are bound to the four corners of your exception, and so that exception wouldn't be available to others because they didn't take it.
Now, perhaps I missed it the first time, but can you just explain to me again why? I mean, I can understand it for jurisdiction as far as the Johannesburg branch is concerned, why there's this distinction between the two, the third and the fourth respondents, but why do you say it is a requirement for subject matter jurisdiction that the conduct should be linked pertinently to the Johannesburg branch office?
The short answer is because that's the common law requirement. The common law says if you are going to cite a party by virtue of their branch office, it's the authority of Appleby and Dumbles. It's in our heads of argument. It's Appleby and Dumbles, Dundas. It is and it follows authority that comes from Innes J.A. and even before him, the first Solomon, and not the very first Solomon, just the first Solomon in our. Then and has been approved in our courts. And Justice Majid, I think you were sitting on the bench in the SCA in Cathay Pacific and Lynn, where the branch office point and exactly the same point was taken and confirmed.
That is so, but are you saying that Section 3.1 did nothing to disturb that common law position? In the sense that, as I understand it, but I may be misunderstanding it, what is argued is that there's this disjunctive, if it has an effect in South Africa, then, well, I think that may be personal jurisdiction. But you say the common law remains extant. There's been no change in the statute.
I submit, yes, there's been no change, and more importantly, the Commission doesn't argue for a change. They haven't challenged any of that law, either before the CAC or before this court.
Thank you, DCJ.
Thank you very much. That seems to be it for
Thank you,
yourself. It's now the turn of the Standard Bank of South Africa case. Is that yourself, Ms. Hofmeyer?
Yes, thank you, Deputy Chief Justice. If I may just arrange my files for a moment.
Pass this on up or when to check if this is what you want.
Should I begin to talk? Thank you, Deputy Chief Justice, and members of the court.
Yes.
I propose Standard Bank to address two topics, but before doing so, to get out of the way two aspects of overlap between the arguments of Standard Bank and the arguments you've heard previously. The two areas of overlap begin first with the submissions that my learned friend Mr. Loxton made earlier today regarding questions of fact and questions of law, and why questions of fact should not entertain this court in the leave to appeal application. We associate ourselves with his analysis of the true criticism levelled by the Commission against the Competition Appeal Court's order, focusing on questions of fact, inferences drawn from facts pleaded, we say ought not to occupy your jurisdiction. We say is the same insofar as Standard Bank is concerned. The nub of the Commission's complaint against the CAC's order in relation to Standard Bank relates to matters of fact, and we say leave to appeal should be declined on that basis. The second area of overlap is in relation to Mr. Gotts's arguments just before lunchtime regarding the exception test and why applying an exception test to the pleaded case against, in his case, Nedbank, but we would say Standard Bank similarly, is woefully inadequate and does not permit the respondents to know the case that they were called to meet. But the two topics which you have not heard submissions on yet are the ones I propose to focus on in my uninterrupted time. The first of those is to make an argument for why the CAC was correct to take into account the new facts that were submitted in Standard Bank's dismissal application. And I shall do that against the backdrop of the procedural history of this case. And I will do so for one reason, and it will be this argument. The reason why it was permissible for the CAC to take those facts into account is because the guiding principle for the proceedings of the tribunal is one of fairness. We know that it is a sui generis beast, and its processes are such too. And so with the guidance of fairness, it may and ought to have correctly taken into account the facts that Standard Bank set up in its dismissal application. So that will be the first topic, and the second will be against those facts to show this court why the referral affidavit, sixth iteration of the Commission's attempt to plead this case, was woefully inadequate, and that why the case against Standard Bank was correctly dismissed. So if I may begin with the first topic. Justices, this case began 10 years ago. In April of 2015, the Commission initiated a complaint. It investigated it for more than a year and a half, and in that year and a half, it did not meet with Standard Bank once. It did not ask Standard Bank for a single document. It did not send it a single request for information. And it did not subpoena one of its representatives. Despite that, on the 17th of February 2017, it went to the media. It went to the media and told the media that it had decided to refer a collusion case to the tribunal for the prosecution of 16 banks, including Standard Bank. It said the collusion was perpetrated by the bank's traders who coordinated their rand dollar trading activities. And it said it was going to exact the maximum penalty from every one of those banks. The same day, it furnished the banks with its referral affidavit. That referral affidavit, Justices, it is common cause, was patently inadequate. Standard Bank was, to put no finer point on it, rather surprised to receive that referral affidavit with no prior engagement with the Commission. And what it did, unlike any other bank, is within 5 days of receipt of that referral, it wrote to the Commission. It said it was dismayed by the fact that this investigation had been going for a year and a half and it had never been called to a single meeting or asked a single question. It said, please, can we meet with you? We've had 5 days, we've looked, we can see absolutely no wrongdoing, meet with us. That was on the 22nd of February 2017. On the 23rd of February 2017, the next day, the Commission refused. And Justices, that refusal would be the hallmark of the Commission's engagements with Standard Bank for the next 8 years. It would never engage with it in any meaningful way ever again. So what does Standard Bank do? Well, it takes another month and it does some more digging than it was able to do in the last 5 days. And it looks at the referral affidavit and it sees, okay, the referral tells me, Standard Bank, that I'm implicated in this international grand conspiracy because of the activities of one individual, Mr. Brownrigg. So it engages with Mr. Brownrigg, finds out the facts of Mr. Brownrigg's dealings within the bank, and it writes a month later, again, to the Commission. This is now on the 23rd of March 2017. It says it wants to engage. It hasn't yet filed an exception. It says it's going to tell the Commission what points it says are inadequate in its pleading, and it does so on the following basis. It says, Commission, Mr. Brownrigg is not a trader. He has never been authorized to trade ever. He is a salesperson. And when you have him engaged with Mr. Taylor at Barclays, he's doing stock standard salesman work. He's engaging with a customer about the prices at which Forex will be sold and bought. That is all that he is doing. The essence of that fact is to emphasize to the Commission that the relationship in the one conversation that they have between Mr. Brownrigg and Mr. Taylor is a relationship of a vertical nature, not one between rivals, and hence not of a horizontal nature. Justices, there was no response to that, again, in keeping with the Commission's dogged insistence not to engage with Standard Bank. But for many months, there are numerous further affidavits filed by the Commission as it endeavoured to better its referral. There were 4 more, and by early 2018, despite 4 further iterations of the referral case, there has been no departure from this position that Mr. Brownrigg is a trader and that he was engaged in sharing commercially sensitive information with a rival, with a competitor, albeit that the only engagement that is cited in that referral is between him and Mr. Taylor. So what does Standard Bank do? At this stage, Standard Bank really doesn't know what to do because it cannot get the Commission to hear it. So it files a review application, and in that review application, it has Mr. Brownrigg go on oath. Justices, Mr. Brownrigg went on oath in March of 2018, 7 years ago. He confirmed those facts under oath. I've never been a trader. I'm a salesperson. I've never been authorized to trade. But Justices, that was still not good enough for the Commission, because despite the fact that it was given an opportunity to redo its entire referral affidavit after the CAC's order in 2020, it stuck to its bloody-minded ignorance. It did not change its position in relation to Mr. Brownrigg. It did not take any of those facts into account, and those were facts that it could have learnt if it had engaged Standard Bank at any point post-initiation in the 1.5 years before referral and after referral in the 3 years before it was required to replead its case. Justices, it is on that basis, against that procedural history, that when Standard Bank received that 6th iteration of the referral affidavit, post the CAC 1's order in 2020, that it put in place its dismissal application. It did so because the Commission ought to have behaved like a responsible public body. It is not open to a responsible public body exercising the powers that the Commission exercises when it investigates cartel conduct to close its eyes to facts like this. And what did it do? It put these facts in its dismissal application, every one of these facts, and a few more about prejudice. Because prejudice matters also to why it was appropriate for the CAC to take these facts into account. Standard Bank didn't just tell this procedural history. It told the court that in the moments after that press release in February 2017, when the Commission went to the media before going to any of the banks, at least Standard Bank in this case could speak for itself, the bank's share price dropped 3.8% in the few days after that press announcement. And it indicated that at that time, that drop in share value equated to 8.5 billion rand. That was the prejudice to Standard Bank, because the Commission would not engage it at any point prior to the referral. It also told an account of how criminal charges of collusion had been laid against the bank's executives. And Justices, Mr. Brownrigg went on oath and spoke about his personal prejudice. He said the following, I read from page 1879 in volume 19 of the record, paragraph 9. Mr. Brownrigg said, the Commission's complaint referral has taken an enormous toll on me. A cloud of uncertainty has hung over me for more than 3 years. The fact that my integrity, an attribute which I value above all others, has been called into question has caused me considerable distress. Given the referral's prominence in the media, my family and I are often asked awkward and embarrassing questions about it. Despite the fact that I was not a foreign exchange trader and that I behaved lawfully, ethically, and professionally, we are unable to respond in a way that dispels lingering doubts and suspicions. I have undoubtedly also suffered prejudice in my professional capacity. By way of example, certain customers, some of whom I had worked with for many years, have advised that their compliance departments have enjoined them from working with me until this matter is resolved. Justices, that is what happens to institutions and people when regulators do not exercise their powers responsibly. And it was for that reason that the CAC was correct, we submit, to take these facts into account in the dismissal application. I'd like to be clear here, I don't say in all cases it would be appropriate. Fairness depends, as this court has said repeatedly, on circumstance and context. But this context, in this case, against this procedural history, meant that these facts could appropriately be taken into account. And justices, when those facts are taken into account, there is no case that Standard Bank is required to meet based on this referral. I'd like to take just 2 examples in the time I have available. It's the 2 start dates that the Commission proffers in its referral affidavit for the involvement of Standard Bank. Justices, the first occurred on the 1st of January 2008. You've heard already, that was New Year's Day. The new fact that Standard Bank added that the CAC took into account is trading desks are closed overnight on New Year's Day. It may have been possible to take judicial notice of that, but Standard Bank, for good measure, put that fact in. It also put in the fact that those quotes which are referenced in the market conduct traversed in the referral affidavit are happening on an information platform, not a trading platform, an information platform. So Standard Bank is alleged to have entered this grand conspiracy in the dead of night on New Year's Day in 2008 when no trading was taking place in South African markets. And if not then, the Commission says, with somewhat lack of confidence we say in its own case, that the next start date was almost 5 years later, on the 1st of October 2012, when this conversation between Mr. Brownrigg and Mr. Taylor took place. A conversation between a salesperson and somebody from Barclays who was inquiring from him about what price they would sell or buy rands at. That is not a conversation between competitors. It is a conversation between parties in a vertical relationship. Justices, if I had more time, I'd take you through more of the details. In our heads of argument, we've analysed every single averment made against Standard Bank and shown in our submission why they are palpably wanting. Thank you, Deputy Chief Justice. Those are our submissions. Thank you.
Questions for you? Oh, sorry.
The specific incidents, the or the allegations about what is inferred from Reuters that Mr. Gotts dealt with. Standard Bank is often mentioned there in that catalogue. Is your answer just the same as Mr. Gotts's, that you can't infer anything from the trading data?
Well, we go further than that. We say insofar as there are references to what was happening, that was not actually happening on a trading platform, that we have at best been able to infer it was happening on an information platform.
All right, so, but assuming the allegation is you're trying to affect the exchange rate by the way you quote on the Reuters platform, what do you say about all of those allegations about Standard Bank?
Yes, well, we say the following, if I could just take you to some of them, because what the Commission helpfully did was it gave us an analysis. You might recall, Justices, I'll just give you the page now, you don't have to pull it up immediately, but in the bundle that was provided the day before hearing, if you were to turn to page 12,100, there is a summary there of the market conduct of Standard Bank. And if I may, I think it's a good place to address your question, Justice Rogers.
Which page?
12,100. Justice Rogers and members of the court, there are identified by the Commission 7 instances there of alleged market conduct by Standard Bank. As it so happens, many of them are replicated, so they end up being only 3 instances. The 3 instances occurred first on the 7th of July 2008, and if I may just let you go there in the referral affidavit, you'll pick it up in volume 5 at page 429, paragraph 187. So this is one of the 3, if you take out duplications in the Commission's note that they provided for the court the day before the commencement of the hearing. It's important there to look at the allegation. It's the 7th of July 2008. This is the point Mr. Gotts made earlier, when you're looking at these times in the evening, they are times actually 2 hours later in South Africa because it's UTC time given there. So there's a period between what is effectively 8:47 in the evening and 9:28 in the evening, at which ABSA, Nedbank and Standard Bank are said to have set focal points. We make 2 points there. Happening in the evening, you know from the facts put up by Standard Bank, trading is not happening at that time, and you also know from the facts put up by Standard Bank, it's happening on an information platform. That is the most you get from this pleading. If you read it together with those facts, which we say the CAC, for the reasons I've already indicated, was entirely correct to take into account, then the most that you know is that at a point in time when trading was not taking place in South Africa, between 10 in the evening and 10 in the evening and 9 later that evening, there are indicative quotes being posted on an information platform. I can do the same, Justices, for the next averment, which is at page 433, paragraph 194. Justices, there again, we have hours at which conduct is taking place, on what we say is not the trading platform, but it has shifted into the evening hours when trading was not taking place, because 4:30 UCT is 6:30 South African time. And Justices, the next one is the next paragraph, paragraph 195. That one alleges grand conspiracy-esque conduct over 53 seconds between 9:23 in the morning and 9:24, that's next morning on the 28th of May, 2010. I can't tell you that's in the dead of night, but I can tell you that that is for 53 seconds on, if you take our facts into account, what is only an information platform. So Justice Rogers, the short, that might have been a fairly long answer, but the short answer is that these instances do not come anywhere close to satisfying even a reasonable possibility of an involvement in a grand international conspiracy.
Thank you.
Thank you, Ms. Hofmeyer.
Thank you.
Ninth respondent, Nomura International.
Thank you, Deputy Chief Justice. Justices, Nomura opposes leave to appeal in this case for the 6 reasons set out in our heads of argument from paragraph 74 onwards. The main one that I wish to stress, because I won't address any of the others, is that the case before the CAC was decided on its specialist assessment of Nomura's facts. There was no error of law. If you read the relevant paragraphs of CAC 2, it's paragraphs 100 to 108. There the court identifies the correct test for an SOC, specifically confirming its requirements and as they are set out in the HSBC case from the European Union, and then assesses the pleaded facts in the referral affidavit that mention Nomura. It finds those are, quote, skeletal and vague, and it finds that, in fact, this demonstrates the difficulty of the ambitious case that the Commission chose to bring when it chose to bring an SOC. And that choice is something that I will address later on in my submissions as well. So we say that there is simply no route for the Commission to sustain an appeal against Nomura, whether on jurisdiction or on the pleading standard. But, Justices, I wish to focus on 3 topics in the time that I have available. The facts and how they matter in this case, the consequences of framing the case as an SOC, the consequences of that deliberate choice that the Commission makes after CAC 1, that it is only pleading an SOC case. It is not pleading a case of mini cartels, bilateral cartels. It is only pleading one single overarching conspiracy. And lastly, to talk about the fairness that requires the balancing of the interests here of the Commission and respondents like Nomura because of that choice. So facts, framing, and fairness. If we can start with facts. Facts matter here for 2 reasons. Firstly, because Nomura has objected and said the referral affidavit does not comply with the Rule 15 requirement to set out the material facts on which you rely as the Commission. So the compliance with Rule 15 requirement is the first reason why we're anxious about the facts. The second is because the Commission's case is inferential. In order to support the inferences that it wants, it needs to plead the facts that can be established, that are objective, that are consistent, and that lead to the most reasonably probable inference from the facts pleaded against Nomura. So with respect to that first dimension of why facts matter, Rule 15 non-compliance here, Nomura has 4 instances pleaded against it in the referral affidavit. 3 of those predate when the Commission pleads Nomura joined the conspiracy. Not a single instance refers to the conspiracy. I must stress here that in each of the 4 instances, there are leniency recipients or banks that have settled with the Commission. ABSA, Barclays, and Citibank are in all 4 instances, they either have leniency or they've settled. They have an obligation to share information with the Commission so it can prosecute their co-conspirators. None of the facts have ever changed against Nomura since the 2017 referral that is the subject of this appeal. And the traders, Katz, Cummings, Williams and Howes, that you've heard a lot about, are in the purported instances with Nomura, yet they have not given the Commission any facts for why you should find that it is part of the conspiracy. Justices, the second important dimension to the factual debate here is that we need to draw a distinction between material facts that need to be pleaded in a referral so that you know the case you have to answer, the inferences that you want to draw from those facts, and the conclusions or arguments that you hope for from the tribunal. Because what happens in argument with respect and what has happened in the debate thus far is that there seems to be a continual conflation of, is it a fact? Is it an inference I can draw from those facts? Or is it a conclusion that I'm going to argue for in due course? We say the Commission's case against Nomura rests on inference from paragraph 63 of the referral, which is page 395 in volume 5. There it says, against all the respondents, that the existence of the SOC, its terms, and the objective must be inferred from the following facts, and then it lists in various sub-paragraphs. In the time I've got, I'm going to tick those off for you. Extensive level of communication and contact. Lengthy period over which these frequent and regular communications are happening. Continuity in the modes of communication. The existence of numerous permanent chat rooms where they discuss USD ZAR. And frequent presence in Bloomberg chat rooms. It pleads general conclusions against those respondents, and it pleads there the conclusions it wants you to draw from those. But as I will show you, it never pleads Nomura-specific facts that could satisfy Rule 15. It never pleads facts that could satisfy drawing inferences against Nomura on any of those characteristics in paragraph 63, and it pleads only the conclusions it would like you, it hopes to find when it gets to the tribunal. So on the facts that we've got, you will not see extensive, lengthy, frequent, regular, continuous contact with Nomura that deals with patterns or being comfortable or that they must have known, or this concept of reciprocity that was introduced by the Commission in argument yesterday. So I ask you to put on glasses and read the referral from Nomura's perspective. Because it reads a referral that says, there is an SOC here. And we know, because 5 banks have settled or received leniency, that there is an SOC. In the Old Gets chat room in ZAR. It's got some bad traders in there. The question is, who else is in the SOC? And when I read through my Nomura glasses, how do I as Nomura understand that I'm also in this SOC? So let's look at these 4 instances. The first is on the 27th of May 2010. It predates the date on which Nomura is said to have joined the cartel. It's in 2 paragraphs in the referral, repeated, paragraph 194 and 270.9.4. Nomura is there alleged to have done the following, quote, held the USD ZAR around the focal point of 7.5760. Does not explain what that means, but let's basically assume a focal point is the rate. It then pleads that other banks, not Nomura, other banks push the exchange rate to 7.56 and then different banks return the exchange rate to a focal point of 7.56. We don't understand that because that's the same number. So I'm at 7.5760, I go to 7.5600, and then I return it to 7.560. I've just lost the last zero. I haven't actually got to a different number. So we just don't understand this. But that movement down and back in the focal point is not said to include Nomura. They ask you to infer from that Nomura held ZAR in its accounts, collected orders to buy ZAR from its customers, simultaneously bought ZAR, strengthened it to the focal point, then offloaded the ZAR to get USD profits, coordinated that reverse process of weakening the ZAR, and gained ZAR profits. But it's pleaded no facts that can support that. These paragraphs have no named traders. So we don't know if it's the rogue traders or whether this is perfectly legitimate trading conduct. The second and third instances relate to a chat on the 2nd of March 2012, before the SOC starts. There we're told that Williams of Barclays, who is a bank that is settled or got leniency, quote, informed the traders that a customer was asking 3 people for a price and the traders should be aware of it. We don't know who the customer is, who the 3 people are, what price they're asking for, and what you should do with this awareness. Those are material facts to work out if I'm in a cartel that relates to fixing the USD ZAR. This might have absolutely nothing to do with that. We simply don't have material facts about customer 3 people price, what awareness is meant to do. That cannot be competitively sensitive information that is being shared. No information is pleaded that could be described as competitively sensitive. Same chat, same day, we then have Citibank and Barclays in the chat, and AR of JP Morgan is said to have shared information about customer quotes. Same problem, we don't know what information, what customer quotes. Was it USD ZAR? We simply don't know. So this can hardly be competitively sensitive secret information that increases transparency in the USD ZAR market. Fourth and final incident is the only one in the pleaded commencement date for Nomura. It's Mr. Dempsey of Nomura and Howes of ABSA, the leniency recipient, that are in a chat room which is not Old Gets or ZAR, nor is the previous chat that I described, and they're said to have discussed the bid-offer spread. Now, the Commission is very clear in its affidavit when it talks about agreeing and price fixing and all the rest of it. What does discussing mean? Discussing could very well be legitimate trading conduct. It could very well be a vertical inquiry about a quote. It could very well be something that is perfectly routine in this kind of market. Discussing doesn't get you material facts required for Rule 15, for inferences, or for the conclusions that you want. So what you don't see in the referral are the material facts actually mentioning the conspiracy and welcoming you into it and explaining what your job is in it. We don't see any implementation of the objective of the SOC. We don't see congratulatory assessment. We don't see punishment. We simply don't see the requirements of an SOC. But what the Commission wants you to do is essentially the logical fallacy of saying, the criminals wore black, you wear black, you're a criminal. That is not enough to get out of the starting blocks in a referral. The framing of this case as an SOC matters, because an SOC is a very particular kind of cartel case. It does not replace the requirements of Section 4. You still need an agreement between competitors involving price fixing, market division, and customer allocation. SOC comes out of Europe because they haven't codified the standard collusive practices, the big 3 that we have in Section 4.1b. So they developed single continuing infringement, as they call it, because they have an object or effect test. So you still need to look for the elements of a cartel, where parties agree to no longer compete, but instead to collude. It links to the fairness point because this is what CAC 1 means. CAC 1 is when the Commission committed itself to an SOC case. It committed itself to that theory of a case because it has advantages for a regulator. Cartels are unstable. The economics of a cartel matter here. When I engage in a collusive agreement, once I think you're going to stick to a particular price, my economic incentive is to cheat. So a cartel is only stable and effective if it's monitorable and if there are punishing mechanisms. That is the economics of cartels. So the SOC theory was developed because there is this instability in cartels. People drop out, they come back. There's instability, there's cheating, we all get together and say, come on guys, it's better if we just collude, let's reestablish our cartel. And so it's an enforcement tool to say, for this entire period, I'm going to tolerate that volatility in the cartel and excuse the fact that I don't know that you're talking to everybody or that you're involved in every part of the cartel. If the Commission is going to get that advantage, then it has to fulfill the obligations of an SOC theory of a case. It has to show awareness, knowledge, commitment to that objective, implementation or participation, playing my part, that I can reasonably foresee that this is what's happening and I take the risk to do that. And here we don't see that. Against Nomura, and this is my final submission in the time I have available, the EGB case plays a big role. But I beg the justices to read that case. You will need to lie down in a dark room after you've done it, because it is very dense and long. But what that commission did was analyzed the chats and showed how they refer to the SOC elements. And you see implementation. And you see trading data that backs up that there was a cartel. Here we simply don't have that.
Thank you, Ms. Leroux. Thank you very much. I'm going to check if there are any colleagues who've got questions.
Is it Ms. Leroux? I don't want to call you Ms. Butler, and I was just not sure.
No, definitely
so I had
not
to check
Butler.
that. Yes. Thank you. On the application for leave to appeal,
yes,
when you are addressing that, you said that there are other bases on which you say that they don't have, we should not grant the application for leave to appeal. But then you referred to one, and you said that the case in the CAC was decided on the basis of its specialized knowledge. Now, my question is, does this court in certain instances entertain cases from the CAC, from the LAC, and the tax court, and whether this is not one of the exceptions, specifically because it concerns the interpretation of the Act?
Justice, absolutely. My submission was that it was the CAC's specialist assessment of the facts, which is why we say leave to appeal should not be granted. So it's the debate that has already happened today about how if you look at what the CAC did when it looked at my client's pleaded facts from the Commission, it found that those facts didn't satisfy the requirements for an SOC. So paragraphs 100 to 108 of the CAC decision in CAC 2 are where it deals with what was pleaded against my client, the 4 instances I've taken you through. It correctly identifies the test for an SOC from the HSBC case in Europe, and it says, based on that, the pleadings are skeletal and vague, and Nomura cannot therefore be expected to understand how it can be in an SOC, satisfying all of the elements of an SOC. So we say because the test was correctly identified and correctly applied because it was assessing the referral affidavit against my client, that's our first reason why we say leave to appeal should be denied. But of course the court entertains appeals in competition law. I'm not saying it can't. I was just saying it was...
Well, I misunderstood you. I thought you were saying we can't.
No.
Now you're saying that it is correct. The way in which the CAC did it was correct.
Yes.
And that because of that we should not grant leave to appeal.
Indeed.
The second matter is that 3 other banks implicated together with Nomura have got some form of an agreement, settlement agreement and leniency agreement with the competition authorities. Now I don't know if I understand you correctly, because I got the impression that you're saying that because there was that kind of agreement, Nomura expected that the commission would supplement or add to the information or to the allegations, and that there was nothing forthcoming, and therefore we should speculate that there was no other information. Is that your submission?
Let me try to make it clearer. The submission was this. 4 instances are pleaded against Nomura. In every single one of those instances, there's either an ABSA person, a Barclays person, or a Citibank person. Those banks all have obligations to assist the Commission to prosecute all the banks that haven't got leniency and haven't settled, which includes Nomura. The submission was, if they in fact had evidence of conduct by Nomura, the Commission should have pleaded that information received from those banks that had to give it to them. The fact that all they've been able to do is put Nomura trading on the Reuters platform before banks that include guilty banks start moving focal points around. But they don't plead Nomura as part of moving the focal point around. We say, if it had been part of that, you would have expected them to say that, because they had access to banks that should have given that information to the Commission. On the 2 chats that are pleaded, in both of those chats are traders from the banks that have pleaded guilty. If they could implicate Nomura in the SOC, you would have expected them to see that. Instead, we have in the one instance these broad allegations, 3 customers are looking for quotes. We don't even know if that's USD ZAR. We know nothing. The second part of that day was that customer quote information was shared, but we don't know what. And if it was shared with Nomura, we don't know. And then the second...
You're saying that we should conclude or infer from that there's no other information that the Commission has.
We say that they have an obligation under Rule 15 to plead it if they have it. Therefore, if it's not there, they haven't complied with Rule 15 by setting out material facts, and they haven't set out the right kind of facts to support an inference. So when you're assessing the pleadings as the CAC did, you should reach the conclusion that they don't have any better information to implicate Nomura and satisfy the SOC requirements. And therefore, the case was correctly dismissed against Nomura by the CAC.
Okay, thanks.
Thanks, Ms. Leroux. I note your concern with regard to the paucity, what you say, of the connecting factors. But as I read the referral affidavit, the reference to Nomura, by implication, suggests that the 2 individuals that are mentioned as representing Nomura would have been involved in those transactions. So even where there's a reference, for example, in the referral to Nomura, I read it to mean that it would have been one of those 2 individuals or both of them. Do you see that way as well? Not that that takes care of, not that that resolves my difficulty, but I just want to get your understanding of that.
Justice Collinson, let me say 2 things in response. The first is that, yes, I accept that the Commission, at the start of the referral affidavit, says these are all the traders involved for these different banks. And I accept that they name 2 traders for Nomura. They don't appear in all of the instances. It's only 1 in each of them. But the submission on the trading data from the Reuters trading platform was that we don't know if the rogue traders, if I can call it that, for the guilty banks, we don't know if those were the traders trading at the same time, and we don't know if these were those Nomura traders. You would think from the trading information and from talking to leniency and settled banks, they could have gotten that information. We merely make the point that you don't see Nomura engaged in the SOC part of that trading conduct. So when there actually is trading conduct needed, which is only that first instance, you don't see who's doing the trading, and you don't see Nomura in the actual fiddling with the focal point, which is the gist of the allegation.
Sure, but if it upfront says these are the two traders trading on behalf of Nomura, surely that would be sufficient, at least from Nomura's perspective, to provide it with sufficient particularity to respond.
Well,
because it wouldn't have to trawl through thousands of traders. There are two possible persons.
So we could accept that it might be the two named traders. What we can't do is understand how it can be part of an SOC where it is not doing the dodgy trading. It is not doing the focal point moving that is then pleaded.
That's a different issue.
Yes.
So, good. Then secondly, in Strang, the court, in dealing with the unconstitutionality of an arrest to found jurisdiction, dealt with the question of personal jurisdiction and dealt with the position of Peregrini and took the view, which may not be applicable here, but the Commission argues that the CAC had got the test wrong. In Strang, it said if there was service on the defendant in South Africa, then all you needed to prove was a sufficient connection between the suit and the country, correct? Whereas in CAC 2, the court seemed to suggest a different test, and that was a clear evidence of linkages to South African banks. Are those positions contradictory, or is Strang distinguishable in the sense that it predicated its test on a requirement for service?
Justice Colopin, let me answer your question by setting out my understanding of what the jurisdiction argument is in front of this court and where the debate has gotten to on these issues. So as I understand the Commission's new 3-1 argument, it's saying you replace personal jurisdiction, and that would be the Strang part, service, attachment, that whole debate. But they still say, because I took careful notes and I watched the recording again, they still say that in addition to economic activity or effect within the Republic, you still need to have connection to the suit. There still needs to be this effectiveness connection to the forum in South Africa of the Competition Tribunal. Now, what does that actually mean here? Because the suit here is a Section 4.1b violation through an SOC. So it feels as if this argument traverses a lot of ground but gets back to still needing to establish whether you call it adequate connecting factors under CAC 1 or whether you call it the Commission's 3-1 test, whether it's straight 3-1 or 3-1 plus, where I have to show a connection to the, between the suit and the forum, and the suit is the SOC that you're alleged to be in. I still have to plead some facts against Nomura that puts you in an SOC. So it feels as if it gets us back to exactly the same problem. It may just be a question of packaging. Whether you package it as adequate connecting factors under CAC 1, whether you package it in Strang language, or whether you package it as economic activity within or having an effect within that connects the suit, the 4.1b cartel case, to South Africa. I still need to plead something against Nomura that puts it into an SOC. So then you're into this, the fact that the SOC sits on top of Section 4. It has to be an agreement between competitors that engages price fixing or market division. It has to be this awareness, knowledge, commitment to implementation of the anti-competitive objective. Alternatively, that I reasonably foresee that and take the risk. So it still requires them to plead how I am in the conspiracy with the banks. My reading
You're suggesting that ultimately, in real terms, there's no difference between those two standards in terms of from a pleading perspective.
What the pleading would have to contain. Because otherwise, if it's good enough for it to be the czar, then it's the czar in the air. It's every one of us who touches rands. It's not, but that's not the case. The case is the collusion on USD czar in a given period of time by certain banks. So it can't be the czar in the air. It has to be the cartel case, specifically an SOC cartel.
But it need not show a direct link between Peregrini and a named South African bank, for example.
No, so my reading of CAC 2 and this debate of the link to South African banks, paragraph 85, our submission is that in fact, let me just get there. I think there's a reading of it that is consistent with what I've just said, because it's that final sentence of paragraph 85. So to sustain an argument that there was sufficient connecting factors, the need is to provide clear evidence of linkages to the South African banks as part of the overall conspiracy. That doesn't mean I have to connect you to each insular. I'm still connecting you to the conspiracy, and through the conspiracy to the South African banks. Now, for my client, because it is alleged to have spoken to ABSA, that requirement doesn't come up. But I don't necessarily read paragraph 85 as requiring contact with a South African bank. I can have foreign-to-foreign contact in an overarching conspiracy that includes South African banks.
Thank you.
But my sense of where this debate has gotten to, and where the Commission still accepts that effectiveness requires a connection to the suit. The suit is a cartel that's said to be an SOC.
Sure. I understood that was the sort of fallback position of the Commission, not so. Their primary position was that if you get past 3-1, then that's it. But anyway. Yeah.
When my learned friend for the Commission argued about economic activity in effect, he still talked about the conduct. And the conduct is cartel conduct. So when he talked about those two concepts, they were not purged of cartel conduct. He still talked about economic activity being the fixing of the sovereign currency. The effect being the fixing of the sovereign currency. It wasn't in the air.
Sure.
So even on their 3-1 argument, as I understand it in its purest form, it still requires a cartel case in order to establish that connection.
Good. Thank you.
Thank you, Ms. Leroux.
Thank you, Justices.
The plan is to listen to Mr. Bana for the 12th respondent, and thereafter to take a 15-minute break, and then to continue with the remaining respondents. Mr. Bana.
Thank you, Deputy Chief Justice and Justices. I appear for Commerzbank with Ms. Williams. The court would have obviously gathered by now that not all respondents fall into the same pot, and there are a group of respondents who say there are no allegations of participation by us in the SOC, and the Commission has failed to set out anything in the pleadings which properly shows that we, as a participating bank, participated in the SOC. In relation to Commerzbank, the issues are very narrow. We raise no issues in relation to subject matter jurisdiction or other jurisdiction. We do raise the issue of engagement by this court of its jurisdiction to hear the leave to appeal, but that's a different matter. We don't take the jurisdiction points that most of the other respondents do. So we, in the time available to us without departing from any position taken in the heads, plan to address two topics, and that is firstly whether the CAC was correct, that there was no evidence in the referral affidavit to show Commerzbank was a participant in the SOC, and then whether this court should entertain the appeal on the basis that there's no constitutional issue and no arguable point of law of general public importance that is set up. Hearing the Commission's address yesterday, the court would be forgiven for thinking that the argument sounded good as it related to Commerzbank. And the reason for this is there were broad sweep allegations that you were not taken to the pleadings, There was a complete gloss over the facts as they pertained to Commerzbank. So our learned friend, Mr. Nkaitobi, said the CAC misdirected itself when it found that vis-a-vis Unibank, the focal point was unilateral. We'll show you that this is the very point that the Commission pleaded. He then said that Commerzbank was a leader in initiation. There is no basis for that in the pleadings. You were then told that matching was coordinated conduct, which as a sweeping statement is simply incorrect, because when banks deal with each other, they match prices, and when they look at prices on Reuters, they match prices. That's ordinary market dealing. We were then also told that the matching of a price with RMB was collusive conduct. And I will take you very briefly to the pertinent paragraphs for you to appreciate immediately that all of these submissions went way beyond the pleadings and have no foundation in the actual pleadings. What we heard from Ms. Hobden was even more troubling, where glib statements were made which are not supported at all on the pleadings. In essence, there was evidence given from the bar, and so, for example, you were told Commerzbank knew 4 out of the 5 types of conduct. We don't read that anywhere in the pleadings. You were also told that Commerzbank knows what the other banks were doing. We don't read that anywhere in the pleadings. And when you look at the meager allegations set out against Commerzbank, you will, we submit, agree that the Competition Appeal Court was absolutely correct in saying that the Commission had done a terrible job of trying to show that my client, our client, were part of the SOC. Justices, this morning we delivered a table of about 3 pages simply to summarize the pleadings. We're not sure if you have access to that. I'm told it's in the authorities bundle starting at 12107, and we do have hard copies here if anyone of the justices requires a hard copy. Can I take it that you have the table before you? What you will see, and what we've done, is in the first column we've summarized the requirements to plead an SOC as summarized in the CAC judgment, and I can tell you that that summary came from what was submitted by the Commission's counsel, so essentially it records the Commission's position, and that is a correct position in law. The second column sets out the requirements to plead an SOC as per the Commission's heads, and we also submit that is a correct statement of the law. The third column sets out what the Commission's pleadings, the referral affidavit, does in relation to each of these requirements. And what we do in the fourth column is to ask the question whether the requirements in respect of Commerzbank, as set out in column 1, the CAC decision, and column 2, the CC's heads, has been met. And you would have read this several times, but it's worth perhaps just restating for the purposes of giving context to the argument. The requirements which are largely common cause and which come from decisions such as Teams relocation and the other decisions such as ANIC, which is referred to by the Competition Appeal Court, can be summarized as follows. There is a need to show a common anti-competitive objective, being the existence of an overall plan pursuing a common economic objective. Call that the overall common plan. Secondly, the participation of each firm being an intentional contribution by its own conduct to the common objective pursued by all the participants. Call that the intentional involvement contribution. And thirdly, knowledge being what the firm was either aware of as actual knowledge or ought reasonably to have been aware of. Call that the knowledge requirement. And that is repeated at several places in the CAC's decision. It's repeated in the Commission's heads, and it goes back also to the Eurobonds decision, which we've referred to in the column as the EGB decision. When you look at column 3, you then analyze what is set out by the Commission against those requirements, and I won't paraphrase, I won't read out 56 and 57, except to say that in 56 they tell you when the SOC endured. They say from September 2007 until at least 2013. In 57 they tell you what the participants pursued. And then you get to the specific allegations in the third column of participation by Commerzbank. And there are 4 instances, and I'll take you to them. One consists of a focal point. One consists of a single discussion over this more than 6-year period in a chat room. And the other 2 consists of dealings on Reuters. And we say when you look at those allegations, as we point out in the last column, none of the common cause requirements to establish an SOC are established in relation to our client, Commerzbank. In particular, the minimal conduct of Commerzbank does not fit the general allegations made in regard of frequency of participation as required by the Eurobonds decision. Our learned friend, Ms. Leroux, suggested you read that case at your leisure, and when you do, you will see it's actually against the Commission rather than for it, because in that matter, there was extensive discussion, although in one chat room, there were hundreds and hundreds of chats of the implicated banks over long periods of time. We say furthermore that against the allegations in the Commission's referral affidavit in regard to frequent and regular communication and extensive levels of communication as required by Eurobank, none of those requirements are met. If I can then, as I see the time is going by very quickly, take you to the allegations in the affidavits, and you'll see the general requirements. I'm not going to deal with them right now. You'll have regard to paragraph 60, which deals with the requirement that the participation must be frequent and regular. It's in the record at 393. You will have regard to paragraph 63, which deals with the inference of a single overarching conspiracy, the SOC, and what is required, the Commission pleads correctly, is extensive communication over lengthy periods of time with frequent and regular communication. Now, keep that in mind and turn to paragraph 185.4 at page 429 of the pleadings. And this is what the Commission defines a focal point as. Remembering for the moment that a focal point is not a standard term, it's a term the Commission creates, but on its own created term, this is what it says. Where banks coordinate in putting up bid and ask prices in order to generate identical average spot exchange rates or create focal points of spot exchange rates. So on their definition, for a focal point you require coordination. It can never be unilateral, and it's to generate average spot prices. So when one gets to the actual allegations against Commerzbank, it is with surprise that one reads in paragraph 231 at page 439, and this is one of the aspects our learned friends for the Commission said the CAC got wrong. But at 231, they tell you, on 29 March 2012, between certain hours and on Reuters trading platform, a focal point was initiated by Commerzbank. And the point will be immediately apparent that for a focal point you need coordination. They don't suggest there was coordination with anyone. The act is a unilateral act if one can indeed have a focal point in their definition. And all that happens if there is no coordination is that there's a bid and ask price put up by the bank. So clearly the so-called focal point which you were told about cannot be sustained against our client. That's a unilateral act. You then get to the two instances of matching, and the first is at paragraph 233, where you're told on 20 September and on Reuters trading platform, a number of foreign banks did a number of things. I'm not going to spend time going through that, but essentially what you told ends up happening is that Commerzbank posts different bid and ask prices, and they give you the price, and nonetheless result in Commerzbank matching the rating of Investec. Now, if you do the maths, the average between the bid and ask price, the average comes to 8.3277, and there's nothing peculiar about that, firstly. Secondly, the point is that when traders trade, they try to match prices, and there's nothing sinister or peculiar or essentially anti-competitive about that. You get the next instance at paragraph 234, where you're told that RMB paid its bid and ask prices with a number of banks, and you get a whole lot of instances, and when you look at that, you'll see all of those prices resulted in different prices throughout the day. Again, we say there's no suggestion that Commerzbank acted anti-competitively. Firstly, the pairing is said to be done by RMB, but even then one understands when traders trade, they match prices, and there would be a pairing of prices, and the pairings show several different prices across the day. Lastly, to deal with the instance of the chat, the one single chat over this 6-year conspiracy in which our clients are mentioned, and that's at 251 at page 444, para 251, 444. On 28 July 2010, Katz and Darzi were participants in an implicated chat room in which Darzi shared information with Katz about a potential customer in the market. Now, the Commission clearly has the chat. What they don't tell you is what was discussed. They don't say whether it was commercially sensitive, and they don't say why the sharing of that information would be an infringement or would be anti-competitive. So the instances against Commerzbank are meager in the extreme. They demonstrate absolutely nothing in relation to the Commission meeting the requirements which we've taken you to, and we say on that basis the Competition Appeal Court was absolutely correct in finding that there was no case made out. On the issue of leave to appeal, we wish to make a few points quickly. Firstly, that this court should approach the topic of arguable points with circumspection. You'll have regard to Paulson versus Slipknot, and also that not every arguable point of law meets the threshold. More importantly, you'll have regard to the case of the GCP versus Jibba, where it was held that divergence of views do not flow from differences in law, but stem from a different evaluation of facts, do not constitute arguable points of law. So decisions, even if one contends they made on wrong facts, cannot ever meet the test. Lastly, we say that the Commission tries to bring in this test of plausible evidence by suggesting that the CAC applied a different standard, but if you look at the judgment as a whole, the CAC applied the ordinary laws on exception, and where it used the term plausible evidence, all it was doing in context was saying there isn't sufficient evidence. Thank you, Justices.
Thank you, Mr. Panna. We will take the adjournment now, 15 minutes, and we'll come back. Court adjourns. to be argued is that of the 13th respondent, Macquarie Bank Limited. Mr. Wilson.
Deputy Judge President, members of the court, let's wait for papers to be arranged. Deputy Judge President, I represent Macquarie Bank Limited, the 13th respondent. You will have seen that Macquarie is a pure peregrinus. It is an Australian registered bank with its principal place in Sydney. It has no operations in South Africa. The appeal court, the Competition Appeal Court, upheld Macquarie's appeal against the Tribunal's 2023 order on the grounds that the Commission had not pleaded material facts that sufficiently linked the alleged conduct of Macquarie to the SOC that the Commission was required to plead, and you will see the CAC's reasoning at paragraphs 119 to 123 of the record, that's pages 274 to 275. Without detracting from the various arguments raised in the written heads of argument on behalf of Macquarie Bank, given the time and given what has been said by my colleagues on behalf of the respondents, I intend to focus my submissions on only one issue, which is the basis upon which the appeal court upheld Macquarie Bank's appeal, namely that the complaint referral does not disclose material facts from which it can be inferred that that Macquarie Bank was a party to the SOC that the Commission alleges in its complaint referral. We will submit that that is a mundane inquiry because it is purely fact-based. But it is an important one because in circumstances where the pleadings do not disclose that nexus between the alleged conduct of Macquarie and the SOC, well then it is common cause that it is not part of the SOC, and that in itself is fatal to the complaint referral. A further consequence, of course, is that there would be no jurisdiction because the jurisdiction arguments of the Commission, both personal and subject matter, are premised on the notion that Macquarie Bank is party to the SOC and is therefore liable on a sufficient factors basis and also on an effects basis for the conduct and sequelae of the SOC. Now, we will submit that inquiry is not appealable. The Competition Appeal Court's conclusions on that arise from the application of a common cause legal test to the facts of this particular case, and whether or not the Commission or any other party would wish to disagree with the application of the test to those facts is not a matter which is either constitutional in nature or raises any arguable points of general public importance. The court will recall that there are three categories of conduct on the basis of which it alleges that an SOC can be inferred in this case. First is the conduct implementing the agreement. There's a section on that. The second is what the Commission refers to as the effects of the conduct, and that includes trading behavior. And the third category of conduct is history of collusive practices. Now, in relation to the second and the third, there is no reference to Macquarie Bank whatsoever. There are no trades alleged on the part of Macquarie Bank. There is no reference whatsoever to Macquarie Bank under the effects section of the complaint referral. There is likewise no reference whatsoever to Macquarie Bank in the history of collusive practices. It has not been implicated in any of the other proceedings that have been relied on by the Commission. In relation to the first category, which is conduct implementing the agreement, in the many, many pages that are set out in the complaint referral, there is but one paragraph in the entire complaint referral which refers to Macquarie Bank, and that is paragraph 116, and that is at page 415 of the complaint referral. The entire case of the Commission, in other words, rests on the inferences that can be drawn from that one paragraph within the complaint referral. May I briefly read what that paragraph 116 says? On the 11th of September 2013, Chia, Kuneni, Murray, Atkins, Harkins, Donnelly, Friday, Barner, and Naidu were participants in an implicated chat room in which Chia and Kuneni discussed bid-offer spread for USD ZAR. Murray shared competitively sensitive information. Full stop. That is it. Can I point out some signal features of this paragraph? The date is the 11th of September. That is 5 months after any other conduct of any other party alleged in these proceedings. In other words, the campaign period that has been specified by the Commission in this matter has been extended to September 2013 to capture this particular instance of conduct. There is no other specified conduct of any other respondents that is alleged to be taking place at this particular time. The second feature of this paragraph is there is only one other bank which is implicated in this chat, and that is Absa Bank. You will see that of the participants that I mentioned, they are all Macquarie Bank participants, except for Kuneni, who is said to be a representative of Absa Bank. There is also reference to Barner and Naidu. They are not attributed to any bank in these proceedings. I should say that in previous versions of this complaint referral, they were alleged to represent Absa Bank. Make of that as the court will. But they are, at best for the Commission, there is only one other bank that is party to this single chat on this single day. I should also add that none of these participants are implicated in any other conduct. We have heard that Absa was alleged to participate in various other conduct in the complaint referral. None of that conduct involved Kuneni, or to the extent that you wish to read Barner and Naidu into the fold, is there any reference to those parties whatsoever. So none of these participants, either for Macquarie Bank or for Absa Bank, are implicated in any other conduct in these proceedings. And a final significant feature of this paragraph is that it does not refer to the ZAR chat room or to the old GITS chat room. It refers simply to an implicated chat room, which the court will recall is defined in a relatively circular way in paragraph 88 of the complaint referral as a chat room that was used as the primary mode of communication to implement the terms of the conspiracy and to further the objective of the conspiracy. Of course, that is simply a conclusion. There are no material facts whatsoever in the complaint referral to substantiate that particular conclusion in relation to that chat room. What we do know is that it was not the ZAR chat room or the old GETS chat room, which are said to be the central modes of communication of the SIC that is alleged in this particular matter. Other respondents in these proceedings have taken you through the requirements for pleading an SOC. Those must be viewed through the prism of Section 4.1b of the Act, in particular whether it can be said there was an agreement or a concerted practice as defined in the Act between the Macquarie Bank Limited and the other alleged participants in the SOC. And we know it is common cause the requirements that the European law has written into the notion of an agreement or a concerted practice in this context. Namely, there must be an overall plan pursuing a common objective, an intentional contribution of the firm in question, in this case Macquarie, to that plan, and Macquarie's awareness, either proved or presumed, of the offending conduct. The question that this court will consider is whether the CAC was wrong in concluding that there is no plausible basis upon which that paragraph 116 that I have read out to you, given its features that I have elucidated, could ever achieve any one of those three requirements of the Act. How, we would submit, can it plausibly be inferred from one chat with one party on one day at the very end of the specified period discloses any participation by Macquarie Bank in any kind of overall plan to pursue a common objective with any party other than, at best, for the Commission, Absa Bank, which would be a bilateral cartel. It would not be the SOC that the Commission was required to plead. Likewise, and it follows from that, there is no basis whatsoever from that particular paragraph that one could plausibly infer that Macquarie Bank intended to contribute to the broader SOC, or that it was aware of the conduct of the other parties in that SOC, or should be assumed to have been reasonably aware of that particular conduct. And on that basis alone, we would submit that the case against Macquarie Bank Limited must fail. There is simply no plausible inference that can be drawn from that paragraph that it meets the three requirements of an SOC that I should emphasize are common cause in these proceedings. The very same cases that were relied on by the CAC in its decisions are the same cases that the Commission has relied on and that the respondents rely on. There is no dispute as to what the requirements of an SOC are in these particular proceedings. The Competition Commission in its oral argument makes 2 points to try and overcome this difficulty that it faces. The first is to point out that ABSA, which is the counterparty, was a leniency applicant. The second is to rely on the European government bonds case to say there are sufficient similarities between the paragraph 116 conduct and the other conduct to allow an inference to be drawn that they are part of the same conspiracy. As regards the first point, ABSA, in our submission, the fact that ABSA was a counterparty counts against the Commission, not for it. One cannot assume and infer from the fact that ABSA is a leniency applicant that the conduct alleged in paragraph 116 was part of a broader SOC. There is no basis, in other words, to assume that the leniency application that was made by ABSA related to an SOC and not simply to bilateral cartel conduct. When you make a leniency application, that the leniency application of ABSA either involved conduct of Kuneni as opposed to Mr. Howes, or that it involved any kind of allegation of an SOC. Indeed, as the appeal court pointed out, one would have expected if this conduct of Macquarie Bank Limited was indeed alleged to be part of an SOC, then material facts would have been pleaded in that regard, given that ABSA, the counterparty to the conduct, was the leniency applicant. And the fact that the Commission simply has to rely on an inference from one chat with one counterparty being itself in order to get to a conclusion that it participated in a broader SOC indicates that there is nothing in the cupboard insofar as the ABSA leniency application is concerned. Secondly, in relation to the EC bonds case, I repeat what my learned friends have indicated, is that the facts in that case were very, very different to the facts in this particular case. When you read through the EC bonds case and the UBS appeal case of the General Court, you will find that in those circumstances it is true that the conduct of Bank of America in the Cods and Chips chat room was found to be part of a broader conspiracy, which was also carried out in another chat room. But in those circumstances, those two chat rooms were in place for a number of years. There were hundreds and hundreds of chats that were intertwined between those two chat rooms, between all the main players in the alleged conspiracy. In other words, there was a complete confluence of communication between the chat participants, between those particular chat rooms. There were 380 chats over the course of the period, with a stable group of all the core alleged participants in the SOC, and it was happening all over the same time period in relation to conduct that was wholly intertwined. None of those factors feature here, and therefore, with respect, the reliance of the Commission on those cases to ask you to draw an inference of participation in the SOC cannot flow. And finally, let me just say, in relation to the question of appealability, the only question that is the focus of my submission today, being the connection between conduct and the SOC, is not one which raises any questions of law. It relates to the application of common cause legal principles to the facts in question. And on that basis, that is not a matter that engages the jurisdiction of this court. And for that reason, too, we would submit with respect that the appeal as against the findings in relation to Macquarie Bank Limited should be dismissed, as the court pleases.
Thank you very much, Mr. Wilson. Do you mind if I ask you just to take your seat? Justice Rogers would like to ask Advocate Bana a question.
Mr. Barner, I'm sorry about that. I was struggling to find in my notes which respondent had raised this point. I think in your written submissions, you're the only respondent to refer to Section 62 of the Competition Act and to say that it renders the decision of the Competition Appeal Court not only an exclusive but final arbiter. Insofar as a matter raises an arguable point of law of general public importance or a constitutional matter, do you accept that the Competition Appeal Court is not final in that sense?
Perhaps we should reconcile it in this way. The decision is final unless the Constitutional Court invokes 167(3)(b)(3), where it grants leave. So in those
test is still the same. Yeah. Does it engage our jurisdiction, and if so, are there prospects?
Indeed.
So in a sense, it doesn't affect our analysis, does it?
No, it doesn't. All that we say is until you give leave and until the jurisdiction is engaged by virtue of that section, there is no jurisdiction, and the jurisdiction is final.
Yes,
it comes to the same point.
That's just what I wanted to clarify. Thank you.
Thank you.
Thank you very much. Advocate Wilson.
Deputy Judge President.
Yeah. No questions.
Chief Justice.
Just one question, Mr. Wilson. Is it your submission that the more frequent the interaction is between the sort of co-conspirators, the more likely one would find the existence of an SOC? But as the frequency decreases, the possibility of drawing that conclusion diminishes. But can one say that a single interaction with another conspirator would be dispositive of a conclusion that that party wasn't part of an SOC, if under those circumstances that particular conspirator may have had other contacts with others? And so you could sort of find conspirators at the top end and those at the bottom end.
Justice Collett.
I just asked that as a matter of principle, not necessarily in relation to your client, but you would place them at the bottom end in any case.
Yes, Justice Collett, it is an important question because the Commission raises the argument to say it is an error of law that because you don't have frequency, you cannot participate in an SOC. That is not what we understand the appeal court to have said, and that is certainly not my client's position. As a matter of principle, it is conceivably possible that one chat may give rise to an inference of participation in an SOC, but there would have to be pretty exceptional circumstances because, of course, the inference has to be drawn from all of the relevant facts and circumstances. The more the frequency of the chats, the easier it is to make that particular inference. In circumstances where there is a single chat, there would have to be very exceptional other factors which would allow that inference to be made. So I don't argue in this case that because it was one chat, as a matter of law, it cannot give rise to an SOC. What we do submit is that fact, together with all the other facts I've indicated, mean there is no basis for the inference to be drawn.
Follow on that. The Commission also contends that this argument about frequency and the level of involvement bears more on the eventual question, if you do eventually get there at the trial, what your quantum of liability of the infringement. So So what the Commission argues is that, and they contend that the EC decision holds the same, the EG bonds decision holds the same. But it matters not that you have participated only once and at a lower level, provided that the allegations are sufficient to, if it's proved at trial, attribute knowledge or foreseeability of knowledge of what was going on in that chat room. Once your people are in the chat room, chatting to an Inkula, and it's more or less the same broadly as the SOC, they say it's adequate. What do you say about that submission?
Justice, it is correct that if you read in particular the EG Bonds case and the UBS General Court appeal, what both of those bodies indicate is that the first requirement, in other words, the overall plan to pursue a common objective, is what they refer to as an objective inquiry. And you take into account numerous factors, frequency, the number of the participants, the number of the trades, all relevant factors, and an inference can be drawn from all of those factors to effectively pull a particular respondent's conduct into the SOC. Once that requirement is established, there is then what those two bodies refer to as the attribution question, which involves more subjective factors as to did you intend to contribute to this plan, and were you aware or should you have been aware of the conduct of the other respondents. But it doesn't follow in our submission that the Commission in this case only needs to satisfy this court on the first of those requirements. It has been common cause throughout these proceedings and remains, as we understand it, the law, that in order to attribute liability to a particular respondent, all three of those particular requirements are met. In other words, the Commission doesn't satisfy the tests of pleading simply by establishing an overall plan. It needs to establish the overall plan plus the intentional contribution plus the firm's awareness. But the other point I would make on that is even in relation to the overall plan requirement, that is one which, it is true, can be inferred from various objective factors. But the point that I was wishing to stress in my address, and I think other respondents have as well, is that the facts on the basis of which that inference was made in those cases are a million miles away from the facts in this particular case. So even if this court were to conclude it is sufficient for purposes of pleading to establish the existence of an overall plan pursuing a common objective, you still need to be satisfied as a process of inference that the respondent's conduct was part of that overall plan, because otherwise you haven't satisfied in Competition Act speak in South Africa that the respondent was part of the agreement or the concerted practice. So the Commission still needs to satisfy you through that inferential test that you can plausibly conclude that each of these respondents was part of that broader SOC, and for the reasons I've indicated, we submit that's not satisfied either.
Just lastly, correct me, I'm getting confused with all these respondents, but are you one of the, or did you raise the de minimis argument? And I seem to think that Nomura did, but not you.
Well, a de minimis argument was raised against us by the tribunal. The tribunal, and it might have applied to other respondents, I don't know, but the tribunal dealt with our objection to the complaint referral on the basis that a de minimis objection is one which simply goes to the extent of the penalty. It doesn't go to the principle of whether you should be implicated in the conduct or not. And in answer to the question from Justice Collipin, it's important to emphasize that ours is not a de minimis issue. Ours is an argument which is because there was only one instance and because of all the other facts that I've indicated, you can't infer that we're in the SOC to begin with. We would accept as a matter of principle that if you could infer from that single instance that we were in the SOC, the mere fact that it was only one instance would by definition, not go to whether we were in the SOC, but simply go to a quantum of liability. And that's why it's important for us to stress that ours is not a de minimis argument. It is one which is to say that one instance only in very exceptional circumstances could found the inference, and those exceptional circumstances don't apply here.
And basically, to sum up, what you are saying is that if the Commission had pleaded bilateral conspiracies or mini conspiracies, number of them would have been a different matter.
Yes, and we would have accepted that they have, if you were to accept that the conduct alleged in paragraph 116 was sufficient to plead prohibited conduct, that then potentially they would have satisfied the requirements for the pleading of a 4.1b, but that would have been a bilateral cartel, not the SOC that they were required to plead.
Thank you very much, Mr. Wilson. That will be it for you. 19th respondent, HSBC Bank USA, Advocate Cockrell.
Thank you, Deputy Chief Justice. Deputy Chief Justice, as you'll know, I act for two appellants/respondents in this matter. The one is an American entity, HBUS, as we refer to it, and the other is a European entity, HBU. My present argument purely relates to HBUS because it is the respondent in the matter. It was kept in by the Competition Appeal Court, and we say with respect that that decision was correct. I'm going to indicate why, and in my time, what I'd like to do is I'd like to develop three arguments, if I may. I'd like to begin by dealing with the Commission's argument regarding jurisdiction. And I'm going to label the Commission's argument regarding jurisdiction as a slash-and-burn approach. And I don't mean that in a pejorative way, but I'm going to submit in due course that it's a slash-and-burn approach because they say you can consign to the scrap heap of history all of the law relating to jurisdiction over the person and most of the law relating to jurisdiction over the conduct. I'll develop that argument in due course. And then if time permits, I'm going to develop two other arguments. The one is that in terms of the conventional or the orthodox approach, jurisdiction over the person was established, and the third submission will be that on the orthodox approach, i.e. the approach not advocated by the Competition Commission, jurisdiction over the conduct was also established. And hopefully I'm going to do all of that in 15 minutes, although it is going to be a bit of a stretch. May I start then with the Commission slash-and-burn approach to jurisdiction? The Commission slash-and-burn approach has two implications. Number one, they say there's no need to establish jurisdiction over the person, at least not in competition matters. And number two, they say that when it comes to establishing jurisdiction over the conduct, the qualified effects test is not part of our law. Now, both elements of those go into the slash-and-burn approach, and I'm going to deal with them in turn, if I may. Let me start with the Commission slash-and-burn approach to jurisdiction over the person. The first argument, which I don't have time to develop, is simply this. It's an argument that is not available to the Competition Commission because that argument is barred by the doctrine of res judicata, or otherwise the Commission preempted its appeal. Deputy Chief Justice, I've listened closely to the debate between Advocate Rogers and other speakers today. I don't have time to deal with that debate, but for our purposes, it doesn't matter much whether you say it's res judicata or whether you say that the Commission has preempted its appeal. I don't have time to go into the difference between those two approaches, but it doesn't matter from our perspective. On either approach, the slash-and-burn approach, which says that the Commission doesn't have to establish jurisdiction over conduct, is not open to the Competition Commission on either of those arguments in our submission. And may I make an important point at this stage, because I may forget it later. I've also listened to the debate regarding whether there are exceptions to the doctrine of res judicata. But res judicata, of course, is a fundamental feature of the rule of law. So it's not something that can be dispensed with lightly. A fundamental feature of the rule of law is that we expect courts to respect the principle that once a matter has been finally litigated to finality, it will not again be reopened by the same litigants. So, for that reason, we say that it's simply not open to the Competition Commission to say that the CAC's finding regarding jurisdiction over the conduct was incorrect. But if we're wrong in that regard, our second argument, still regarding jurisdiction over the person, is that the Commission says that the competition authority does not have to establish jurisdiction over the person. It says that the jurisdiction over a foreign peregrinus turns solely on the interpretation of Section 3.1, and that Section 3.1 does not include the common law personal jurisdiction requirements. Chief Justice, Deputy Chief Justice, our response to that very briefly is this. That, in effect, involves ignoring all of the common law. And you're aware of the presumption that the legislature intends to change the common law as little as possible. If you were to adopt that argument, you would in effect be writing out of the script the doctrine of jurisdiction over the person. You would be crossing out all of the law of 300 years in one foul swoop. And we submit with respect that is not something that this court would want to do. So much for jurisdiction over the person. If the Commission comes home on jurisdiction over the person, it then has to establish jurisdiction over the conduct. And here, again, the submission I make is that this argument is not available to the Competition Commission because of the doctrine of res judicata, or because it has preempted the appeal, and once again, it doesn't matter much to us which of those arguments you adopt. The fundamental point is the Commission was told how to plead the jurisdiction over the conduct. It pleaded the case as required by CAC 1, and it did so without demur. And so we respectfully submit it's simply not open to the Competition Commission now to say that any of those findings should be held not to be binding on the Commission. They are binding because the Commission complied with the order in CAC 1, and it did so without demur. But again, we have a second level to our argument regarding jurisdiction over the conduct, and it's this. If you're against us on res judicata, then with the greatest of respect, the reasoning in CAC 2 is entirely above any criticism whatsoever, because what the CAC did in endorsing the qualified effects test, which had been adopted by the tribunal, was to recognize that if the competition authorities were to exert jurisdiction very widely, then that jurisdiction would obviously impact on the jurisdiction of foreign authorities. So if I can use a simple example, if this court were to find that the Competition Commission or the Competition Commission has extensive authority, jurisdiction over the conduct of two traders in New York who collude to sell oranges, for example, that would impact on the jurisdiction of the foreign authorities. And all of the principles of comity and private international laws tell us that a court should be very reluctant to assume that jurisdiction. Deputy Chief Justice, we've addressed that argument in our heads. I emphasize that because I didn't hear any of my learned friends address the argument, but we've given you authorities to indicate why this court, with the greatest of respect, would be very slow to assume jurisdiction which would tread on the toes of another regulator in another country. And for that reason, we, with respect, would advise caution in that regard. That is the argument regarding the slash and burn approach. The Commission says this court should endorse the slash and burn approach. We say, with respect, you should turn your back on it. If you were to turn your back on it, then you would be left with an application of the established requirements for jurisdiction. Jurisdiction over the person, jurisdiction over the conduct, in terms of what we say is the orthodox approach. May I just interrupt my own argument here before I get to the orthodox requirement for jurisdiction? I listened closely to the debate between my learned friend Mr. Loxton and members of the court. And I may have misunderstood him, but I did understand him to say that if the CAC judgment in CAC 2 altered the reasoning in CAC 1, then this court would no longer be bound by the doctrine of res judicata. But with respect, that is not correct. I am a little friend say it's not correct, and I agree with him if he's prompting me to say it's not a correct submission. It's not a correct submission in our submission, because the law regarding the binding effects of orders applies to the order, not to the reasoning of the court. So the real question for this court would be, not is the reasoning in CAC 2 inconsistent with the reasoning in CAC 1? The real question would be, is the order in CAC 1 one that was altered by the order in CAC 2? And of course it wasn't in our respectful submission. So what that means in our submission is that the doctrine of res judicata applies, and it applies without regard to the difficulties regarding the difficulties the Commission has invented in our respectful submission regarding whether CAC 2 in any way altered the order in CAC 1. But if we get that argument out of the way, then we would be back to the established requirements regarding jurisdiction over the person. And you will know the law. The law will be well known to you, and it's been well traversed in the past day and a half. I don't have time to develop the submission, but our submission is the one in our heads of argument. We say that applying the established test for jurisdiction over the person, those requirements were not established by the Commission, and therefore the Commission does not have jurisdiction over the person of HBUS. Again, I don't have time to develop that submission, but if it's raised in questions, I'll develop that submission in due course. And that then brings me to the final element of the argument, jurisdiction over the conduct according to the established test. Now, the established test would be the test as developed by the Competition Appeal Court. It's the qualified effects test, and you'll know that. And our submission is that that qualified effects test was not established by the Competition Commission when it pleaded the case. And I want to develop this argument in a little bit of detail. I listened closely to the debate between Justice Majid and one of my learned friends. And the only element I want to add to that debate is just to draw the court's attention to the pleaded case regarding the effects of the conduct according to the Commission's own allegation. I don't have the reference before me. I'll ask my learner junior to find it. But my own notes say it's volume 5, page 447 to 448. And it's paragraph 282. Sorry, my correction. It's paragraph 262. And the Commission's pleaded case there, and I'm going to quote it, is that the daily ZAR foreign exchange turnover on the spot market, I think that should be the spot market, on the spot market amounts to US dollars 26.8 billion, with US dollars 6.6 billion daily on an outright forwards market. Now, Justices, you can do the math yourself. You then have to have regard to what are the allegations of the SOC which are pleaded by the Commission, and they've set out in enormous detail in the founding affidavit. If you tot up all of those amounts, it's going to come to a very small fraction of either of those numbers that I gave you. 26.8 billion a day, or 6.6 billion daily on the outright forward market. And so in our respectful submission, once the Commission says, well, this is a case that affects the exchange rate and therefore affects all South Africans, it's simply a case that is not made out on the papers. On the contrary, the impact of the exchange rate is going to be very small according to the Competition Commission's own numbers. And may I make one other point in that regard, Justice Majid? It's easy to misread the Competition Commission's case as saying, well, there was a conspiracy between all the banks to drive the exchange rate one way or another. So a simple way to understand it would be the banks decided to short the rand. But that isn't the pleaded case, and that's the point of the examples which we cited in our heads and you referred to yesterday, Justice Majid. The individual trades show that the rands was affected in different ways. Sometimes it went up, sometimes it went down. So if the grand conspiracy theory is that the rand was being shorted, that is a case that is simply not made out on the papers. And so for all of those reasons, we would respectfully submit that the case for jurisdiction over the person and over the conduct is not made out by the Competition Commission. We say with respect that the appeal of H. Bus was correctly upheld, and we would therefore ask this court to dismiss the application for leave to appeal. Deputy Chief Justice, I've got 25 seconds to go, but those are my submissions. Thank you.
Thank you very much, Advocate Cockrell. Questions? Justice Rogers?
Mr. Cockrell, in assessing whether the qualified effects test has been met, should one be looking at the percentage of South African foreign currency trade as compared with global trade in the rand on a particular day? At least some of the allegations here seem to involve the idea that you will affect the exchange rate by a few pips because somebody wants to sell or buy rands at 4 o'clock or whatever, at a rate that's set at 4 o'clock. So you will affect it by a small amount and then perhaps bring it back. Now, I just did the maths. I'm sure it's been done somewhere in the papers, but perhaps for you and me going on holiday, it wouldn't matter very much whether we were buying our dollars. Now we're thinking back to the glory days of 2007 at 7 Rand 85 to the dollar.
Yes.
But if you're a South African needing to acquire $50 million,
yes,
the difference between an exchange rate of 7.85 and 7.89 is 2 million rand.
Yes.
You have to pay 2 million rand more for your dollars. And if each of the manipulations were, these traders wouldn't have been manipulating it unless in relation to the specific transactions that they were targeting, it was going to have some effect.
yes.
Why would that not be an economic effect in South Africa? And why, I can appreciate that substantial effect is, rules out something that's de minimis. But do you really say that say to a South African regulator, if all you can show is a persistent 8-year cartel that really existed, in which every day people were only making derisory sums such as 1 million or 2 million rand by their manipulation, this is something we should overlook because it's a mere fraction of the trading of the rand.
No, I understand the question, Justice Rogers, but with respect, the fraction is important. I haven't done the numbers. The fraction is important. You have the numerator and you have the denominator. The fraction is going to be a very, very tiny number in our respectful submission. And so,
I've indicated, I think a difference, say, between 785 and 789
yeah,
would be the sorts of adjustments that were occurring here, allegedly.
yeah.
And on a South African needing $50 million, that's a difference of 2 million rand.
Yes.
Otherwise, why would anybody be doing it?
They were not doing it consistently, Justice Rogers. That's the point. So sometimes they were pushing the rand up and sometimes they were pulling the rand down.
Yes, because in either case, somebody on the other side of the transaction
Yes.
was going to get a couple of million rand more or less.
Yes. No.
Now, why isn't that a material effect? Do you say a South African regulator must ignore persistent cartel behavior which has only transitory daily effects of a couple of million rand.
No, but the relevance is sometimes the South African customer would benefit from the cartel conduct, and sometimes the South African customer would not benefit. So that's the point. I can't say the two balance each other out, but what I do say is that on the examples that the Competition Commission gives in the exchange, in the referral affidavit, sometimes the South African customer would benefit and sometimes he or she would not.
Yes, but doesn't ANZAC tell us that it doesn't matter whether in a given transaction the effect is beneficial or deleterious in South Africa? Yeah. The question is it having an effect of the kind that we can take notice of? Yeah.
Justice Rogers, I can't improve on my answer. The numbers are incredibly small in our respectful submission. And I understand you say, well, surely the regulator should have regard to that. But I say, with respect, the numbers are so small that there is no reason for a regulator to have regard to those numbers.
So, I mean, would you say that if all that is happening is that a particular trader is benefiting or disadvantaging a client by a couple of million rand a day, and that's happening every now and again, maybe once a week, that is insignificant?
I can't say a couple of million rand, but I'm saying on the numbers that the Commission gives us, the numbers are very, very small. The Commission doesn't tell us that a particular trade was for 2 million rand or 3 million rand. The Commission doesn't give us any of those numbers. So you give me the hypothetical example. Well, what about a South African who wants to go overseas and is using her foreign exchange allowance? But the Commission doesn't give us any of those numbers. So I don't...
At some stage I understood an inquiry, maybe it was Brownrigg and Taylor, which is, we know it is said not to be part of a horizontal dealing, but wasn't there, what would you charge for 25 million and what would you charge for 50 million? Yeah. So, I mean, these traders, I don't think we're looking at your and my holiday allowance.
Yes. I don't know, Justice Rogers, and I don't know because the Commission hasn't told us. And that's part of our complaint of my client, at any rate, is the Commission ought to have told us what was the effect on the rand in relation to these particular transactions, and what was the extent of the detriment felt by South African consumers, if there was any detriment. So I accept the legitimacy of the questions, but I can't give an answer, and that's not because I've been lazy or slothful, it's because the Commission hasn't done its job in our respective submission. At least in the complaint referral, they haven't done the job of setting out these very elementary facts, which we would have thought are fundamental to the very complaint that the Commission is prosecuting.
Well, it's of course conceivable that if, say, Mr. Katz wants the rate changed by a couple of pips before 4 o'clock, and after that he doesn't mind if it goes back to a previous level, the Commission may not know what the actual trades were. I mean, where will you see it? You may not know what the trades are, but you know that the traders are not colluding for nothing.
I'm going to give evidence from the bar, and I don't want to give evidence from the bar. I don't know to what extent the Commission has knowledge of the individual trades. I do know that the case made out is a series of individual trades rather than any grand conspiracy, for the reasons I've given in answer to Justice Majid's point yesterday. But I can't take it any further than to say it was the case that the Commission had to mount. It was a case that they had to establish. It wasn't for my client to establish it, at least not at this stage. And that's the case they haven't made out. We tried to do the exercise, and I think we've done it in the heads. We've tried to summarize the individual trades, at least in relation to HBUS, which was an affected party. And the analysis shows that the rand was jumping around in all respects. I understand your point. You saying, well, it could have been a South African, and the South African could have been on the losing end of that particular trade. But I simply don't know, Justice Rogers, and I don't know because the Commission hasn't shared that level of detail with us. I can't tell you that the Commission has that level of detail. What I can say confidently is that they ought to have done that exercise in order to plead the qualified effects test, and that's what they didn't do in our submission.
Thank you.
Mr. Cockrell, the trader that worked for the two banks that you represent was Christopher Hatton. Now, the Commission's case is that he was quite active in the old kids chat room. but also outside of it, and he interacted with cats in other chat rooms. That's the one part. The other part, they say that Merkovich is also one of your traders, and he's also implicated. And their allegations are that their participation in the chat room, especially that of Hattons, together with the fact that this is an overall conspiracy where people are continuously chatting about fake bits and fixing the rate and so on, is indicative of the fact that they were actually part of this overall conspiracy. And they make the point that after leaving you, the two banks, Hatton then went to Credit Suisse. What do you say about the contention that the Commission says one mustn't have, as the tribunal called it, a microscopic view of this? You must have an overall view of the allegations. You can't break it down into small little components and say, these two are implicated here, and you must have look at the overall picture and the effect of that conduct. What do you say about that argument?
I'm saying with respect, you can break it down into little micro components, because that is the case that the Commission mounted. The case is one of a series of individual trades, a series of individual events. The Commission then tries to draw a circle around all of those, and you can group this together into the grand conspiracy theory. But we say with respect, you can't do that, because that is not a justified inference on the papers. So we say, Justice Majid, with respect, one has to go back to the microscopic level, because that is the only permissible case that the Commission pleaded in our submission.
Is that really the way that you should plead an overall conspiracy? I mean, I don't understand. It's obviously the sum of a number of parts.
Yes.
What's wrong in saying there's a number of parts here, and there's a common trend across all the these parts with certain objectives? That's just allegations at this stage. But the allegation is that there's a common trend, a common feature across all of this. It's manipulation and so on, and influencing the market, sharing commercially sensitive information with a particular objective in mind, to make profits illegally. That is the ultimate objective, so it is alleged. What is wrong in putting all of that together and say this is the sum of the overall smaller parts?
What's wrong with it is the third leg of the test. That's the test which many of my learned friends have referred to, and it's the test in the ECJ case. The third leg is the Commission has to show knowledge, either actual or computed, on the part of my client, which is HBUS for present purposes, has to show knowledge actual or imputed. And with respect, they don't show that knowledge. They make the bold averment, but they don't establish anything to substantiate that averment, and that is the problem for the Commission.
No trader, unless that trader has pleaded guilty or has accepted liability, will come forward and say, well, you know, I had knowledge. So you got to impute that knowledge mostly. You got to infer that knowledge. What is wrong with the Commission alleging that Hatton, quite active in this chat room, is seen to be communicating with one who has, I'm not sure if Mr. Katz has admitted liability, but we know he's been convicted in the US. Is it proper to make that allegation? What is wrong with that allegation?
So the allegation relates to the old GITS chat room. Let's just assume for the sake of argument that the Commission's allegation is beyond criticism in the case of the old GITS chat room. The problem is, how do you draw an inference regarding the conduct of Hatton in the case of the other chat rooms, the ZAR chat rooms, and indeed in the case of the other chat rooms which are not identified by name? And there's nothing at all to show that the conduct of Hatton should be attributed to. There's nothing to show that the conduct of Hatton should lead to the ascription of responsibility in relation to HBUS for that conduct. At worst for HBUS, it's the conduct you refer to in the old GITS chat room. But the Commission has to go further. The Commission has to connect all of the dots with all of the other chat rooms. And that, in our respectful submission, is the missing piece of the puzzle.
Thank you, Decision.
Mr. Cockrell, I have questions on two issues briefly. The first is on res judicata. Now, you've heard the debate this morning with regard to whether the court may have a residual power, notwithstanding that the right may not reside with the parties to seek to re-argue the matter, but the court may well do so. And I know in the context of the distinction you wanted to make, which you didn't have time to, between preemption and res judicata, and that's quite clear, and in this case, it may well be that this is not a case where preemption applies. But to the extent that the interests of justice principle may well be applicable to both preemption and res judicata, both in respect of a departure from the two.
Yes.
So a court could overlook preemption and it could depart from res judicata in the interest of justice.
Yes.
I just want to refer you to a judgment of this court that dealt with tax matters, and it was 5 tax matters. And in one of those matters, which is Absa Bank versus the Commission of SARS, this court adopted the position that where the interests of justice warranted, it may well elect not to enforce preemption. And it went through a few cases to illustrate how this court had dealt with it. And the one case that is quite fascinating and may be of interest to us here is the case of Boy. And in that case, this guy was dismissed. It was an arbitration. It was reinstatement was ordered. However, when he went to the Labour Court said reinstatement is not appropriate and you should get compensation rather. His compensation was calculated at about 750,000 rands. It was paid to him in full. About a year later, he sought leave to appeal from the Labour Court. And the court refused leave on the basis of preemption. He sought leave from the Labour Appeal Court. It was refused. He then came to this court 213 days late. This court decided not to enforce preemption because it said that the issues at the heart of that matter were so important, unfair labor practices and job security. I just offer that case as an example that, one, the jurisprudence of this court, and I agree with you, where one would depart from res judicata would be exceptional. It would be the interest of justice criteria, which is broad and flexible. And it may well be suggested that the issues involved in this case may well fall within that category, and I'm not saying that that's where we may go. I just raised that with you.
Yes. Justice Colopin, to answer your question, may I start by assuming, just for the sake of argument, that the debate is one of preemption? I understand Justice Rogers' point that it may be a case of res judicata rather than preemption, but just for the sake of argument, let's assume that. So a litigant has a right of appeal. The litigant waives his or her right, and let's assume the conduct is unequivocal. For this court to decide that it will nevertheless hear the appeal, the court would have to decide that even though the litigant forfeited his or her right of appeal, there is nevertheless a higher level reason why the court should hear the matter. Now, I understand the point you put to me. There may well be cases where, certainly in a textbook sense, one can contemplate those examples. But in my respectful submission, they would be very, very few and far between, precisely because the personal autonomy that is at stake when the person forfeits his or her right of appeal is the one that should be given effect to by this court, in my respectful submission. I understand that's not a complete answer. It doesn't deal with the cases, the textbook examples. What about the rare cases? What about the exceptional cases?
Sure.
But I would say that in by far the majority of cases, the court should be extremely reluctant to depart from a principle that is foundational to the root of law, because that's what it is. Preemption is ultimately foundational to the root of law, in my submission.
I hear you, but certainly there's a distinction between the instances where it's a question of personal autonomy and where an institution is discharging an obligation given to it by statute.
The question you raise is a very difficult one. It's about the normative force of the rules. So are the rules one which can be, are the rules one that can be changed at whim by this court? I don't mean that in a pejorative sense at all, Deputy Chief Justice. But is the court at large to say, there's a rule of law. The rule of law is you are bound by your conduct if you preempt your appeal. But in this case, it works a hardship, so I'm going to not enforce that rule. Ultimately, the foundational question is, what value do we attach to those rules Are they important to us? Are they important for foundational reasons? Or are they ultimately not important? Is it all driven by the equities?
Sure.
Those are very deep questions.
Sure, and there's a
You'll be more
balance.
aware of that than I will.
My second question, Mr. Cockrell, is that you say the Commission seeks to almost airbrush the common law requirements regarding personal jurisdiction out of our law, and be content to rely on Section 3.1. Now, it may well be argued that CAC did, well, not airbrushed it, but CAC went quite far in revisiting personal jurisdiction.
Yes.
It did away with presence. It did away, well,
Yes.
in the context of did away with presence, it did away with having assets that are capable of being attached,
Yes.
and adopted the test of connecting factors.
Yes.
Correct.
Yes.
Now, my question to you is that, in a real sense, the difference then between the two categories of Peregrini, local and pure, as a result of CAC 2, is really nominal from an effectiveness point of view.
Yes.
Because in the one scenario, you wouldn't expect the Commission to make out a case of a connection in respect of local Peregrini,
Yes.
if the other requirements of personal jurisdiction, so mere presence without any assets,
Yes.
or no presence with nominal assets would be sufficient.
Yes.
Whereas in the other case, the bar would be much higher.
Yes.
Now, I ask, when this court is challenged to develop the common law,
Yes.
is there a rational distinction for treating, a rational basis for treating those two categories of Peregrini in such a marked and distinct and different way, and setting very different jurisdictional standards in terms of when the Commission or the Tribunal will have jurisdiction against them respectively?
No, thank you. I'm grateful for the question. The short answer is you say the Commission airbrushed the common law out of the test. And
I said that your argument was that the Commission's argument was to airbrush
yes.
those requirements. And I'm saying, well, the CAC didn't quite airbrush it, but they came close to sort of radically transforming the common law.
No, that's quite right. And in our respect for submission, that was the correct approach. So they didn't draw a red line through the common law. They didn't draw a red line through 300 years of law regarding jurisdiction over the person in particular. What they did is they tried to develop the common law in the light of Section 39.3. And in our respect for submission, they did it in a permissible way and in a competent way and in a clever way. So there was no need to draw a red line through the law, which is what the Commission invites you to do. There was no need to airbrush out 300 years of common law. We say, with respect, what the CAC did was to develop the rules of jurisdiction to a modern economy in a sensible way. That is our submission, Justice.
But my question really doesn't relate to that. Maybe sort of airbrushing sidetracked us. It really relates to the consequence of CAC 2. Is how it now treats two categories of Peregrini
yes.
in markedly different ways, whereas in truth and reality there may not be any difference with regard to those Peregrini
yes.
in respect of the doctrine of effectiveness.
No, I understand.
And is there basis for that?
Probably not, Justice Collipin, but that would be a matter for you to decide. And the fundamental question would be, how do we develop the common law? So whether you develop it in the CAC way or in a non-CAC way, you would still be asking, how do we develop the common law? My only submission for today is that what you shouldn't do is throw the entirety of the common law out. So how you develop it is entirely up to you. I'm sensitive to your question that the distinction, which is now implicit in the jurisprudence, may be an artificial distinction. But my submission is that is still a more sensible way to do it rather than to throw out all of the common law. That is our submission.
Do you think that if we should develop it, we should do so in a manner that's consistent with the principles of doing it equitably, that it should be rational?
Yes.
Yeah.
No.
I mean, surely those are fundamental principles.
Yes, no, of course, Justice Collipin. It's hard to argue with that, and you certainly won't hear me arguing against that.
Thank you, Mr. Cockrell.
Thank you, Mr. Cockrell.
Thank you. Thank you, Deputy Chief Justice.
Thank you. For the 27th respondent, FirstRand Bank Limited, Advocate Wesley.
Yes. Not that you had a chance to look at it. Is it not that you had a chance to look at it? Okay. The court pleases Deputy Chief Justice. Justices. FirstRand Bank's complaint has always been that the complaint referral doesn't make out any case that it was a participant in the SOC that is the subject of the complaint. It's a distinctive position that relates to its particular features. And so I'd like to just start by reminding the court of the essential distinct features in the proceedings involving FirstRand Bank. Firstly, FirstRand Bank was not identified as a participant in the alleged SOC in the original initiation in April 2015. It was only joined as a respondent for the first time with Nedbank 2.5 or 5 years later in June 2020, after earlier amendments. And that belated tag-along is because the second distinct feature is the case alleged against FirstRand Bank and Nedbank is fundamentally different to that against every other respondent bank. Of course, you've heard that from Nedbank already, because instead of relying on any records of membership of or participation in chat rooms, which form the heart of the complaint against the main banks, the only allegation against FirstRand Bank is that data patterns in respect of the sequence and timing of posting of quotes on the public Reuters trading platform by FirstRand Bank and some of the other respondent banks on 8 occasions over 4 years suggests that their conduct was coordinated. As the complaint referral stands in, the Commission contends that it can prove that FirstRand Bank was a participant in the SOC solely by proving these 8 incidents. FirstRand Bank suffers material prejudice in being dragged along in this case, in particular ongoing reputational harm, and for this reason, it properly delivered an exception before this tribunal. The exception procedure gives effect to the constitutional right to a fair hearing, and this is the third distinct feature. Although brought on affidavit, FirstRand Bank's application is an exception. It was brought in that form because of the practice, but it is an exception, and that means it doesn't require the court to consider any facts outside of those pleaded in the referral. It requires only the application of the ordinary principles in relation to the determination of such exceptions. It must be determined on the basis that the Commission will prove all the facts alleged in the complaint referral, but only those facts. And it is not a complaint that the facts pleaded are unclear. It is that those facts are insufficient to establish the conclusion the Commission seeks to draw from them, which is the inference that FirstRand Bank was a participant in the SOC. This exception was upheld by the Competition Appeal Court, as appears from paragraph 161 of its judgment, and the subject of the Commission's appeal is in respect of that finding. And so the final distinct feature is that because FirstRand Bank's application is a classic exception, and because FirstRand Bank is an incular, only the Commission's fourth ground of appeal therefore applies to the CAC's decision in respect of its exception. Now, I'm going to argue at the close of this that this ground of appeal doesn't engage this court's jurisdiction, but this really becomes apparent when one understands the substance of the ground of appeal. I want to turn to that. And I'm going to do that by dealing very briefly with the concept of an SOC and the requirement of awareness, and then I'm going to deal with the application of those principles to the case against FirstRand Bank. So an SOC is a particular type of cartel. It's a shorthand description. It's a cartel carried out over a very long time. It involves multiple participants, but in which not every participant participates in every act of collusion. Nonetheless, they are attributed liability. And there are 3 essential requirements to establish an SOC and a firm's participation in that SOC They are not in dispute. The first is the anti-competitive objective, what's called identity of object. The second is participation, each firm's intentional contribution. And the third is knowledge, each firm's awareness of the actual conduct planned or put into place by the other participating firms, or awareness that the other firms would engage in such conduct and acceptance of the risk of that. Now, these requirements reflect fundamental principles. A cartel is at heart an agreement between firms. To establish that someone is a participant in a cartel, you must show that they knew about the agreement and that they signed up to it. Who's in and what are we doing? But an SOC adds one rider reflected in the third requirement, because in an ordinary cartel, a firm participates in all of the acts of the cartel, and attributing liability is relatively straightforward. But in the SOC, that firm can be held liable for acts that it didn't participate in because it knew that at times other firms would be carrying out that conduct, and that is the reason for attributing liability. But you can only do that if the firm knows that the other firms are part of the cartel and that they are acting or will probably act without it in furtherance of the cartel. Those are two separate requirements. They're both rolled into the third requirement in the case law. On the first leg, there are three cases that we have referred the court to that are instructive as to what the requirement of awareness means. They are in our heads of argument from paragraphs 24 to 26. The first is Sigma Technologies. There, a number of Danish and German firms created a Europe-wide cartel setting quotas in respect of heating pipes. Sigma Technology was only aware of the cartel in Italy. It had a bilateral cartel with one of the participants. And the General Court held that the Commission did not show that the applicant, when participating in the agreement on the Italian market, was aware of the anti-competitive conduct at the European level of the other undertakings, or that it could have foreseen such conduct. Because it simply didn't know about the other German or Danish firms. It only knew about the one firm that it was colluding with in Italy. Toshiba 2015 case is very similar. It involved cathode ray tubes, and there the General Court again said that in bilateral meetings between Toshiba and some of the individual participants in a Europe and Asia-wide cartel wasn't sufficient to establish that Toshiba was aware of and a participant in that broader cartel. And the final case has been referred to already as Soliver, again the General Court, in automotive glass. This was a case about market share allocation and information exchange on pricing. And the General Court held that anti-competitive bilateral contacts with members of the broader cartel wasn't sufficient on its own to establish awareness of the broader cartel at all. It simply showed identity of conduct. And that's what I want to come to. E.g. bonds has been dealt with. It doesn't deal with any of these issues in A at all, because in that case you had what you would expect. You had a chat room, 380 chats. All of the participants are in that. The only question before the court was, what about the next door chat room, DBAC, where everybody except Bank of America was? But that's about B. Is the conduct in DBAC attributable to the firms in CODs and CHIPS? So how does the Commission then go about awareness in that first sense, that FirstRand Bank knows by engaging in an act of collusion that it's part of the broader cartel? Well, in the general case is very clear, and it's direct evidence. And the Commission made the submission to the Tribunal in the 2019 hearing, and it appears at paragraphs 148 and 149 of that decision. And that the court recorded, as Mr. Nglukai Toby put it in argument, the opening of the chat rooms is an invitation to a conspiracy, and the acceptance of that invitation is an acceptance to join the conspiracy, because it is these chat rooms that were used by the traders to facilitate, perform, and undertake activities that are in violation of Section 41B. The SOC comes about because respondents are invited to join the platform and accept the invitation. It is the electronic equivalent of the proverbial smoke-filled room of cartel folklore. And that case remains in paragraph 170 of the founding affidavit in this application for leave to appeal. The Commission says again, these traders were aware, or ought reasonably to have been aware, that the implicated chat rooms were used to further the objective of the plans and actions of the other participants in the conspiracy, because they could see all current and past messages exchanged by members of the chat room. Now, of course, for FirstRand Bank, there is no chat room evidence at all. There is no suggestion that they can see everybody who is participating, even if they're not actually participating on the day. So the Commission is not going to establish chats or chat room participation. For purposes of this exception, it has said, I don't know who FirstRand Bank's traders are. It doesn't matter. If I prove the facts alleged in the complaint referral, I will succeed. And those allegations are that on 8 sporadic incidents, one day each in January 2009 and May 2010, one day in May 2012, and then a flurry of 4 days in September and October 2012, there was individual acts of collusion. We've collated these 8 incidents in Annexure A to our heads of argument. Now, some of the pleaded allegations of collusion against FirstRand Bank are difficult to understand, for example, focal point, but at heart, the underlying conduct itself is clear. It's either alternating with other firms in putting up quotes, it's not putting up quotes, or it's putting up quotes when other firms don't do so. Can I make the point that just to correct one submission made by my learned friend in the opening, there is no allegation of fixing the fix in relation to FirstRand Bank. It is only the conduct that I've just described, and that, of course, is indistinguishable from ordinary commercial conduct. Anyone who's putting out, who's at the information platform is either putting out a quote or not putting out a quote, and they're doing so before or after somebody else. So, and of course it would have to be indistinguishable if it was part of a cartel, otherwise it would be obvious. If it were very clear that cartel conduct and collusion was going on from conduct in the trading room, then there would be no effective cartel. It must be indistinguishable from ordinary trading conduct. What's also noticeable, of course, is that there's no allegation that any trade was ever conducted consequent on the alleged act of coordination, and the Commission doesn't have any allegation that the conduct was the product of any prior agreement, let alone set out facts. Now, that's the first inference that my learned friend Mr. Gotts dealt with, that you are asked to infer a cartel conduct from the trades. All of the shortcomings in the allegations relating to Nedbank apply equally to FirstRand Bank. But I want to spend my last 2 minutes just dealing with the next inference, because the next inference is to say, once you've assumed there were acts of collusion on these 8 days, you must then also infer that those were the acts of collusion in furtherance of this much, much broader cartel spanning 8 years, the one you see in the chat rooms. And we say that that's simply untenable. The Commission's only case is to say, well, you can tell, I can't show it, but you can tell that it's part of the same cartel because the activities are the same. The similarity between the conduct allegedly observed on the trading platform and the conduct that's discussed in the chat rooms. Well, of course, ordinarily, similarity of conduct goes to identity of object, the first requirement, not the third requirement of awareness. So what the Commission says in this case is, well, this conduct is so unusual that it is implausible that 2 different groups of traders could have hit on it. It must be part of the single cartel. But of course, that simply doesn't hold. Because as I've said, the collusion is normal trading behavior. The only difference is that instead of deciding unilaterally when to post a quote and not to post a quote, there is agreement beforehand. Not only is that the obvious method to collude, it's the only method to collude. The second point is that collusion can obviously be carried out by smaller groups of traders. We know that because all of the instances of collusion that are identified, alleged collusion, involve only smaller groups of traders. So that there could be 2 small groups of traders is not implausible. And of course, lastly, if it occurred to one set of traders in the US, in their chat room, that you could at the right time manipulate the rand with a small group of traders, then it is entirely plausible that it would occur to another group of traders at another place for another time. And so the small acts of collusion give rise to the inference that different groups of traders at different times decided simply to get hold of each other and say, I need tomorrow to make a change, can we work together on this, or I need to do it right now. But what you cannot infer is that any of them knew about the other groups. And of course, lastly, you can't do that by looking at the data, because if you only looked at the data, you would think everybody else was behaving normally, because the data doesn't disclose the collusion. And so the facts, if proved, and on the most favourable assumption to the Commission of the 8 incidents, assume everything in their favour, that they prove that those are instances of collusion. That doesn't give rise to the conclusion, those facts don't give rise to the conclusion that this was part of the single overarching conspiracy. And so we say that there are no prospects, but what this discussion has shown is that this is simply about whether the facts are sufficient to reach the conclusion. That's not a question of law. And in fact, the Commission says as much on the 4th ground of appeal. In paragraph 153 of the finding affidavit, it says, the CAC's finding that the referral was deficient is based on the incorrect application of the law and ought to be overturned. Well, that doesn't meet the jurisdictional threshold. The final point I wish to make, it is correct that the CAC found in favour of FirstRand Bank on a second point, joinder. That doesn't matter, though. If there are 2 independent points and the one is not subject to leave to appeal, then leave to appeal must be dismissed regardless of the prospects of the other case. Those are our submissions. I'm indebted to the court.
Thank you, Mr. Wesley. Okay, there seems to be no questions for you.
I suspect that might be because it's late in the day, Deputy Chief Justice.
Thank you very much, Mr. Wesley. Ms. Engelbrecht.
Deputy Chief Justice, Justices of the Court, it's 5:30 at the end of a very long day, and you may think that you've heard it all before. But allow me to speak to you about the unique position of Standard Americas, the only one of the pure Peregrini to have been added unceremoniously in June 2020 when the Commission filed its new complaint referral affidavit and in circumstances where there were very peculiar facts. In relation to my client, the Competition Commission asks of this court to accept that it can, post-referral of a complaint, sit on information that a firm is potentially implicated in the conduct referred, do nothing with that information, and then decide more than 3 years later and several amendments down the line that now is the opportune moment to cite this party as a respondent. It asks of this court to hold that joinder of that implicated firm would then be a mere formality, and that it would have to offer no explanation whatsoever for waiting until that moment to introduce the firm as a respondent, that it didn't even have to ask for permission or an indulgence to do so. All of this they do because this court previously confirmed that at the moment when the Commission initiates a complaint, it need not identify all of the respondents. According to the Commission, it need not identify all of the respondents even by the time it has completed its investigation and taken a decision to refer. And even if a respondent is identified, then immediately after referral, it can wait. It can wait for 3.5 years. Like a child clutching to its favourite blanket, the Commission holds on to Pickfords and this notion of the complaint at the outset. The idea that then all need not be in. but it never explains to this court what it should make of the definition of a respondent in Section 1 of the Competition Act and Tribunal Rule 3, sub-Roman 3. The Act identifies a respondent as a firm against whom a complaint of a prohibited practice has been initiated in terms of this Act. A firm against whom? Tribunal Rule 3, consistently therewith, says that a respondent means, in respect of a complaint referral, the firm against whom the complaint has been initiated. Because, as my astute attorney put it, you can initiate an investigation against a prohibited practice, but you can't refer against a prohibited practice. You have to refer against the people, the parties who engaged in that practice. And at the moment of referral, the Commission investigator goes on oath, as required by the rules, and sets out who's in and what did they do. Before this court, the Commission unfortunately steadfastly refuses to recognize that there are these three distinct steps: initiation, investigation, and then referral, and that has implications. It glosses over this definition of a respondent, and it asks this court to ignore that, for example, in Section 51, sub 2 of the Act, a complaint referral must be in the prescribed form, and that prescribed form requires identification of the respondents. It asks this court effectively to ignore Sections 51, 3 and 4, which demand that the tribunal, upon referral, publish in the Gazette a notice of who the parties are that are the respondents and the conduct that is referred. There is a notice to be published in the Gazette, and yet the Commission can come whenever it wants afterwards and just add names. And the Commission says all of this we can do, and I don't have to fear as the Commission that Section 67 and the time bar will operate against me, and I don't have to fear that I will have to give an explanation for not acting on information that I had, whether deliberately or negligently. Justice Majid quite correctly points out that Pickfords cannot have this effect. It cannot be that the Commission can just act with impunity. On Tuesday, counsel for the Commission repeatedly asserted that Mr. Jason Katz was employed by Standard Americas from 2001 to 2010. He was the linchpin, they say. And then Mr. Nkatobi also repeatedly said that he was jailed. There's a danger with giving evidence from the bar. He was not. He entered into a plea agreement, but he gave community service. But that's just by the by. Of course, the problem with the Commission's identification of Mr. Katz is that it never shows, not the tribunal, not the CAC, and not this court, it never shows that Mr. Katz was convicted for the activities that he engaged in whilst he was in the employ of Standard Americas. And it can't. We refer the court to the record at volume 30, page 2795. It's paragraphs 7.10 and 7.11 of a letter that my attorney wrote in March 2017, then, in fact, representing Standard New York Securities. And what they explained there was this: as the Commission is aware, in December 2016, Katz entered into a plea agreement with the Department of Justice in the US for violations of US antitrust laws. It should be noted that the DOJ did not charge Standard Americas or even identify Standard Americas in the charging documents. If Mr. Katz was such a linchpin in the conspiracy at the time of his employment with Standard Americas, why did the DOJ not charge Standard Americas? Why did the leniency applicant not identify to the Competition Commission that Standard Americas was at the center of this conspiracy? Why did the Competition Commission's investigation from 2015 to 2017 never uncover facts pointing to the fact that Standard Americas was in the middle of this conspiracy? Why did the Commission initiate a complaint against Standard New York Securities and not Standard Americas, alleging incorrectly that it was Standard New York Securities that employed Katz at the time? It's quite terrible because the Commission stuck with that version over many years. When it was told it was wrong, and it was told it was wrong before referral, because Standard New York Securities was one of the firms that the Commission showed the courtesy of telling them that they were being investigated. And if I can go again to the March 2017 letter, it refers to previous correspondence on behalf of Standard New York Securities. It is at volume 30, page 2793. In paragraph 4, my attorney records, "You will no doubt recall that on 29 November 2016, a letter was submitted on a without prejudice basis to the Commission outlining why the case against SNYS ought not to be referred to the tribunal. In light of the concerns raised at the pre-hearing about the referral affidavit, we re-emphasize certain of the points made in that letter, this time on a with prejudice basis." So in November 2016, the Commission was told, you've got the wrong guy. They go ahead. They refer against Standard New York Securities. In March 2017, my attorneys write the letter explaining that Mr. Katz was in fact employed by Standard Americas. They ignore it then. They ignore it in May 2017 when that letter is attached to SNYS's exception. That is in volume 30, page 2743, para 28. They ignore it again when a fresh exception is filed in March 2018. That's volume 30, page 2744, para 31. After the order of the CAC, in 2020, they mention Standard Americas for the first time. Now, yesterday, Ms. Zikalala did a remarkable job of explaining to you about the named respondents issue and what the intention was. But the one thing she omits to say is this: the order only gave the Commission the right to file a new referral affidavit. It did not give the Commission the right to file an amended notice of motion. If it wanted to alter its notice of motion, in other words, if it wanted to bring in new respondents, it had to. It was compelled to ask for permission to do so. But they thought no. And it is for that reason that Standard Americas then brought a dismissal application saying, you cannot bring us in, amongst other reasons because of the content of the CAC order. It was that then ultimately prompted the Commission to bring what it called a conditional joinder application. It still didn't accept that it had to bring a joinder application. It said at paragraph 9 on page 1384 of the record that it doesn't need to apply to join Standard Americas. It relied on the April 2015 initiation. It said it was convenient and appropriate to join Standard Americas. I've got little time left, but I do want to emphasize to this court, a la Kurland, at paragraph 82. The Commission is not an indigent and bewildered litigant on a sea of procedural uncertainty. It shouldn't be offered circumventing lifelines in this court when it made an election to ignore information over years, when it made an election not to bring a properly motivated application to join my client. There's a bit of the spectre of the one that got away, but I've explained to this court that in fact the DOJ didn't find there to be reason to prosecute Mr. Katz for his activities during the time of Standard Americas. And in any event, we all understand that sometimes fairness dictates that the principle must hold good. And that if one gets away because the procedures were not properly followed, that consequence of the rule of law and our entitlement to rely on the rules. With 40 seconds left, if the Commission could ask for joinder in the circumstances that it did with a mere perfunctory allegation of convenience, then we might as well say that Section 67(1) of the Competition Act is rendered nugatory. It would serve absolutely no purpose, because the Commission could come at any time and say, but I'm winding down the clock to that first complaint initiation. It would mean that this court's indication that when the Commission comes late with allegations of involvement in prohibited conduct, it cannot hide behind negligent inaction would ring hollow. Those within the time allowed are the submissions that I have.
Thank you, Ms. Engelbrecht.
Ms. Engelbrecht, can you please assist me with finding the evidence of negligent inaction in the papers, where you say that the Commission waited for at least 3 years before, and you said they had the information, if I heard correctly, but they didn't use it.
Yes. So what happened, and that's the reference, so there is the letter of March 2017, and it appears in the record at at page 2793. Let me just double check. Yes. So in the record at 2793, you will see the letter. That is the letter of 23 March 2017. And on this date, that is when my attorney writes. Now, at the time, what the Commission had done is it had made a referral against Standard New York Securities. And it alleged that Standard New York Securities employed Mr. Katz. So, you will recall, Justice Chikri, that the referral was made in February. And then there were complaints about the quality of the pleading right at the outset. And at the first, at the first pre-hearing, the Commission said, we are going to fix this. We are going to file something. Now, before anybody took an exception, the Commission said, we're going to file a further affidavit or an amended affidavit. And in anticipation of that amended affidavit, my attorney, then acting for Standard New York Securities, wrote this letter. And what it said was in paragraph 5 of the letter. As an initial matter, we note that SNYS is not a proper respondent to these proceedings, and all references to SNYS should be withdrawn. At all relevant times, SNYS was a registered securities broker stroke dealer and did not engage in foreign exchange trading, Forex. Moreover, none of Jason Katz, Louis Friedman, or Richard de Roos was an employee of SNYS. So that's the negative. The positive they give then in paragraph 6 is this. In fact, Katz until June 2010 and Friedman until October 2014 were employees of Standard Americas Inc., through which forex trading activities were conducted. Standard Americas was at all material times incorporated in and conducted business within the USA. De Roos was not at any time an employee of or authorized representative of either SNYS or Standard Americas. So this information that Katz is employed by Standard Americas comes to the Commission latest, we say, on 23 March 2017. Now, one might say that in all of this litigation, maybe the letter got lost. It would be quite strange. It was quite direct and concerned with this proposed amendment. But even if it did, what happened then, as I indicated, in May, when there was then an exception filed by Standard New York Securities, they made the allegation again and attached the letter. And if I can just pick up that reference, but they made it then, and they again made the allegation and attached this letter of 2017 in March 2018 with the next round of exceptions. So on at least 3 occasions, formally on the record, the Commission is told Standard Americas employed Jason Katz in this time. The Commission never did anything. The first time they made the allegation that Jason Katz was employed by Standard Americas was in the June 2020 referral, when they just cited Standard Americas before they brought an application to join them or to amend their notice of motion. And then what they did is they described in all instances that Jason Katz was employed by Standard New York Securities or Standard Americas. So they still wanted to ride the 2 horses at that time. And it's only at long last, after the Competition Appeal Court with the latest order in 2024, also dismissed the case against Standard New York Securities, that the Commission had the good grace not to appeal that aspect and not go after SNYS anymore.
Okay.
It's now for the first time that it really accepts that Standard Americas was the one that employed Jason Katz.
Thank you.
Ms. Engelbrecht, self-evidently, if we are with you on the joinder point that you couldn't join after referral, and that Pickford's is no authority for the submission made by the Commission, that would be the end of the case for your client.
Indeed.
But I nonetheless want to say this. The point that is made in the letter of 2017 is that you've got the wrong bank here when you link the bank to Katz. It's not SNYS, it's SAS. I'll just call it SAS for now. Now, it must be said that Katz was a central figure in all of this.
Yes.
It matters not the basis of his plea and conviction in the New York court. On the allegations made here, he plays a central role here. He's all over the place. He's quite active in there. In some instance, he apologized. He made a mistake. And the other trader suffered. And he said, sorry, I didn't read the earlier chat. So I say this on the basis that you have this other point. But surely this is indicative, with him being a central pillar of a contribution to this overall conspiracy, as far as he is concerned, as far as his employer is concerned, you outlined.
Justice Majid, I make, and I shouldn't be misunderstood, but I make the point about what he pleaded to and what the consequences were for him, at least as it appears from the record. Because my learned friend for the Commission asks this court to make certain inferences from the fact that he was prosecuted and, as he puts it, jailed in America. So the converse is also true. if he was in fact not prosecuted or did not, and my client was in fact not prosecuted, it does cast a question about the extent of the participation. But I'm not running away from the fact that there are allegations against Mr. Katz. And I don't think anybody is trying to make the argument that Mr. Katz was not a central figure. Whether there are arguments about him acting completely on his own and potentially not representing any of his employers over the years, but serving his own interests, that's a whole different question. I'm not saying he wasn't a bad apple, but I am saying in the circumstances of this case, it shouldn't concern this court when it applies the proper principles on joinder that Standard Americas might be, as it were, the one that gets away.
Tongue in cheek, because it's late in the afternoon. You'd better get past the first point, otherwise, who knows? Jay, thank you.
Thank you, Justice Majid.
Mr. Engelbrecht, does the fact that Mr. Katz and your client were not prosecuted have any bearing on the thesis that has been foisted upon us that we must draw an inference that because of Mr. Katz's involvement in the scheme, by implication, and because he was employed by you up until 2010, therefore makes your client to fall into the net of the SOC?
With respect, we would say, even if it brings us into the net, in other words, if what happened elsewhere makes no difference, the important point is that he was employed only up until June 2010 by my client. So if this is all about Mr. Katz and his involvement, we have to bear in mind that the initiation of the complaint is in 2015, 5 years later, 5 years after he stopped being employed. And
excuse me, does it matter when the complaint is initiated? Because as I understood the commission, they seem to be suggesting that it does not matter when, and when it also does not matter when it stops. Forget about the initiation. Is there any significance to be placed on exactly when the initiation started, a la Pickford's, or not?
well, Justice, there is this pesky little thing which is section 67(1), which does demand that the Commission initiate a complaint within 3 years after the practice is stopped. And we know from Pickford's that the Commission may ask for condonation. It's not forever barred. It can give an explanation as to why it comes late. But the question here is, with Katz having left Standard Americas in June 2010, with the Commission knowing by latest March 2017 that Katz was employed by Standard Americas, and the Commission then waiting until June 2020 to first mention it, we submit it does assume the dates do assume a very great importance. Because what the effect of the Commission's conduct is now, precisely 10 years after the employee has left, the employee on whose conduct the Commission is centrally relying, 10 years later, now my client is expected to come and defend itself, to make discovery, to find documents. 10 years later, that is the effect.
Do I understand you to be pouring water over the notion that Mr. Katz was a central figure in all this?
No.
I see. Thank you. I don't think there are other questions. Thank you very much, Ms. Engelbrecht.
May it please the court.
Advocate Mugaitobi, I just need to check something with you. Justice Rogers requested you to provide us with a list of your errors of law.
Not my errors of law, the judge's errors of law.
Now, what I want to find out is, you've shared that document with us.
I did.
Have you shared it with the respondents in this part of the
Yes, everyone has it. They were furiously discussing it at lunchtime. I overheard two of them.
Oh, so they have it?
They have it.
Okay. Thank you very much. I needed to check that. We will start with you tomorrow morning.
As you please, Deputy Chief Justice.
Court adjourned.